Hey, everybody. Thank you all for joining us for our 2021 Mediation Seminar. Just a few quick things before we start. If anybody has any questions during the programming, you can ask that in the chat. I'll be monitoring those for all of our speakers today. As a reminder, we also have our Family Law and Ethics seminars coming up on the 3rd and the 10th of December. So register for those. We have great programming. I have sent everybody a link to a Dropbox with all the materials for today's event. I've updated those as they've come in. So when you got it, there might be new materials in that. At the end of the event, you will also see, you also get a link for the form to get your CLE and mediation credits. I will go ahead and introduce our first speaker today. First of all, I want to thank her for stepping in last minute after Sean Hunt unfortunately passed away last week, who was scheduled to do this topic. So thank you, Charlotte, for stepping in to cover this. But Charlotte Fleming is a lawyer from outside Nashville for 34 years. She went to Emory Law School. She is a local part-time judge in Robertson County for the last 26 years. She's been a mediator since 2002 and a mediation trainer for the AOC's office since 2016. She has 2 grown children and a dog by the name of Jack Daniels, and she loves and believes in mediation and is excited to talk about the future of mediation. So, Charlotte, the floor is now yours.
Thank you so much, Andy. I appreciate that introduction. I've never talked to you on the phone, but I haven't actually met you before. Can everybody see me? I don't know if that's something that, Andy, can everybody see me, or can I see them?
So it's in webinar, so you won't be able to see them, but everybody should be able to see you.
Okay, and can they put things in the chat?
Yes, they can.
Through? Okay, yep. Great. Hopefully I'll be able to see that. Well, welcome everybody. Like Andy said, thank you, Andy, for asking me. I'm Charlotte Fleming, and there's a really sad reason that I'm with you today, and that your original speaker in this slot, a keynote speaker on the future of mediation, has passed away. Sean Hunt, I did not know him personally, but I read his background in his obituary and bio, and it's definitely a clear loss to the Memphis community, the legal community, and the bar. And my condolences go out to all of you, especially his family and his law colleagues. That's just so difficult to lose somebody tragically like that. So it's a sad reason that I'm here, but I'm really excited to be here. Again, my name is Charlotte Fleming. It's Fleming if you're looking me up online. And I'm so excited and thrilled to be joining you on the topic of the future mediation, because I talk about it all the time in my trainings and with my mediator colleagues. Get your chat on this morning. I love to use the chat. If I didn't realize I wasn't going to be able to see you guys, I see 12 participants on, so there's about 10 of you guys on right now, which is perfect to have some interaction through the chat. And if you would do me a favor and just put in the chat your name and where you generally practice mediation, and about how many mediations a year you actually do. If we can do, now am I going to be able to see that? Let's see if I can see the chat. Okay, I guess I can just pop it up there. Let me see if anybody's going to pop it up there. So who's going to be first? Somebody. Dusty, thank you. Dusty from Jackson, 15 to 20 a year. Great. Jonathan Steen. Jonathan, where are you and how many do you typically do a year? And listen, you guys, this is a no judgment zone. So like if it's 0 and you're just getting going, that's fine. If it's 100, that's fine too. I just want to kind of see what I'm just kind of finding out what you guys generally do and what you want to do in the future. Okay, other than Dusty and Jonathan, you guys know where your chat is. How many mediations do you do approximately a year was my question. Michael Hill, Milan, 5 to 10, Jackson, Tennessee. Okay, participating in mediation. Yes, definitely. Mary Jo, hi. So you guys are mostly in the West. Hi, Mark. 35 a year. Wow, that's pretty robust. Keep going, you guys. There's a few more of you who haven't posted up on the chat. Participating 12. Okay, great. This is wonderful. I'm just trying to get a feel for it. Now keep your chat open as you go through. You're going to be asking any questions that you have or any comments that you have. We'll have a Q&A at the end. I hope Andy let us do a little bit of that, and Andy's going to monitor the questions so I don't miss any. But welcome again, and I'm really excited to talk to you about it. Okay, now, one thing I wanted to tell you is that I have several students from the Memphis area, and I'm asking if you guys know these lawyers. One is Lori Holyfield. She took my 46-hour family law class, and also Jessica Ferrante. She took my 46-hour class. And my friend Beth Yarborough. Does anybody here know Beth Yarborough from the Memphis area? She is she has an article on the Tennessee courts.gov website right now on pivoting to online mediation. So does anybody know those guys? I just thought I'd throw that out there to see if you guys know them. Before that we can discuss the future of mediation, let's take a quick look at where we have been and where I see mediation in the state of Tennessee now. Where we've been in terms of the history of mediation, I don't know how much you guys know about it. Rule 31 was adopted by the Supreme Court in Tennessee in 1996. I was practicing law at that time. I started practicing law downtown Nashville in 1987. It tells you how old I am. But they had been working on this for like 4 years before it was actually adopted by the Supreme Court. And the idea was to use neutrals as essentially quasi-judicial function to help the courts resolve pending cases. At first, this was fairly controversial. Do I have any lawyers on today that were practicing law back in 1996? If so, can you put that in the chat? And tell me if I'm right about what I'm about to say in regards to mediation, that it was controversial at the beginning. Now, the young lawyers, they don't think anything about mandatory mediation prior to setting a case for trial. They just think that's normal. But at this time, I was a lawyer then, and there was a big outcry about the implementation of neutrals in the process. Why? I felt, as many of my trial lawyer colleagues did at that time, that mediation would steal our business, that it was a stupid idea. And we had a way to resolve disputes in the state of Tennessee for the last 200 years. And what was that? What was the way that we resolved disputes in the state of Tennessee until 1996, generally? Who will put that in the chat for me? Trial, Jonathan, thank you. Trial, Justy, thank you. Thank you guys for being on it. I appreciate it. I thought I'd be able to see everybody's faces. So the chat's the only thing I got to connect with you guys, because I love to connect. But trial, absolutely. I mean, come on, just go to the courthouse and go try your lawsuits. I mean, John Day, I don't know if you guys know who he is. I used to practice law with him at Bolt Cummings. He's a big time personal injury lawyer in Nashville. He wrote an article sometime back called "Where Have All the Trial Lawyers Gone?" What I guess I'm getting there is that we knew how to try lawsuits, but what the heck was this mediation, and how is that going to be involved in our cases? We thought it was a fad. We thought it would go away. We thought it wouldn't work. We thought it was too expensive. Why the heck are we going to make people go to a mediation? They got to pay their lawyers typically, and they've got to pay the mediator, and they got to get off of work another day. Oh, I saw someone pop in the chat. Let me see who did that. Michael Hill started in 1995, was resistant at first. Thank you, Michael. Yes, agree, me too. I thought it was a dumb idea. We should just go to the courthouse and hash it out. That's what the judges are paid for. That was my favorite thing. That's what the judges are paid for, right? They make a big salary in bennies, right? So they should be resolving the disputes and not mediation. So I decided, well, crack, I'm going to have to go to the mediation training because all my clients are going to have to go to mediation. I have no idea what it is. It sounds like a little kumbaya to me. I'm a pretty hard-hitting trial lawyer. So I was like, oh my gosh. So I decided to go to a mediation training. I did the 46-hour family law training because I do divorces primarily. I could try anything, but that's what I do primarily. And I decided to go to the 46-hour mediation training with a woman by the name of Jean Monroe. Does anybody here know Jean Monroe's name, or have you heard of her before? She was a statewide trainer. She spent a week every year, I think, down in the Memphis area. Dusty's saying she trained. Okay, Dusty, you're going to get all my jokes, all my Jean Monroe jokes. I appreciate somebody here that's going to get my Jean Monroe jokes. But anyway, she was training all over the state. She was probably the top trainer at the time. She did a week in Memphis. She was from, there's Mary Jo. Yay, another Jean Monroe advocate. It's so exciting that you guys that you guys are with her, because it's like your second grade teacher, right? Whoever your mediation trainer was, you never forget. Well, anyway, I went to this training from Jean Monroe, and I know you hear this too much in the news media, that something or someone or some book or something has changed your life. But honestly, Jean Monroe's training changed my life, and it changed my future. She was just so excited and enthusiastic and knowledgeable about mediation, and wanting us to implement this and wanting us to give it a real try. And I went in there, I mean, skeptical would be an understatement. As I went into her class, by the end, I was like jumping up and down for mediation. But even though I loved the training and I knew what my clients were to expect, and I became a Rule 31 listed trainer way back in 2002. So I've been a mediator for a long time. What I realized, and I hope you guys realize this too, is I started to give mediation a chance, and I began to see something interesting that anybody who's been in this business long enough can tell you, which is that statistically, our cases started settling in mediation. Can I get a high five for that? I can't see you. Can I get a high five for stuff started settling in mediation? And if you're in the business long enough, you know you have to turn your tables. And what we would find is people's retainers were gone by the time we got to mediation. They were ready to settle. They were exhausted. They were done doing discovery. They wanted their case over, and they didn't want to wait 6 months for a trial court to hear their case. They wanted to move on with their lives. We go to mediation. They settle. They're happy. They have a dog in the fight. They have some say in what their outcome is, and they're happier. They're sending you more clients. You're happier. You generally get paid. And I'm like, holy crack-a-mole. This mediation thing has some legs to it. Like, I think I was probably way too skeptical at the beginning. Happier clients, less expensive for them, and wow, it was working. Now, I'm not going to tell you I came around super fast, but over time, lawyers would start saying to me, man, I settled that big case. I settled that big case. I didn't have to try it. And that's where the trial lawyers have gone. They go to mediation, and they settle in mediation, and they do their documents, and they don't actually have to try. There's still a robust motion practice, and we'd still do a lot of discovery. But in terms of trials, I hope you guys would agree with me. They're really cut down based on the way mediation statistics are happening. And the AOC and the commission put out statistics for mediations that are pretty, they're pretty satisfying. You can see how that's working. So that's really the history of mediations in Tennessee in a nutshell. So guess what happened? The AOC decided to start a list of mediators. And if you go to TennesseeCourts.gov, if you've not been doing this a lot, I got some chats. Oh, good. Okay, just those ones I was telling you about. I love for you to put stuff in the chat, so please feel free to be liberal there. So the AOC started a list of mediators. If you go to TennesseeCourts.gov, and I encourage you to do that, under the mediation section, you find the mediation section and look under there. There's a lot of resources in there. You're going to see something called the list. And that is why we are, quote, listed, because we are on the list. So if you're a mediator and you're on this CME training, which I would assume you guys are all listed or about to be listed or involved in listing, go, I can't see you. So if you get bored with this, you just go today during your whole seminar, go on TennesseeCourts.gov and make sure you're listed. Make sure your information is correct. Make sure your address is correct. Make sure your county is, the county where you primarily do mediations is correct on there. And look at the list. If you want to check and make sure you are on there, I do it about every year. I check to make sure that I'm on there. It says family law. It says domestic violence certified under mine if you're looking for me. The other thing is, if you want to see if somebody in another area or even in your community is on the list, you can look on there. Sometimes people say they're a mediator, but they're not a Rule 31 mediator, which is important, I think. So, so make sure you're on the list. As I said, I check that pretty much every year. And if you are new to this game of mediation, one of the things I'm gonna save you from a bad rookie mistake. It is a major rookie mistake in Tennessee to tell someone that you're certified as a mediator. Just don't do it, because it's not correct. In Tennessee, if you are either putting this on your letterhead or you're putting it on your marketing materials or whatever you're doing in conversation with colleagues, trying to get bookings, you need to say that you're listed as a Rule 31 mediator. The operative word, listed. A very good lawyer in another part outside of Nashville just sent me a card. I'll show you my card. This is the card that I used when I became a mediator that I sent out to all my colleagues. Can everybody see the card? Like somebody say I can see the card or something in the chat. So I just put Rule 31 on there. And yeah, Eric says you can see me. It says Charlotte Fleming is pleased to announce she is now listed. See that word listed? By the Supreme Court of Tennessee as a Rule 31 mediator. Please don't make that mistake and say certified. The only certification we actually have in Tennessee is an advanced certification, which is called domestic violence, or in the industry, we call it a DV certification. You can see if somebody's DV certified on the list. If you go to tennesseecourts.gov, you can see it there. That is the certification advance that we have. That is a 2-day class. I believe it's 12 hours, additional hours, that deals with domestic violence issues. And you can handle more cases, and the courts will often appoint you if you're domestic violence certified. And I am going to be teaching that for the very first time in the first quarter of 2022. I have been approved by the commission to teach the DV class in the pilot program that's extended 2022. I have been approved to teach that class online. So I'll have 12 spots for that. If you're interested, I have a email, flemingmediation@gmail.com, and I'll put that in the chat later on if you're interested in that class. And I recommend it for you guys doing a lot of mediations. If you're not DV certified, I recommend that you get that. You don't have to take it from me, but find it. Maybe there's somebody down in Memphis that teaches it. I don't know. But the reason you want to do that is you're going to get more bookings and more, it's a higher certification. So if you're somebody like me in the industry, you want to get that. So what do we have in Tennessee? We have a civil, we're civil and family divided. Not every state is, but we have civil mediators, we have family mediators, we have crossover mediators that do both. A lot of niche mediators like me that do family law mediation, they only do one kind, even though they could do more than that. And then there's a crossover class that you can take, I believe is around 20 hours. There's the DV class I just explained. And then there's this, which Andy is putting on successfully, I might say, which is a CME class, which you need every other year biannually. But always remember, and I'll probably say this more than once, because the human mind needs to hear something 7 times for it to digest it. But you need to renew your application, your standing with the commission every year and pay the fee, which you'll probably hear me say several times today, so you don't forget. Because if you do forget and you lose your listing under Rule 31, you have to take the whole class again. So I've got somebody that's registering for my spring class that has to do it all over again, based on Rule 31, and look at Rule 31 there. So where are we right now in mediation before I talk about what I think is going to happen in the next 10 years in mediation, in the mediation business in Tennessee? The first thing is the mediation community is getting stronger. The community of mediators is getting stronger. I have students that I've trained in Memphis, as I said before. I have trained some people in the East, and most of my students are in the middle section, but the community is getting stronger. What I mean by that is I can call somebody up. There are more organizations, there are more trainings, and I think it's strong and growing in Tennessee, and I'm really glad to see that. Secondly, right now, I think the commission, which is comprised of usually 11 or 12 commissioners with the Adrc Commission, which are volunteer lawyers that are appointed by the Supreme Court. There's 3 new ones coming in January, and I think we have a new chair also. The commission is more active than it's been before, and they're very serious and involved in who gets to be a mediator. They review the applications. They review the trainer applications very, very closely. If something's missing, they'll reach out to my students and say, hey, we need this information before we're going to list you as a mediator. And I think they're more robust. I think they're stronger. I think it's a high level commission. I think they're active. They meet quarterly. I know they've been meeting online, but typically they meet together. One of my students, Lori Reed, is my former students, Lori Reed is on the commission now. And she's spoken for me before, but they have committees, and they're pretty serious about it. They're trying to improve the quality of the training and the people that are mediators in our state. So I think it's a good thing right there. And I'm really excited about working with the commission. Now, the commission, I'm seeing if I had a note about John Jefferson on here. The commission has a liaison, someone that works at the AOC. That person's name right now is John Jefferson. Has anybody ever heard of John before or had any dealings? Andy, have you had dealings with John? I'm wondering. I know
Actually
Andy's
went to
on
law
it.
school with John. So yes, I know
Oh,
John very
okay.
well. Yes,
You know John pretty well then, don't
yes,
you?
yes.
Well, John's doing a good job because, and I don't know where this is in my notes, but I'm just going to say it now. John has really elevated the systems, wouldn't you say, Andy, within the AOC the commission and the portals and everything? Do you know what I'm talking about?
Yeah. John is absolutely incredible. And if you ever get to meet him, he's great.
I have not actually met him, but I've talked to him, and he spoke at he spoke at the inaugural pivot when we pivoted to online. He spoke at my inaugural class. Mary Jo's saying something here. I got to find out what she's saying. John is great. He's changing jobs. I told him cream rises to the top. No. Where's he going? Mary Jo, where is he going? Here I am talking all good things about him. Hey, and tell him I was saying good things about him before I knew he was moving on. I hope he's staying within the organization somehow. I don't know. If you know, you put it in the chat. Anyway, John Jefferson, who's I've been dealing with the past couple of years, I think he's really elevated the technical side of the commission and the way you put in the portal, the way you renew, the way you put in your when you have to put in your mediations to the commission. I think he's been doing a great job. Moving within the court system. I have forgotten the title. Okay. Well, at least we're not losing them to private practice or something like that. Okay, so what have I said so far? Mediation community is growing, strong. The commission is strong and robust and active. Number 3, in my area, at least, the judges are relying on mediators to help with the backlogs. And let me give you a case in point. I was looking at this last night. When the pandemic hit, I don't know if you guys realize this, but the Supreme Court and the ADRC, they called out the cavalry to help with the backlog. You know who the cavalry was? Us, the mediators. They called out the mediators to help. And I'm going to show you this one. This is the Alternative Dispute Resolution Plan to address case backlogs related to COVID-19 pandemic. And it says this is a plan to assist in reducing the backlog of civil cases. This is what it looks like. You can find this online. I think it's on tennesseecourts.gov. But basically, there was this plan that they implemented where they sent it to all the judges, and they were encouraging the judges to be more robust in their mediation appointments and their orders of reference, not just in family law cases, but to do anything and everything to keep this moving. Jeff Bivens is another lawyer I used to work with at Bolt Cummings, who at the time was the chief justice of the Supreme Court in Tennessee. And oh wait, here Mary Jo's telling us something about John here. Hang on. John Jefferson said a promotion with the office will serve as the inaugural chief of staff. Ooh. All right. Deborah Tate and I used to practice law together too in Nashville. I'm getting old. All these people are in charge. Oh my gosh, that is fantastic. That is just fantastic. And anyone who talks to him, say, congratulations. What was I talking about? Oh, this plan. So they created this plan for the ADR to reduce, for neutrals like us, to reduce the backlog by encouraging trial judges to refer more cases to mediation. The community mediation centers were going to be the pinpoint for these, or the portal, the place where they were recommending that the Adrc Commission and the Supreme Court was recommending that the judges refer to. And I was looking at that in the West, in your area. You guys are mostly in the West. It's the Community Mediation Center for West is Mid-South Community Justice and Mediation Center. Andy, is that who you work for, or is that part of your organization?
That is not part of us. It is not.
Okay. Is that somewhere in Memphis?
I believe so.
Okay, I don't have any dealings with them. I'm just reading off the plan. But what's been happening is judges were starting to think, man, maybe this could go to mediation. Maybe this could go to mediation. And we're referring out more, especially if they were getting behind and they weren't being able to do Zoom hearings and that kind of thing. So that was just a case in point of how they, I believe, are standing within the legal community as a mediator is not like, oh, you're some side thing, just, oh, go send it to mediation. Just as we say in the business, just, click, punch my card and get me a trial date. But we're being considered more as professionals in really helping get rid of the backlog. Okay. Interestingly enough, in that plan, and I've been saying this, if you've been listening to me or my trainings for 6 years now, I've been training for the AOC. I've been saying that soon enough, we're going to get there. You're going to have to be a Rule 31 listed mediator to get referrals from the courts or other centers. That is not the case. I think there was a lot of really good mediators that were grandfathered in that never got their Rule 31 listing. A lot of those have passed away, including Bobby Jackson, one of my mentors in Nashville, passed away in 2021. But listen, in that plan that I was just telling you about, this ADR plan to reduce the backload, to bring in the mediators, right? And it's section 3B. It states this. It says, mediators under the ADR plan must be a Rule 31 listed mediator in good standing with the ADRC. So here we go. I've been saying it for a while. You know, if you're mediating without being Rule 31, that's going to be eclipsed, in my opinion, over time. And what does it mean to be in good standing with the ADRC for you guys? One, you're already, I'm preaching to the choir, because you're taking the 6-hour CME right now, which you have to do every other year, which just confuses people. But you know, some of my students, they take it every year just because they don't want to mess up, but they want to know what's going on. But you have to take 6 CME hours every other year, and you also have to pay your renewal fee. What? Somebody put it in the chat. How often do you have to re-up with the ADRC? Somebody. Well, I'm gonna wait. Somebody's gonna put it in here. I know it. Who's paying attention? Every year, Mary Jo. That's right. So don't forget that, and then you have to pay a fine, and then they throw you out, and you don't want that if you want to continue being a mediator. Most Rule 31 mediators are lawyers. You don't have to be, but within my class, if I have 12 students, I might have one non-lawyer mediator. It's tough. It's possible, the rule allows it, but it's tough to break in. I had a couple of women start a mediation center down in Franklin, Tennessee, which is outside of Nashville. They were non-lawyer mediators. They came out of the counseling field. They were wonderful women. They worked for a year to try to get bookings in their mediation center. It's really hard because I'm going to ask this question, like somebody to put it in the chat, maybe someone who hasn't even put stuff in the chat yet. Who is booking you? Who is your audience? Who do you need to be talking to get more bookings? Somebody tell me. Who books you? Does everybody know what I'm asking? How are you getting business? If you want to be a mediator and you want to do more mediations, or you want to get some mediations, how do you get them? Who books you? Who's awake? I know it's early. I'm this first speaker. Oh, it's hard to go first. Just realized that. You guys are warmed up. We have 13 people on here. Don't make me call on people. No, I wouldn't do that. Andy would kill me. All right. No one's putting it in there. I'll give you one more minute. How do you get business? You need to know this. You know it. You already know it. From other lawyers. You get business from other lawyers, and you get business from the court. That's how you get business as a mediator. So most Rule 31 mediators are lawyers. Something that I see now as I close out the part about where I see us right now before I talk about what the future is going to hold is most mediators, and I would like you guys to put this in the chat too, everybody. Are you a practicing lawyer in addition to being a mediator? Are you a practicing lawyer? But what by that I mean, do you have a practice and then you do mediation on the side? Anybody? Mary Jo says yes. Anybody else? Jonathan, yes. Come on, guys. Woo, let's go. Get that chat going. I see two. I would say most of you guys are. I think that most people don't see right now. I think this is going to change. You're going to see me talk about changing, but right now, I don't think people in the industry think mediation is a viable business. Michael Hill, practicing and listed in civil and domestic, fabulous. I think that's normal. I think for me personally, I am a practicing lawyer. I'm also one of the city judges. And what I do is I do some mediations, and then I do mediation training for the AOC. So those are all streams of income for me. But most of the mediators that I work with or that I talk to are what I call la-di-da mediators. You know what a la-di-da mediator is? That's a Charlotte Fleming term. That's not a legal term. A la-di-da mediator is just someone who's like, la-di-da, someone called today. That's great. I think I'll do a mediation on Thursday. Yeah, I got some time, and they pay cash or check, and I just have the money. There's no AR mediating, and all the positive things about being a mediator, that you don't have to deal with it or sleep on it. You can close your file after the mediation is over. These are positive things about being a mediator, right? They don't see it as a viable income stream in the higher income brackets. And I hope I'm gonna share with you some information that you really can make this a viable income stream for you. I hope that's what I do in the next, how long do I have? It's 8:30 to 10, so I have an hour left. Would you guys agree with me on that? Would you agree with me that people are like, yeah, so-and-so's a mediator. They practice law, and then they're a mediator on the side. Would you guys agree with me? That's what you're seeing. I call them la-di-da mediators. They're not marketing for mediation. Jonathan says, yeah, I agree. Jonathan, is there anybody on this? I think if Andy and I are on here, that means there's 11 of you guys, 11 participants. Of you 11, how many of you guys want to do more mediations? That you would like to have that cash flow? Because there's really no AR with no accounts receivable with mediations. Is there anybody on this? Is everybody happy with what they're doing in mediation? You're just getting your 6 hours, or is anybody on here like, yeah, I really, really want, here it is, Jonathan. I don't know you, but I like you. This is the segue that I needed right here. There are a growing number, look in your chat, you guys. There are a growing number of lawyers I know who are moving to full-time mediation. Bing, bing, bing. Dusty says he'd love to do more mediations. Great, because that's my thing. My thing is how, well, I have a whole segment in my training, half a day in my 46-hour training on how to get your basically business in a box, how you're going to get your mediation business off the ground, and how you're going to make it super robust, as many mediations as you want. There's some people that will do 2 mediations a week. There's some people that want just 2 a month. Oh, wait, here I got a chat. I would love to do more. That's Dusty. Mary Jo, yes, but that is due to smaller pool of mediation. In large cities, there are people that are only mediators. We have one mediator here who is moving to full-time. P.S. Jonathan is great. You guys know each other. That's hilarious. It's not Jonathan that's moving to full-time, right? Jonathan, are you moving to full-time? Or she's talking about, no, okay. All right, so with somebody else. All right, so I agree that you're gonna see some mediators. Lisa Houston, I'll write her name down. I might call her. Okay, so there are some people on here that would like to do more mediations, and I'll bring this to the future. So in the last 58 minutes that I have, I want to talk about, I talked about where we came from in the history of mediation in Tennessee and how you could get information at tennesseecourts.gov. You can learn your commissioner, see if you're on the list, all the things. And I talked to you about the portal that we can renew, and you can send your money in, you get your CMEs and all that. And now I want to talk about the future. What I see now, this is a dangerous topic, because anytime you're posing what you think is coming in the future, I don't know if this is coming. It's just what Charlotte Fleming thinks is coming, based on what I'm seeing, based on talking to people, based on reading things like the ADRC plan, based on talking to commissioners. This is what I see in terms of the future. The first thing that I see, let me see what I've got here for the first one. Where are we going? Okay, the most obvious is that the pandemic has thrown us into a situation where we need to know how to do on-ground mediations, and we need to know how to use a platform like Zoom to do virtual mediations. And I would subscribe to you, and I've been talking to a lot of mediators this week in preparation for this and my CME, which is December 2nd. I've been talking to everybody about it, and everyone agrees that you're going to have to be able to do online mediations, but there are some older lawyers in particular that don't want to book with you if it's online. They still want to do on ground. I'm not just picking on older lawyers, but there's some lawyers that just want on ground. There's some that want complete virtual. And what I would subscribe to you is you need to be prepared to do what I call hybrid mediation, which is, I'll tell you how I did it the other day. my client and I went to the mediator's office, and the other group was on Zoom in the other lawyer's office in Clarksville, Tennessee, which is toward you guys, is where the military base is. And I think as a mediator, you're going to need to know how to do all of this if you want to be robust, if you want to grow your practice. Now, there's a really good article by a lawyer in Memphis. Y'all need to know. Her name is Beth Yarborough. That I asked before if anyone knew her. She wrote an article about how she had like 50 or 75 lawyers in the Memphis and surrounding community. I guess what's around there, Collierville. I don't know if she has people as far as Jackson, but she had like 50 or 60 lawyers that were regularly booking her in her office. This was a primary income stream for her and her family. Pandemic hits. Beth, a lot of people didn't want to mediate with her online. So she had to cultivate an entire new group of 50 or so lawyers that were booking her for online. And she said very few are overlapped. And she wrote an article. Who's read the article? Has anybody read the article? Andy, have you read the article? I don't know. I'm always picking on Andy.
Not.
You can see it. It's on the TennesseeCourts.gov under the mediation section. Andy, there's a great article, if anyone asks you, on pivoting to online mediation. And I read that article and I had her speak to one of my classes because I thought it was so good. And when I got to Memphis, my daughter is the reigning Miss Tennessee, and she was crowned in Memphis. Her name's Tally Bevis, if you want to follow her. She was crowned in Memphis. And when I was down there for the Miss Tennessee competition in June last year, I went out to lunch with Beth because I was so impressed with her, and she is amazing. And she wrote that article. So if you guys if you ever see her, tell her that I was talking about her. But she really talked to me about how you're going to be robust online. So here's what we've got. On ground, let's talk about what you need to be doing to be a successful mediator on ground. Now, I wrote an article. Does everybody here know about the Tennessee Association of Professional Mediators? Does everybody know about that? I think it's mostly guys from your area. Andy, can you put that in the chat, the Tennessee Association of Professional Mediators, if anybody wants to look at this article I'm about to talk about? I wrote an article for them. They asked me to write an article, and don't ask me to write an article and tell me I can write anything I want to write about, because I wrote an article called "Where's Our Southern Hospitality Gone?" in the mediation newsletter. They're probably like, oh my word, like, what is this lady writing about from Nashville? You know, what is she talking about? The experience economy. Has anybody here read the book, The Experience Economy? Anyway, you need to make your mediation, if you're the mediator, an experience. That's what I say. That's what my article argues. Okay, so when does the mediation start if you're on ground? When does the mediation start? The answer is not when they walk in the door. When does it start? Anybody? Put it in the chat. When does the mediation start? Wish you guys could yelp out. When's it start? Well, it starts when they call your office to book. If you do not know, there they are. Here goes Mary Jo. Thank you, Mary Jo, for being on it. Before they arrive, when they receive information from the mediator, ding dong. I mean, your mediation starts when they call your office to get a booking. Okay, you need to talk to your secretaries, your paralegal, whoever's doing intake for your mediations, that there's a different intake procedure for mediations as there is, and this is for on ground and online, different intake procedure than your regular law cases. You need to say, what are they, tell your secretaries, if you're working with their secretaries, like, what do you want me to say? You've got to have some dates available for people to book with you. I usually keep about a 3-hour slot a week just for an emergency mediations, because if one of the judges calls over and says they have to have this mediation done immediately, you want to be able to accommodate that. And you can always do drafting and stuff in this time if your mediation time is there. But tell your secretaries, are you going to start at 9 and 1:30, 8 and 12? Are you going to do all days? Are you going to have deposits? How are you going to get your contracts out? How are you going to do your letters to the lawyers that are booking you? Have a procedure, have a system, start your experience at that point. Because if it's hard to book with you, they're not going to call back. You've got to make it easy on the on-ground experience. The second thing is you've got to have some snacks. You got to keep people's sugar levels up. Everybody knows that. You need snacks, protein bars, drinks, whatever you can afford and whatever you can do. But you need to have something. And I always tell my students, if if you're charging 200 or 250 or 300 an hour, you can afford 4 lunches, a sandwich from the local deli to bring in lunch. Because if you lose momentum as a mediator, you know you could lose your deal. And you're all about the deal as the mediator. So the experience when they're there, make sure it's not too hot or cold. Make sure you have charging stations for phones. Make sure they know where the bathroom is. You guys all know this. This is Southern hospitality. I need you to think about that if you're doing something on ground. Ask yourself, make yourself walk into your law office as if you were mediating there. How would you feel? Or have someone walk in and tell you how they feel if you want to do a dummy take of it, and see what you need. And make sure they know where they're allowed to go if they're a smoker. Because if smokers can't smoke, they get weird and they don't want to, they're not going to finish their mediation. Where they can get some air, where they can make a phone call. And I don't let anybody else other than the people mediating come into my mediations, because if grandma comes or boyfriend or girlfriend, that's going to be a huge problem. I recently had someone try to bring a child to the mediation, which I did not agree with that. So if it's on ground, if you want to read more, I wrote that article for TAPM in, I think it was November of 19. I think they do those articles quarterly, all about the ways that you can have an experience. Because if they have a good experience and the lawyers have a good experience, then they will rebook you. Because what do you want? You want a rebooking. Wait, I got something in the chat. Dusty King says, we had a fight break out in the parking lot between the 2 new spouses in a post-divorce mediation. Exactly. That's why I let the groups go out like one, and then I make sure they leave the parking lot, and then I let the other people go. But I always say, who's in charge of your mediation? You are in charge. Oh, wait, Andy is showing, this is the kind of stuff I'm not sure how to do. And by the way, you guys, I don't even type. So I came of the era where women lawyers typically didn't type because they'd be confused with a secretary. That's a whole nother story when I started practicing law. But Andy Cole just put my article on the link of that. If you want to read it, there's some more tips in there for on-ground experience. But remember, you want to make an experience. Okay, online. How the heck are you going to make an experience online? Well, the first thing is read Beth Yarborough's article, but also you can still be courteous. You can find out about people. Can you make sure they have a coffee? Make sure there's no one else in the room. You've got to protect your privacy in the mediation. You may want to check your contracts. There's some articles in the TAPM. There's a really good article in the TAPM newsletter about what to add to your contract to make sure there's security, that's safe and secure online if you're doing an online mediation. Your contract, but you still have to follow the same things if you're doing online. You still have to secure the room. You still have to be courteous and hospitable, letting them know if they need to talk to their lawyer, what they can do, if they need to break, what they can do, if they need to get snack, what they can do. Let people know what's coming. People are scared when they come to mediation. They don't know what it's going to be about. They don't know how it's going to go, especially online. So also familiarize yourself with Zoom. If you're going to use Zoom as your platform, I was scared. I didn't know how to use Zoom until the pandemic hit, and I had to learn how to use it. So I started doing YouTube videos. Don't laugh at me, you guys. I literally was doing YouTube videos on how to do breakout rooms because I was like, I don't know how to do breakout rooms. How do I put somebody back in the waiting room? I didn't know. So I educated myself. So if you're taking notes, right, educate yourself on the platform that you're going to be using. Because guess what? I wrote this in caps. That means I definitely want to tell you this. There is no question that remote participation is here to stay. And I agree with that. We've been thrown forward probably half a decade or a decade with a pandemic on so many things. But for mediators, doing the online mediations and doing the hybrid mediations, where you're just going to have to get used to it. There's going to be, and it's good for domestic violence cases because you can keep the victim separated. But it's also good for people out of town, for people that are ill. I just think it's here to stay. So let's get used to it and consider an addendum to your contract that deals with securing that space. I do want to tell you that be flexible and be knowledgeable about different ways that you can conduct your mediation. Let's just use Zoom because we're on Zoom today. Zoom, as I don't like some of the other ones that I've tried to do it on. I'm sticking with Zoom because I understand it now and I'm getting better at it. But remember, there are different mediators. Like if you're going to a mediation or you're doing mediation, you don't have to do what I do. You don't have to do what some other mediator does. Let me give you a couple of examples of what I mean. I have a friend, Lindsay Ralston, in Gallatin, Tennessee. That's outside Nashville. She's a fabulous mediator. She's one of my students from many years ago. And she has 2 computers in different rooms. And she is so afraid of a Zoom bomb. Does everybody know what a Zoom bomb is? Where something like pops onto your screen. It can, I mean, one of my friends had a sexual thing pop up on her screen. She had to shut everything down. Those are called Zoom bombs. They don't happen very often, but she got freaked out by Zoom bombs, and she put 2 computers up in different rooms. And she literally, you all, she literally stands up, walks to the other room, and sits down and starts that part of the mediation online. I'm not saying you have to do that or you have the space to do it, but just remember, different mediators are doing it in different ways. The second thing you can do, and this is what I do because sometimes breakout rooms doesn't work for me. I put people back in the waiting room because I can verify that they can't hear and I can see them in the waiting room. So I put like one group back in the waiting room. That way they're not kicked off. I know some lawyers, actually some mediators will say, I'll text you when I want you to get back on, but then you're always letting people in. So for me personally, it works for me to put groups back into the waiting room. 2 computers, putting people in the waiting room. And then a lot of mediators will do breakout rooms. There's a breakout room feature on Zoom. If you don't know how to use it, watch some videos. I do know how to do breakout rooms. I don't do them that often, but I do know how to do them. But pick a system that you're comfortable with and stick to it. Also, you never, ever, ever want to embarrass a lawyer with technology. If you have a lawyer that is muted and they can't get off mute. I had a guy that was obviously his first time on Zoom. He was troubled with his video. He couldn't get the mute on and off. And he was just fumbling and fumbling. I'm talking about the lawyer now. I'm not talking about the client. Help the lawyer with the tech. He finally had to go get his secretary to help him get off mute, but you can't do a mediation if you can't hear the client or the lawyer talking. So we were able to do that, but don't embarrass. If you're doing an online mediation, don't embarrass people because they don't know how to do the tech. That is like 101, rule 101 with that. Try to help, do whatever you can. We did have a lady whose internet went out once when I was doing a mediation, and we actually, with communication and acceptance by everyone, she continued to participate by phone. So if you're in desperate situation, get somebody on the phone. But pick a system and stick to it if you're doing mediations hybrid or you're doing mediations online. And you don't have to. Guess what? You don't have to. It's your business. You get to do what you want. You can do it on ground. You can do it online. You can do hybrid. You can do whatever. But if you want more bookings, I'm recommending you do it all because and be good, as good as you can in terms of your craft so that you can get you can get more bookings. You still have to do, whether you're online or on ground, after you secure the room and everything I've already said, you have to follow the 4 phases of mediation, which we need to cover. The 4 phases of mediation, and you guys all know this, but when I used to go to Jean Monroe's seminars, after I took her 46-hour class, I took her seminars for years. I went to I would drive everywhere she was teaching. I just wanted to sit at her feet. And eventually she asked me to start training for her, because her voice would go out. Because if you're teaching for 46 hours, like this is an hour and a half, I can do this easily. But if you're speaking for 8 hours a day or whatever, you can lose your voice. So she would ask me to train like on parenting plan or something like that. That's how I started training. And then when she retired, for all you guys that are Jean Monroe people, I took over her business. She asked me to take over her training business, and I got approved by the ASC. And so I asked her to speak for me, and we kind of went backwards. And then I eventually took over her business, which I'm very grateful for. And I thank her all the time for it. We're still in contact. She's retired now. She lives in the East. But every time I went to one of her seminars, no matter what the topic was, she always reminded everybody of the 4 phases of mediation. So I'm going to remind you of the 4 phases of mediation. What's the first phase of mediation? Who's taking notes? What's the first phase? One of my people that are active today. Introduction. Thank you, Michael. How long should your introduction be? You should be practicing it. It should be fluid. You should be able to do it without looking at notes. I have a little card that I give my students that's got, like a cheat sheet card, explain this, do this, whatever. And here are the 4 phases of mediation that I give out, my confidentiality, mutual respect, that kind of thing. But introduction is required by the rule, and don't ever forget it. Rule 31, section 10 says, and I'm quoting, and by the way, If you don't have Rule 31 printed out off of, and by the way, it's in tiny, tiny print. So if you're blind like me, you have to get your readers out. Because, you know, when I'm reading the rule, I read it aloud. That's another tip that I can give you guys, read it aloud. But anyway, Section 10 says in Rule 31, and I'm quoting, before the commencement of any Rule 31, the mediator shall. What's the difference between shall and may? Shall means you will. You will do this. You will do this. I'm gonna pull out my rule. So I keep my rule. I keep my rule in my training book. I can pull it up anytime I need it. I suggest you take the rule with you wherever you go, so you have it or you can pull it up. Section 10, obligations of Rule 31 mediators. A, before the commencement of any Rule 31 mediation, the Rule 31 mediator shall, 1, there's 3 things. Make a full and written disclosure of any known relationships with the parties or their counsel which may affect or give an appearance of affecting the Rule 31's neutrality. Okay. 2, this is the part where the introduction comes in. Advise the parties regarding the Rule 31 mediator's qualifications and experience. You need to explain to the people that are coming to your mediation what your qualifications are and what your experience is. And for lawyers, that is really, really hard for us. We don't just get up every day and go, oh, I went to Emory Law School and I've been a lawyer for 34 years. And, you know, I have had over 7,000 divorce cases in my life and I trained for the AOC. It's very uncomfortable, but you have to do it. Why? Because the rule says you do. Plus, people need to know you're qualified. I also say, listen, I've taken an advanced class, 46-hour class, to be able to mediate. You're telling the person, look, I am qualified to do what I'm about to do and try to settle your case. Because I'm Switzerland or the Red Cross. I'm not for you. I'm not against you. I'm for the deal. Okay. So 1 is regarding any conflicts of interest. 2 is regarding your qualifications of experience. And 3, it says, discuss with the parties the rules and procedures that will be followed in the Rule 31 mediation. Rules and procedures, what that means is it's a confidential proceeding. I will testify against you. My fee, you're supposed to bring up your fee. My fee is $250 an hour. I have a 2-hour minimum. And by the way, you need to know that. And what the minimum is in our area, what's the minimum in you guys' area? Somebody tell me that mediates a lot. Somebody was saying they do quite a bit of mediations. In our area, it's 2 hours. If you don't try to mediate for 2 hours, the judges are not going to stamp your card through to a trial. What is it down there? Minimums 2 hours, 3 hours, or anywhere, because it's not in the rule. We have mediators in our area that do 2-hour minimum, 3-hour minimum, and 4-hour minimum. That's what I normally see. Who was telling me before? Here comes somebody in the chat. No minimum time. Okay, that's interesting. So who was the guy that was telling me he's done like 35 or 40? Here it is. Mary Jo, you doing a lot too. Mark, if you're still there, what are you guys' personal minimums? Is it 2 hours for you to book your morning? Is it 3 hours or is it 4 hours or do you just do whatever? Somebody tell me what you got. What in your area? I do whatever. Okay. Interesting. That's very interesting. With the pandemic, I do know I charge for a 2-hour minimum. Me too, Mark. That's my minimum. I charge 2 hours because I get ready for it and I get the court file and I get everything ready and the packet ready and everything. And I feel like, you know, if someone's just going to cross their arms and not really try to mediate, just wants to get through to the trial, you know, 2-hour minimum for me. I don't always enforce it. Yeah, if one side doesn't come, sometimes I just charge them 30 minutes, right? Thanks for that. Our mediators take a non-refundable, Mary Jo's talking to me here. Thank you. Our mediators take a non-refundable for 2 hours. The judges don't inquire in the minimum time. Interesting. Okay. That's really interesting. So what I tell my students is that I think that the opening statement or introduction should be about 5 to 7 minutes. I think you should read it out to yourself or talk to some pillows about it, do it for your dog, and tape it, see how you sound, memorize it, really get your craft on your introduction, because it does set the tone for the mediation. It also keeps the lawyers in line. I recommend that you look directly at the person that's mediating and not the lawyer when you're doing your introduction. That way you establish rapport with them and they see that it's about them and it's their day. It's not the lawyer's day in court. So introduction, this is on behalf of Jean Monroe. Jean, I know you can't hear me, but I'll tell you later. I'm reviewing the 4 steps of a mediation with my class today. Introduction, we've covered. The next one is issue spotting. How do you pivot from introduction to issue spotting? When I'm pivoting, I always clap and I go, okay, so I've told you a lot about me and how much this is going to cost and what we're going to do today. And I've showed you where the bathroom is and where you can get coffee. Does anyone need anything? By the way, your host or hostess responsibilities don't end after you give them that. They don't listen. They're scared when they first get there. They forgot where the bathroom was. They don't know where they can go. They don't know if they're allowed to get coffee or you have to get it for them. So I'll say coffee bars open, those donuts are for you or whatever. And, give them permission to do that. But your host and hostess responsibilities carry on throughout the day in your mediations. If you want to be a good mediator, I say they do. Okay. Phase 2, issue spotting. So I would suggest a pivot. It says, okay, let's get started. Tell me a little bit about yourself. And ask that open-ended question to get the conversation going. Obviously, look at the person that's mediating, get the issues. Sometimes I'll take out the letter or the pre-mediation packet that the lawyers have sent. And as I always say, somewhere in all of this, compliment the lawyer. And I'm going to compliment someone that has been in the chat today. I'll compliment Mary Jo. Mary Jo, I've known Mary Jo for a while, and I think she's a wonderful attorney. And she's going to be your lawyer today. If you have any legal questions, you certainly ask her. I really appreciate what she did for me. She gave me this whole packet of information before the mediation so that I could be prepared today and it could be more streamlined. What does that say? You're complimenting the lawyer. And by the way, say the same thing in both rooms. Number 2, you are thanking them for their paperwork. Why is that important? Because they're billing their clients for the paperwork. So if you compliment the paperwork, it says that the lawyer, when they get their bill next month, was right in doing that. I cannot emphasize enough how you want to try to get along with the lawyers that are booking you. They are booking you. This is where you're getting money to go to Europe or pay for your kids' college or put food on your table or put your retirement, however it is. These are people that are giving you money and you want to compliment them, not in a disingenuous way, in a genuine way. And if it's someone I don't know, like I was thinking, I don't know Dusty, for example. Dusty King, I'd say, listen, I've not worked with Dusty before, but he has a great reputation and he's given me all this paperwork and I look forward to working with him. And the other thing I can tell you is treat each of the lawyers exactly the same, online, on ground, whatever, even if you golfed with them the Saturday before. Because if you greet one like, hey, Dusty, how are you doing? How's your brother from the golf course? Da, 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 da. And then the other lawyer comes and you go, hello, Mr. Hill, how are you today? You'll be in this room or whatever. You see what I'm saying? It's the tone of your voice and it's what you're saying. You must be a neutral on all accounts, which is including your tone, your pacing, and the word choices that you use. So make sure you compliment the lawyers in somewhere between introduction and issue spotting, and then get out that paperwork and go down there and go, okay, so you have a house. Yes, what would you like to happen to do with the house? You see what I'm doing? You go into issue spotting. Try not to settle your cases in issue spotting. Get the issues out. It's like a puzzle. You know, what do you do when you get a puzzle? You guys, Christmas is coming. Who does puzzles for Christmas? What do you do when you get a puzzle out of the box? Somebody tell me. I'm gonna have to pick on Andy. Lay out all the pieces. Dusty, yes, thank you. You lay out all the pieces on the table. That's the same as mediation. If you only lay some of them out, you don't know what colors you're getting into. And by the way, you flip them over and you line them up and you put the edges out, right? I mean, this is what we do every Christmas. We set up a table for the puzzles. Mediation is the same thing. Don't try to problem solve until you got your issues out. So issue spotting, get it out there. 20 issues, 30 issues, find out if there's a timeshare, find out all the things, get that done, get your issue spotting. You got all your puzzle pieces on the table. Okay, what is the third phase of a mediation after you get all the issues on the table? Anybody who can tell me what the third phase is? Problem solving. Thank you, Michael. I'm gonna, you guys better come see me in Nashville. I'm gonna buy you coffee for being my my go-tos today. And anybody jump in here. These other participants, jump in. I love people in the chat, so please jump in. And if you have any questions, pose those too. So problem solving. Problem solving is the third one. Again, make a pivot between issue spotting and problem solving. What that means is you do something like, so is there any other issues, Mr. Hill, that you can think of? Counsel, can you think of any? Da-da-da, you think of any? Oh, great, got all my puzzle pieces. Here's what they are. It looks like we've got 15 issues. You put skin around the issues so people know this is what we're mediating, right? And then you move into problem solving. Problem solving is putting the puzzle together. If you keep your IRA, then she can have more equity in the house. And you start horse trading. right? That's what you do. You're a horse trader. You're just going back and forth between the rooms, figuring out the problem solving. Okay. And then let's say there's a settlement and you settle it. What is the last phase of the mediation for recapping today? What's the last thing you do if there's a deal? Write up the agreement. Thank you. So we do memorandums of understanding. In the business, we call those MOUs. Some lawyers will do the documents right on site, but if it's late at night, you may not be able to do all the documents. You may have to do a memorandum of understanding and get that written out, and everybody sign it. And then you have your reports to do. How many reports do you have to do? Anybody? How many reports do you have to do when you finish a mediation? Oh, I'm giving you a hint. 2. Right. Mary Jo, exactly. 1 is to the court, the report of mediator, which you have to decide is whether is it included in your fee or not. I include mine in my fee. And I try to get that out immediately. The rule gives you a lot of time, but I wouldn't use it. I get that out immediately. And then the other one is to who? It's to the AOC. On your portal, you put on there, the name of it, did it settle, did it not, for their statistical sheets. Okay. Any questions? Can you pop in the chat right now? Any questions you have? I have just, in honor of Jean Monroe, reviewed the 4 steps of a mediation for all of you today. Any questions? Well, we're gonna pivot. Okay, so I told you what the future holds. It's going to be online. It's going to be hybrid. It's going to be on ground. You're going to be a great host and hostess. And I'm going to tell you the next thing. This is number 2, and what I think is coming in the future of mediation. And that is the judiciary is going to get more involved, and there's going to be judicial centers. There's going to be centers for mediation within the judiciary realm. What do I mean by that? There's a lot of words that include a judiciary. They're going to be more conducive to mediation. I went down to a rural, I'm not even going to tell you what county it is, because this is my hand to God true. Not long ago, for the pandemic, I went to this small town outside of Nashville, and the judge looked at me straight in the face and said, Miss Fleming, mediation is for big city lawyers. We don't do mediation down here. I'm thinking, oh boy. Okay, Your Honor, no mediation. He waived it in every case. So that's not going to happen. I think that the judicial conferences, they're talking a lot about mediation. They did this plan and sent it out to all the judges in the state. I think the judges are going to do more. I think they're going to do more orders of reference and more kinds of cases, maybe adoptions, maybe juvenile court may come involved in this. I see the judiciary getting more on board, not every judge, but as a whole, I see this improving. I think within the court system, not necessarily the old courthouses, we still use our old courthouse, but in these judicial centers, I don't know, does Memphis have a new judicial center? And they're building a huge new one in Nashville, where they're going to have more meeting rooms for lawyers and more mediation areas. I think there's going to be more areas where you can mediate in the courthouse. That's just my guess. I see new judicial centers having rooms for mediations and for domestic violence, for DV cases. I see judges turning to mediations for backlogs for certain kinds of things. I see more judicial support. I see judges getting some of their staffing. I see more people getting trained in the mediation process, whether it's somebody who works for the court or whether it's a liaison to the lawyers. I see all this coming. I'm seeing it coming in little bits, but I see it coming more in the next 5 to 10 years. I see it coming more robustly. And I really think eventually there's going to be a staff person, whether it's a clerk or a liaison or a coordinator, an administrative assistant or something that coordinates the mediation functions. Right now, a lot of that's being done by the clerks, and I don't see that being designated. But if there's mediation rooms within judicial centers around our state, that is a possibility. I see that as something that's coming. We will have to wait and see. Something else you need to keep in mind for you guys, whether you're just this is from a law standpoint or whether this is from a mediation standpoint, is I am hearing rumblings coming out of the TBA and committee that the going to non-binding arbitration as another step in certain cases. I don't know if that's just going to be civil or in family as well. Does anyone know anything about that? I'm hearing rumblings that that actually has legs and it may come out of committee. What I'm talking about here is another step. I always say mediation's a hoop you have to jump through. Andy, are you hearing anything about this non-binding arbitration that's in the TBA committee now?
I've seen a few articles about updated arbitration, but I haven't had a chance to look at them.
Okay, Mary Jo's saying it was not approved by the Supreme Court. Okay, you guys, that is something that I don't know if that's coming, if that has legs or not, but just keep your eyes peeled on that. Right now we have mediation and I see it becoming more robust. Okay. This is something I got to talk to. This is probably the main reason why I accepted Andy's call when he called me and said that they'd had an untimely passing of one of the speakers, and I jumped in because I wanted to help Andy, and I'm always trying to help in the mediation arena. But the thing I wanted to say to you all, the point that I wanted to make when he told me the topic, which was awesome, is I am tired of hearing what I'm about to say. I get a call. Charlotte, hey, I really want to take your class in the spring because I teach a 46-hour in the spring and the fall. I really want to take your class in the spring, but my area is saturated. There's just so many mediators in Nashville, or there's so many mediators in blah, 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 wherever their town is. Should I really take the classes early? I mean, come on, y'all. We are not saturated. I looked it up. So, and this is a guess. Like, everybody, come on, everybody that's participating, guess, don't look it up on Google. Guess how many lawyers are there in the United States of America presently, licensed attorneys? Does anybody know? Because I had to look it up. Just guess. Start guessing in the chat. Somebody guess how many lawyers there are in America. It's more than I thought, actually. Okay. Somebody put in there. 1 million. Very close, Mary Jo. 4 million. A little high, Jonathan. Guys, thank you for voting. Thank you for jumping in. I really appreciate it. I am not the kind of trainer that can train without feedback. I just thrive on it. I like the interaction. So the answer is 1.3 million lawyers, which has been staying pretty solid for the past few years. That's a lot of lawyers. And we have what, 20? Andy, how many lawyers do we have in the state of Tennessee? I'm thinking I saw something around 20,000. Do you know?
I am not sure.
Okay, I'm putting you on the spot. You're never going to invite me again because I'm always putting you on the spot, Andy. He's like, I'm looking up how many lawyers there are in the state of Tennessee. I think there's around 20,000, but I know that there's about 1,400 mediators. So what I tell my students is, look, you are going to raise your standing in the community because mediators are considered very high socially, very high within the legal community. Am I right? If someone comes up to you and says, I think you'd make a great mediator, that's a compliment. Or if you book someone to be a mediator, that's a compliment. That means that those two lawyers think that you have the skills and the craft and the personality to be neutral and help them settle their case. It's a compliment, okay? And no, we're not saturated in the state, for Pete's sake. There are areas, I keep hearing about this, there are areas of the state of Tennessee that are what they call mediation deserts. Have you ever heard of food deserts where there's no grocery store? You have to drive 5 hours in Alaska to get to a grocery store. Well, there's mediation deserts too. There's places in the state where there's one mediator, maybe two, and they're just part-time or they're retiring or whatever. Come on, you can mediate in the whole state with your listing. And with online, you can do more. That's the argument that I want to make and why I wanted to do this for Andy and for you guys, because I want to tell you, you're in the right profession. You're doing the right thing. Recommend to the people that you think would be good to become a mediator, because sometimes you have to see it in them before they see it in themselves. And tell them, I think you would make a good mediator. And I love mediating and I would love to book you. So there's lots of space for new mediators in the state. I really think we could double and still have plenty of work with the amount of work that's coming down the pike that I see in the future. So if there's 1,400 mediators and you guys are in a very select few of them, I just read this article. Oh my God, it was amazing about mediators. And I think it was like a mediate.com or something like that. I tried to read everything and it was talking about the future of mediation. And they said the first call will be to a mediator and not to a litigator. And secondly, oh my gosh, this just makes my heart sing. This is what this author said. He said, mediators serve needs of the public like village elders. Village elders. That's what people think of us. I mean, what a compliment. And I don't say elders based on your age. I say it based on your ability to settle the suits. That is so heartwarming to me that anyone would think of me as a village elder. So you guys are in the right place at the right time is what I'm trying to say. I think we're about to pop when it comes to mediation. That's my view of the future. We need more mediators. It is not saturated. If someone says that to you, say, no, that's not. There's lots of room for new mediators. And I read last night, I was reading a book, and I think it was, by the way, you guys need to be readers because readers are leaders. No, it wasn't Making Mediation Your Day. No, it was. This is a book I'm reading now. It's called Making Mediation Your Day Job, How to Market Your ADR Business Using Mediation Principles You Already Know by Tammy Lenski. Hold that one up there if anybody wants to screenshot it. I think it was in this book. It was a quote in this book. It says, "The wise person doesn't give the right answer. He poses the right question." And that's what you need to do, is you need to be the best person posing the best questions. What kind of questions are you posing in your mediations? The difference between a good mediator and a great mediator is their questions. To find the unmet needs, to find out about that person, to find out what makes them tick, to find out how you're going to get that case settled. And one of my favorite questions right now is when we're in mediation is I'll say, if they just clam up or they stop talking, or, when it happens, I go, well, I'd like to, but you say, what are you concerned about right now? You change your tone. What are you concerned about right now? I'm concerned I'm going to be broke and I'm not going to be able to pay my bills. And then they start crying or whatever. You get to that point with what their real feeling is about it. Jean Monroe used to call it the unmet needs for you guys that train with her. If you can't find the unmet need, you can't settle the case. So you have to find it. How are you going to find it? You're going to ask questions. You're going to ask good questions. So the wise person doesn't give the right answer. You're not making a lecture in a mediation. You're posing the right question. So my point to you is that what I see for the future of mediation in the state of Tennessee are mediators that are better than they are now. They're taking it seriously. They're going to seminars like this one. They're reading books like Making Mediation Your Day Job. I'll tell you another book that I'm reading right now, which is more neurolinguistics. And there's a real connection between the brain and solving disputes. It's called neurolinguistics. And I've been studying it for a while because Jean Monroe used to do a segment on it. There's a if you really love it, there's a really great book that I'm reading. It's dense, guys, but it's good. It's called The Mediator's Toolkit, Formulating and Asking Questions for Successful Outcomes by Jerry O'Sullivan. I'm going to hold it up in case you want to screenshot it for that. But in the back of it, oh my word, you guys, it's ideas. It's ideas for, here's one of my favorite it's questions that you can use in mediations. What is the worst thing that could happen if? So it's just a lot of good questions. And I would just write your favorite questions down that come off your tongue and keep them in a little cheat sheet in your book when you go into mediation. So I see the future of mediators in the state of Tennessee is that they're better at what they do. How do you get better at what you do and you stop being a la-di-da mediator? A la-di-da mediator is just like, la-di-da, I guess I'll mediate that case today. One of my friends that does mediations full time, he said, I am tired of la-di-da mediators being text messages with legs. I started laughing so hard. I still haven't stopped laughing about it. Text messages with legs. What he's saying is that people are not, oh, okay. I guess it didn't settle. We've reached impasse. Thank you. See you. Pay at the door. Bye-bye. What? I mean, come on, you guys. Our job is the deal. Our job is to get the deal. Fight for the deal. Don't give up at the first hint of impasse. Ask good questions and keep it rolling. I think that's what the future of mediation is. I'm calling it the rise of the highly skilled mediator. And I think you're going to see some people become full-time mediators or a lot more mediators. They're going to do a lot more mediations and they're going to make more money doing it. Now, I'm going to tell you a story of a man that I know that trained with Jean Monroe. His name is G.C. Hudson. Has anybody ever heard of him? He's in the East. I guess he's north of Knoxville. Has anybody heard of G.C. before? If you did, put it in the chat. He's a full-time mediator. And he's been a full-time mediator for several years. I've interviewed him before in one of my classes that I taught. I have guest speakers, and I asked him to come on because I asked everyone in the state that I could talk to who makes the most money in mediation in Tennessee. I want to know who makes the most income as a mediator in Tennessee as a model for what's possible if you want to make a living as a mediator, or more money than you are as a mediator. And I called GC and I asked him. I actually called him yesterday because I wanted to get his most recent, cutting edge, what he thinks the future of mediation is for you guys, because he mediates every single day. He told me to tell you guys that he has 10 mediations booked this week at $300 an hour. And that's, first of all, that's incredible. I know he works long hours. I know he takes weekend and evening work. He's just, this is how he's feeding his children and doing his business. But I figured out if he does 10 mediations a week, $300 an hour, at least $1,000 per mediation, you're looking at, my guess, $300,000, $400,000, $500,000. And sometimes he does corporate divisions and the fees even higher than that. He's one of the highest paid mediators that I know. It makes several $100,000 a year. I don't think he'd be, I mean, I think he'd be proud of it. He'd probably tell you how much he makes. It could be way more than that, as a matter of fact, but it's a lot of money. And he loves it and he's good at it. And he has, you know, videos and a portal where you can pay online and all this contracts with DocuSign and oh my goodness gracious, he's got a lot of tech going on with it as well. But my point is that what I see for the future is the rise of highly skilled mediators that fight for the deal, that work and that make really good money doing it. And they can put that in their pocket and then go home and they don't have to, you know, work on their trial brief all weekend. So I want to ask you this question. I only have 15 minutes left and I've got to talk about cryptocurrency and I've got to talk about digital assets because that is cutting edge, cutting edge, you guys. But before I get there, let's talk. I got to have a marketing moment because that's what I'm known for, is marketing and mediation business. First of all, you got to have some kind of thank you cards. These are my thank you postcards. This is the courthouse in Robertson County. Come see me, please. If you're on this, stop by. You always have a place in Robertson County outside of Nashville if you need a cup of coffee or a copy or just want to talk. These are my postcards that I send for bookings. Thank you so much for booking me. Especially send a thank you note to a new lawyer that's booked you for the first time, thanking them for booking you. Some mediators have cards, and just make sure you have something at the ready to be able to send out when you're thanking them for booking you. But ask yourself this question. I really want you to ponder it. Who is booking you? Who is booking you? Is it 2 or 3 lawyers that are booking you all the time? Is it 10 lawyers or 15 lawyers or 20 lawyers? How are you getting bookings? Are you asking people for bookings? Are you saying, hey, Mary Jo, if you ever have a case in the Nashville area and you're not able to mediate it or you're double booked, give me a call. I can absolutely do it online. You see how I did that? Mary Jo, can you answer me? Just pretend we're talking. Okay. How would you respond to that? She's probably using the restroom and I just called on her. But anyway, you need to ask. Thanks, I'll do that. Yeah. And if I need somebody there, Mary Jo, I'll refer to you. We need to refer to each other if we can't do it or we're double booked. And ask yourself, who is booking me? Write it down. Keep a list of all the lawyers that are booking you and maybe send them a holiday card. Definitely a thank you card. So who's booking you? And are you doing your thank you cards for them? Are you reading to become that highly skilled mediator? You know, try to read a mediation book. You'll read a law book or you read a fun book or you watch a Netflix, but you know, read 20 or 30 minutes on mediation once in a while and get some new questions and really fill your mind up with what is possible. The future of mediation is mediators that stay up with what's going on. And let me tell you a couple things you need in your toolkit, in your packet that you walk into every mediation with. You need your cheat sheet on confidentiality. You need to memorize your opening statement or your introduction. You need to have Rule 31 with you in case something comes up about Rule 31 or there's a question about Rule 31. You need to have it with you. We've got skin on our rule. We're not one of these states where they've got mediation rules all over the place. We've got a solid rule. Guess what? The commission and the Supreme Court, they change the rules occasionally every couple of years. So don't be pulling your Rule 31 out. If you were listed 12 years ago, you need the new Rule 31 and through Rule 31A that came out a couple of years ago. Keep up with the Rule 31 changes, okay? Read the rule out loud. Remind yourself that you have pro bono responsibilities up to 3 mediations a year. You need to tell the judges. They're the other people that are booking you. Hey, judge, whatever. I have 3 mediations I'm going to be doing in 2022 and I haven't done any yet. So please feel free to send me one, because if they get in the habit of sending you and referring you mediations, what do? They send you more mediations. So remember, you have pro bono responsibilities within the rule itself. That's part of the honor of being a Rule 31 mediator. So that's one thing you need to bring into your mediations. The second thing is the child support guidelines if you're in family. If you're in civil, obviously, I'm not talking to you right now. But if this is a family law case and there's children involved, you need the child support guidelines. You need to know what the imputed amount is. Normally, you're not going to use that, but you might. The imputed amount went up, what, last year? I guess it was 2020. Somebody correct me if I'm wrong. They just added a couple rules to the child support guidelines. I think step parent for dental is increased. Something about if somebody's in jail, you can ask for your child support to be changed. I don't know, there was controversy over that one, but you got to keep up with what the child support guidelines are. So you've got Rule 31 to print off, and it's tiny, so get your glasses, print it out, 3-hole punch it, put in your book. Child support guidelines, you need to have that. And this is what I'm going to spend. I've only got 11 minutes left. Oh my gosh, how am I going to do this in 11 minutes, Andy? But I'm going to do it. You need to keep up with what is going on with assets. Whether you're doing a business division or whether you're doing a family law division, this is the cutting edge right here. This is the future of mediation, and you need to know about it. And don't tell me you don't. You need to at least understand the words, the vocabulary of digital assets. Okay, what the heck am I talking about? Digital assets. This is the part where you get your pen out if you haven't been writing and you don't know much about it. Now listen, if you're in a crypto group, discourse group, and you got, $300,000 and yeah, Eric, thank you. Somebody coming on. Boop, boop, cryptocurrency. I appreciate you guys popping on. I really do. Okay, so everybody's heard the word cryptocurrency right now, but let's talk about this in a more general field that I'm calling digital assets. You've got to know the language because everyone needs to print out here, Joe. Everyone needs to print out the new guidelines, which are effective May 2020. We will have Daphne Davidson covering those at the Family Law Seminar. Good. Hey, somebody send me information about the Family Law Seminar. I definitely want to be in on that. Anyway, digital assets. Okay. Well, I had this, I had this one mediator go, I don't know. I mean, that's up to the lawyers. The lawyers need to know what assets have to be divided, and the lawyers. No, the mediators need to be up at least minimally on what is going on in the digital asset world. It's big, you guys. It's big. It's big all over the place. Some of the major banks are just jumping in now on cryptocurrency. Okay. So cryptocurrency is the first one I want to talk about. Assets in crypto. What is cryptocurrency? There's Bitcoin, there's Ethereum, there's Shiba Inu that I have some of Shiba Inu right now. There's all kinds of secondary cryptocurrency that you can learn about. You don't have to be a scholar on it. Mary Jo says that it's December 3rd. Oh, good. My CME is December 2nd. I bet you I can do that. Anyway, Bitcoin. What do you need to know about crypto as a mediator? You just need to know some of the vocabulary, and you need to understand that whether it's in a business context or a family context, there can be large amounts of assets in digital assets. Okay. What do I mean by that? Well, if you're in a mediation and nobody brings up cryptocurrency, you might want to say to the lawyer, hey, do we have any alternative digital assets such as Bitcoin? Or they're like, what are you talking about? Because I don't know. I'm not even seeing it in discovery. I'm not even seeing cryptocurrency in discovery. You guys add it to your discovery for Pete's sake. Ask if there's digital assets out there. If you're a mediator, know the terms. Okay. So Bitcoin, let's just take Bitcoin for example. Bitcoin can be extremely valuable. It can go way up. When I bought my first Bitcoin, it was at 20,000. Last night it was like 59,000. Okay. It can be a lot of assets, but what you have to remember as a mediator is it's extremely volatile. You can lose 30% of your cryptocurrency in 1 or 2 days or in a week. So if you're dividing up cryptocurrency, my recommendation is that you move it into an account, you sell it off if you can, move it into account, or you pick a date and a time at which that valuation is going to be done. Like if you're doing a divorce today, you can say, we're going to use the crypto, say one of the major wallets that you can keep your crypto in is called Coinbase, Coinbase. Say, can I see your Coinbase, looking at stocks? Can you print it out for me in the mediation? Okay, yeah, okay, you see you've got all this Bitcoin and it's at 59. Tomorrow it might be at 63. So pick a date and a time that the value of that's going to be used. Or you can switch it into a bank account, which there usually has to be a bank account tied to something like Coinbase. You bring a bank account and you get the money in there and then you divide it up because of the volatility. It's not like a stock market where you can look at somebody's quarterly report and then, hey, where's your most recent report from your IRA? And by the way, there's crypto IRAs now. There's IRA retirement money by major holders that are in crypto now. So it's not just investments, it's also retirement. Keep that in mind. The second digital asset I want to talk about, because I am down to 6 minutes, is an NFT. Write it down if you don't know what it is. It's a non-fungible token, commonly referred to as an NFT. What is an NFT? An NFT are certificates of authenticity for digital artifacts. The easiest way for me to think about it is a painting, but it's online. And you buy it online. Okay, people are paying large amounts of money for NFTs, and you're going to see it more and more and more. So it's something you want to know. You can just say, do you have any non-fungible tokens? Lawyers, have you considered any non-fungible tokens? Have you discussed cryptocurrency? Do you have anything? Is there a Coinbase account, or is there another account that has to be divided up? And the number one trader right now, I looked last night, the number one trader of NFTs is a platform called OpenSea Marketplace. I haven't checked it out yet, but I'm going to, where things can be sold on there. So NFTs is, I mean, it's so cutting edge. I mean, Gary Vee is just talking about it right now. Anybody else know about non-fungible tokens? Put it in the chat if you do. So I've got 5 minutes left. The other thing I want to talk about is Venmo accounts. Does everybody know what Venmo is? VENMO. It's where you can pay someone, like I pay my yard man. He like sends me a request for money, and then I send him Venmo and it comes out of my account. You can see it if you're mediating something where there's money coming out on Venmo. You can see it coming out of the accounts. But what you often can't see, friend to friend, Eric says, exactly. What you can't see is some people, including my children, they get Venmo'd for money from their friends. They just $20 for lunch. They're constantly sending Venmos, money back and forth all the time. Blah, 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 blah. Okay, guess what, guys? There are people that never put their Venmo holdings into their bank account. So there's thousands and thousands of dollars in people's Venmo accounts. And the reason I'm bringing this up is you need to know about Venmo. You need to ask about it. Is there any money that you're holding? It's not the old question where is there any money between your mattresses? Are they holding money in escrow accounts? Are they holding money in Venmo accounts? And then, by the way, Venmo is just one of the peer-to-peer transfers that people are using. So I hope that I've helped you. I have 4 minutes left, so I'm going to switch to my close. And what I want to tell you is that if you had any friends that were not able to get on the CME and they've got to get their CME hours, I've got a few spots left on my December 2nd CME where I'll be going into some of this stuff more. Please refer your friends to Charlotte Fleming, FlemingMediation.com. And I'm going to read what they said. And you can always call my law office, the Fleming Law Firm in Springfield. Many small businesses are using the Cash App like Venmo. Yes, absolutely. So if you know anyone that needs CME, I'm just putting a baby plug in for my CME, which is on December 2nd. And it's from 8:30 to 3:30. If you know anyone that desperately needs CME and they've missed the one that the AOC puts out and they missed the one Andy's doing here, which is great. Andy, thanks again for inviting me. Don't be a text message with legs. Fight for the deal. Use empathy in your mediation and try to get the job done. The future of mediation in Tennessee is bright. It is growing. The sense of community is there. And I hope all of you will feel a sense of community with me. One of my main things is that we have a community of Tennessee mediators that we can call on to ask questions like we do with lawyers. And if I'm in the Memphis, Jackson, wherever you guys are from, I can call on you and we can have lunch and coffee and talk about the future of mediation. So Andy, I've got 2 minutes. Did I get any questions? I'm trying to watch the chat. Who's got a question for me?
I have not seen any questions come in, but we've got a couple minutes. So if you've got any, throw them out there.
Yeah. Andy, is there anything you want me to cover in these last couple of minutes?
I think you've covered a lot of great information. So I don't have anything. Let's see.
Okay. Hey, Mark, and all you guys, Mary Jo, that have been watching, tell me something really, really quick. I've only got 2 minutes. Would you please put in the chat something you learned today that you would call like an aha moment, like, well, crap, I hadn't thought of that before, or I need to look into that just for my training and for my teaching. Will you put something in the chat, you guys? I think there's 3 or 4 of you that are super active. Put in there something that you got out of today. Didn't know there were domestic abuse trained mediators. Okay, great, Eric. I hope you'll take my class or another class and become certified there. That's great. Somebody else, Mary Jo, what what did you guys take away from it? You like my article? Thank you so much. I don't know if they'll ask me to do another one, but I really had fun with that one because I was tired of being treated badly in mediations. Oh, cards, which thank lawyers for mediation and crypto too. Mark says, thank you so much. Yeah, get those cards going. They're $50 at a good printer, and you can make friends with the printer too. Realize I need to add crypto to my discovery. Bing, 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 bing. Yes, you guys are really getting it. Is there anything else? Any questions or any more comments? Let me make sure I've covered them all. I like your pivot suggestions, Jonathan. Thank you so much for that. Yes, pivoting is really important. You can clap your hands or make a difference, stand up, change the, if you got somebody that's falling apart, get them a cookie, get the window open, stand up. Hey, let's take a break. We got a couple minute break. Let's all stand up. If you do that and you pivot between the, those different phases, you'll be successful. I wish each of you the biggest success in your mediations. If I never come across you again, you're always welcome in any of my trainings. You're always welcome in Springfield. And please watch my daughter, shameless mom plug for all you guys. My daughter is Tally Bevis. She was crowned in Memphis. She will be representing the state of Tennessee at Miss America this year. You can follow her at Miss America TN, and I would love for you guys to cheer for her from all over the state. So I really appreciate that. Annie, my time is up. So I'm going to end on time. And thank you again, Andy, for having me.
Perfect. Thank you so much for stepping in last minute, getting this done for us. It was great. We have a 15-minute break coming up, so we will be back at 10:15, everybody. Thank y'all.
All right. Bye, guys. Take care.
All right, everybody, we will go ahead and get back started. Next up, we have Floyd Flippin, who is going to talk about ethical practices of mediation, especially online mediation. So Floyd, you have the ability to turn your video on, share your screen, anything you need to do. And I'll monitor the chat. So if anybody asks any questions, I'll let you know.
Okay, I'm showing Andy my video is on. Am I right?
Yes, it is.
Okay. Well, good morning to everyone. I appreciate Andy and West Tennessee Legal Services asking me to have this part. I've been saving this for this program. So Andy does not only put on seminars, he whips the tail of the presenter. We recently tried a case that I felt pretty confident about winning, and it was I took a beating. So Andy, you're multi-talented, and so is your staff. So I want to congratulate you on that win. As far as mediations go, they've been a blessing to me. I think all of us on this seminar have been in mediations. I remember when the pandemic started. I'm specifically going to talk about Zoom today and telephone and remote mediations, and I'll bring up some things about just in-person mediations. But many of y'all know I had Terry Kreider as a partner for many years, very good lawyer. She made a change to go to work for a great guy in Spence Barnes. She's done real well. She's just but I missed her, and she was doing a lot of litigation work for me. And so when she left, I had all of this mediation work, and I thought, well, I'll just stop doing the litigation part, and I did. And then the pandemic hit, and I thought, you darn fool. I thought I was done. I didn't know what in the heck I would do. I had all these mediations set up, but I knew they wouldn't be in person. And my assistant, Lauren Jones, came and said, hey, Floyd, there's this thing called Zoom. Don't give up hope. And I said, okay. And, the first mediations that we did, I used break rooms. I had telephones. I remember one time I had we were just trying to make things work, and like all of us were in the pandemic. But later I learned that there were many advantages to remote mediations, and we'll talk about that a little bit here. But I just want to get that out that I was like a lot of you all, never had used Zoom, had never even thought about it. But it has worked, and I'll talk about the benefits here in a minute. But let's go back and just talk about ethical considerations. I don't want to act like I'm a know-all, hit-all person. I will say that I've learned a lot since 2001 as a mediator, but I've really learned more in the last 2 or 3 years with all of these issues dealing with remote mediations and ethics and confidentiality. But let's start at Rule 31, Section 7, and it talks about 3 things that I want to talk about today. Section 7 of Rule 31 deals with confidential and inadmissible evidence, and I know you're familiar with it, but I want to focus on 3 things and then add a 4th. First is evidence of conduct. That's number 1. Information disclosed, that's number 2, and any statement made in the course of a Rule 31 mediation, that's number 3, is confidential to the extent agreed by the parties or provided by other law or rule of this state. It goes on to say such evidence shall be inadmissible to the same extent as conduct or statements under Rule 408 of the Rules of Evidence. Well, I want to go back to conduct. So hypothetical, and I'm asked this all the time. Let's be honest, there's some people, particularly in court-ordered mediations, that don't want to be there. Sometimes it's the lawyers. Floyd, I don't want to settle this case. Floyd, I want to try this case. In the medical negligence world that I mediate a lot in, the doctors have consent to settle forms. A doctor in most medical negligence cases can tell his insurance company, I don't want to settle this case. And some companies have a consent to settle, and maybe some of our legal malpractice policies are the same way. So in that case, the court has ordered a mediation. Either the doctor has said, I'm not going to consent, and he or she has a right to do that. Or in a non-consent case, the lawyer just says, I don't want to make any offer, Floyd. Then even in the voluntary mediations, you'll have one party say, I'll offer $1. You say, no, you never have had that, Floyd. Yeah, I have. So conduct of lawyers, and let's face it, some in mediation, some parties don't act the way we would like for them to act. I have lawyers say a demand to settle of a high number is not good faith. I have some plaintiffs say that an offer by a defendant is not good faith. In Florida, are you going to tell the judge in your mediation report that they did not act in good faith? No, I'm not. That's not my job. It says evidence of conduct. So the first question I've got to us, the group here, isn't that conduct? Do any of you mediators out there send a report in saying, I'm not saying you're wrong if you do, I'm kind of asking this. I've never done that. And have I seen conduct that I thought was less than desirable? Oh yeah, but it says evidence of conduct. I've always taken the position that if the parties appear, that's conduct. They came. I don't make reports to courts about whether somebody was a jerk or somebody was obstinate. If I did that, I guess as far as obstinate, I guess I do that every single mediation I have. But anyway, I want to throw that out there. I don't believe that we can do that. And if anybody else has done that, I won't fault you. But it specifically says conduct. Any questions about that? Any thoughts? Okay, Mary Jo, I can see that. Great. What if one of the parties refuses to attend? Okay, the mediator report says that the parties appeared. Yeah, if the parties don't appear, I don't conduct the mediation. So I just don't report the conduct. I just don't do the mediation. That's my response to that. And yes, Mary Jo, you're right. There's been instances where I've shown up and the lawyer says I'm handling it. And I said, no, we at least have to get your client by phone so I can have conferences with them. But that would be, so I don't conduct the mediation. I just leave. Anybody, that's a satisfactory answer? Any other thoughts on that? Well, let me just say this much, that, it's an issue now in court order mediations, sort of kind of more than the voluntary. Going back to a lot of the work I do is in the medical negligence world. I tell the doctor's lawyer, or I call them and say, look, if your doctor is not going to execute a consent to settle, there can't be an offer. So tell the lawyer for the plaintiff, in advance. Don't let me, I'll give you an example. Not long ago, again, we're talking about conduct, or as Mary Jo just asked, where the parties don't appear. I had the plaintiff and her lawyer drive it was in person, considerable distance, about 100 miles. And the defendant would not consent to settle, so therefore there can't be an offer. And but they had not communicated that to the plaintiff lawyer and the plaintiff, who had driven about 100 miles to the office. So when I went into the plaintiff's room after talking to the defendant, I'm the one that said, there's no offer. So if you know in advance that you're not going to make an offer, whether it's a consent to settle or not, or you know in advance that your client's not going to appear, let the mediator know, let the other lawyers know, because you cannot have a meaningful mediation in that situation. So that's my conduct part. Any other thoughts or questions about any of that? Okay, number 2. Now, information disclosed. I think all mediators have probably gotten close to making mistakes in that right there. Let me give you an example. I don't know whether I inherited this from my dad or not, but I've gotten to where I like to know where people are from and who they are. And my dad had a famous line, "Hi, I'm Jerry Flippin from Milan." If any of you older lawyers, but Dad probably said that to you. Well, what about the fact that I go to a mediation and I actually know one of the parties just through playing golf or high school or whatever? Of course, I'm going to disclose that. And so I'm assuming that everybody agreed I could hear it. And I see them at the mall, can I say, "It was good to see you the other day. Glad we got it worked out," and other people are around, say their spouses with them, their friends with them? No, I can't. I believe that, information being who was there, that there even was a mediation. I can't. I've actually reintroduced myself to many people that I mediated a case with. And so I would urge you to be careful, and particularly with parties. Now, the lawyers, that's different. But with the parties, you have to be really careful about that. That's a small thing, but I want to get to the bigger thing, which is information disclosed. How many of you all have been in a mediation and a surprise, something really shocking, information-wise, was disclosed to you? That's got to be everybody. For example, give you an example. In wrongful death cases, a lot of my mediations are wrongful death cases. Some lawyers don't know that wrongful death proceeds are distributed by the laws of intestate succession. Doesn't make any difference if they've got a will. And that just happened yesterday. Yesterday I was in Knoxville, and we got the case settled, and the plaintiff said, "Now, under the will," well, that's irrelevant. I said, "Whoa, I'm not giving legal advice," but I told the lawyer, I said, "Look, you need to look at the statute, but it's by intestate succession." Well, he hadn't talked or spoken with the intestate heirs. So that was information that was disclosed in the mediation, and we had reached a settlement. So could I go down there to the defense room and say, "Hey, the ones receiving this money don't even know they have a claim because the lawyer thought it went by a will"? Can I do that? No. So there was information disclosed, information learned that, and this was and I'm not faulting the lawyer. A lot of people think that it is by a will if the decedent had a will. But so I've had mediations in wrongful death cases where you had a stepchild, okay, that was raised by the decedent. That was about a month ago. And of course, I don't know who these people are. I'm introducing them as their daughter. but it was a stepdaughter. Is she entitled to any of the proceeds in a wrongful death case? Nope. So, and those may be trivial things to you all. Those are just two that came out, but information disclosed is extremely confidential. And let me say this much too. And I got a question for the group. How many of you all as mediators have had to really be careful in going to the next room and continuing to discuss the case, but leaving that out because you were told not to disclose it, of course, or you knew not to disclose it? I hope that the answer is a bunch of y'all have had that happen. I can tell you that if I was ever to write a book about my mediation practice, one of the chapters would be how a mediator can screw a case up. Thank goodness that, knock on wood, to my knowledge, I haven't done that, but it's difficult. You get information disclosed, in one room with one party and the lawyer. And most of the time, everybody knows with our discovery today, but there's some stuff that, man, you've got to be careful about. So I'm talking about ethical things. And once the horse is out of the barn or the cat's out of the bag, man, you are potentially have liability for that. You can really, you just need to be really careful about information that's disclosed, particularly if you're advised that it's confidential. And that goes back to everything that's told to you in a mediation is confidential. It doesn't have to be said as that. But I would just point out again, anything that you're told during a caucus, is confidential. And even if you think it's not, you have to get permission to go to the other side and say it. Back to information disclosed. Anybody want to share? You don't have to share the information, but just if you can generally describe an experience that you've had where you had to be really careful and almost made a mistake. Well, let me say this much. Just be leery of disclosing anything to the other side except a number, and get permission each side. What I normally do in a mediation is advise before I leave the room. I advise the others what I'm going to talk about and get permission, of course, to talk about it. But I will tell you that there are definitely mediations where you end the day and you're driving home and you're thinking, wow, that poor lawyer on the other side does not know what's about to hit them, or the lawyer I've just left thought that he had something worked out and he doesn't. I'm going back to the law of intestate case I had, which was, by the way, not long ago. In fact, it was yesterday. So, just understand information disclosed is confidential. Okay. Statement made in the course of Rule 31 mediation is confidential to the extent agreed by the parties. Well, I neglected to say this. Please have an agreement to mediate signed at the beginning of the mediation before you ever do anything. Get the parties to have that signed. And in the world that we all live in now, if you're in the personal injury world, you have a claims person. By the pandemic, they're not being able to travel, at least in my experience. So they're available by phone. So be sure that they sign the agreement to mediate, the confidentiality agreement. Let me give you an example about this statement made in the course of a Rule 31 mediation is confidential. Okay, so I'm in a mediation. I am advised by the plaintiff. They needed to prove that the nurse had information about the patient. The patient was in the hospital room. Their family member was a caregiver or a sitting there with them. And the patient advised the caregiver of a problem they were having, and that was disputed. The nurse indicated that she had not been told that. And so it was a he said, she said. And then at the mediation, the family member was upset that that was a challenged point, and kind of got upset about it and said, look, I can prove that that's what was said because of this. I sent we suspended the mediation to take a limited, I can't read that, Jonathan, you said something. Andy, am I still going on?
Yeah, so let's see. Jonathan said he observed a technique where you suggested confidential information be disclosed after preserving testimony in order to enhance settlement chances of settlement. And then we suspended the mediation to take a limited number of depositions, then disclose confidential information under the mediation privilege. And then the case settled when mediation resumed.
That's very good. Jonathan, that's thumbs up. Well, back to what I was saying. Thanks, Andy. Back to what I was saying is, so the family member who was in the room said, well, by golly, I can prove that. You know, I sent a text to my daughter confirming what was said to me. You know, I thought, well, I've got the, you know, the lady in the red dress, I've got the smoking gun. And I said, well, can I go down there and tell that to the defendant? Oh, absolutely, you can. So I went down there and told them that. And unbeknownst to me, I guess even to the lady, she had forgotten, they'd already gotten her cell phone records and her text records, and it was not there. So mediation unsuccessful, case not resolved. And the defense lawyer said, I'm going to cross-examine her at trial about the text messages not showing what she just told you she did. Can he do that? I'm ready for an answer. Somebody send in, can he do that? Andy, I'll put you on the spot. Can he do that?
See, I was going to wait to see. Oh, we got a few answers.
All right.
We got
Michael
I
Hill.
think he can, and I don't think so.
Well, it sounds like a lawyer, doesn't it? We're riding the fence. Eric, nope. Okay, I don't know. Nope. Who says you can? Somebody said, yeah, you can. All right, not. Andy, you going to read these comments out, or can I guess everybody can see them?
Yeah, everybody should be able to see them.
Okay. Well, I'm not a Supreme Court justice, but we're going to let Justice Andy Cole. Andy, can you do it?
I'll give the attorney answer. I'm not sure.
Well, I absolutely told him I didn't think he could. I mean, let's think about it. The statement was made in the mediation. It was made in anger. Well, by golly, they're lying to you, Floyd, and I can prove it. And I said, how can you prove it? Well, I sent a text message to my daughter telling her that, you know, so forth and so on. And I mean, I don't think you can. I mean, isn't that a statement made in the course of a Rule 31 mediation? Now, let's put our lawyer hats on. If I'm right and you can't use that, what can you do as a lawyer after that mediation on that point? What can you do? Anybody? I didn't tell him what to do. He told me what he was going to do. And what did he tell me he was going to do when I told him he couldn't use that statement? There you go, Jonathan. That's right. I think that's all he can do. Jonathan said, depose the declarant and see what they will say. That's right. That's the only thing I knew that he could do, was to depose her and, see if now, what if she said, no, I did not text my daughter. What can he do? Or I didn't text anyone. I told the nurse, hey, while you were out in the hall, all right, Jonathan says you're stuck. Anybody else? I mean, I'm sitting there, I absolutely heard it. She was mad or no, you know what, and wanted me to go down there just as mad as she was and just stick that in their face and say, but I don't think they can do it. And if she's deposed, by that time, now, by the way, I didn't go back and tell, well, I set you up for this. Let me ask you this. Could I go back and tell the plaintiff lawyer that the defense lawyer had already gotten, well, he knew they'd gotten the cell phone records and the text message wasn't there. Could I go back and do that? I tell you, Jonathan, you're on it. That's right. So did I get, not unless I had permission from the defense lawyer. That's right. And did I get permission from the defense lawyer? Yes, I did. So I went back in there just as mad as she was and he was. And I'm sure when I left the plaintiff's room, I am sure that that plaintiff said, you must be mistaken because they got your records, but the answer all about this is anything that's told to me or you as a mediator, no. If it's information disclosed, I think they're out. Other information is disclosed in a mediation. Just in the last month, sometimes, rarely, but sometimes the amount of insurance coverage is disclosed, even though we know that that is prohibited under our rules of evidence. So therefore, once they get to trial, if the case doesn't settle, are they able to use that information about the policy limit in front of a jury or judge? No, you can't. The other information, I wrote down some notes here of other examples that I've had. And you need to have information disclosed. You just don't need to be a number. Anybody can put a pair of roller skates on and say 100,000, 10,000, 80,000, 20. I mean, anybody can do that. That's, to be honest with you, I try not to ever do that. At some point in every mediation, if you're a civil mediator, you do just get to that, but you need to talk about the issues. And in order to talk about the issues, you've got to have freedom. And freedom means that you're stuck with not being able to prove, what was said in a mediation. You may think, well, that isn't right, Floyd. That lady's not telling the truth about the cell phone thing. But if you were to be able to use the information, we would never be successful really in getting cases resolved. So just be leery of that. Be wary that just anything that's said is locked down. This past week, we had a mediation, or last week, in medical bills. Medical bills, Blue Cross Blue Shield, Medicare, any of your insurance companies in these personal injury cases have subrogation rights. And so, a settlement, if you're paying a settlement, you're a defendant and you're settling the case, it's always, or 99 times out of 100, the defendant wants to be indemnified and held harmless for the medical bills. In other words, you're paying a settlement. Out of those settlement funds, the plaintiff lawyer and his client must resolve the liens. And so there's an indemnity and hold harmless provision in almost every civil mediation. And we had that about 2 weeks ago, a pretty substantial case. And of course, we haven't talked about preparing a post-mediation settlement agreement. We're going to get to that, but I had done one. Everybody had signed off on it. And just Monday of this week, one of the lawyers said they didn't agree to that. Well, the lawyer and his client had actually signed the post-mediation settlement agreement, and it was checked that they would do that. So can I, the defense lawyer was calling me and saying the plaintiff lawyer says he's not going to do that, and he didn't agree to that. Can I pick up the phone and call the plaintiff lawyer and say, have a conversation with them about that? Can I do that? Anybody? It was information disclosed that they would do that. Well, I'll make it simple. The answer is yes, I can. And yes, I did. Now, once he and I have that conversation based upon a signed agreement, can I be compelled to go to court? Of course, the answer is no. Am I out at that point for any future involvement in that issue? Of course. But even things like that are disclosed in a mediation that they will do that. You put it in an agreement, and there you go. I've never been subpoenaed. I know there are many of you mediators out there that have. I'm fortunate that I haven't been. I can't respond to a subpoena. I mean, I can respond to simply say I can't testify. I'm not aware of a single judge making a mediator testify. Are any of y'all aware of any mediator, you or any other mediator, that's ever been compelled to testify about matters disclosed and so forth and so on in a mediation? Okay. Well, the statute says no Rule 31 mediator may be compelled to testify by deposition or otherwise regarding conduct, information, or statements. So that's, again, that's the protection that we have. Those are just general mediation topics I wanted to talk about. Now I want to switch over for the minutes that we have left, about another half of the time I've got, to talk about remote mediations and confidentiality. And the point I want to show in this is that just confidentiality, period. So let's just go to in-person first. If we're in person, you've got your agreement to mediate. Everybody that's in that session with you signs the agreement to mediate. What do you do if you're on the defense side and your claims person, now you're in person with everybody, but your claims person is in another state or in another office? They're not with you, but they're available by either Zoom or phone. What do you do as far as their agreement to confidentiality? Do you just disregard it because they're not there? I can make that answer easy. No. What do you do? Well, what I do is I have their lawyer send the agreement to mediate, send it to them, have them sign it, scan it back, fax it back. I have them sign. Sometimes, rarely, but it does happen where they're not available. They don't have fax. They're not able to scan. What do you do then? What have I done? I hope I'm right. Do you let it go? Nope. I get them on the phone and I say, Susan, can I have Michael sign your name with permission? And they always say yes. Now, how good is that? Well, I know it's better than nothing. I've always preferred that they sign it, but I don't know now. I'd love to hear from you all any other options or alternatives that you've used when you have one party, and I'm talking about, usually it's a claims rep. They can't attend. That's what I've done. Anybody got a better idea or another idea? Okay, well, don't just let it go. Do not. I think that it's our obligation as the mediator to make sure that everyone involved in an in-person, we're going to go to remote in just a second, signs the agreement to mediate, the confidentiality agreement. They must sign that. Now let's go to Zoom and telephone. So I think I started this thing out by saying I thought I was done when the pandemic started. I thought what a fool I'd been to reinvent my law office. But Zoom has been a blessing. Currently, my experience is still about half of my mediations are by Zoom. Actually, I think that people have found that it's very convenient. What they tell me is that the plaintiffs tell me that their clients are still concerned about the virus, so they're able to stay home and not come into an office. I'm told by the plaintiffs that when the clients don't have a computer or Zoom capability, that they do come in, but they only come into their office. And while they're in their office, the lawyer's able to do multiple things while I'm in the other conference with the defendants. Of course, the insurance world, switching over to the defense side, the insurance claims world, they love it. Many of these adjusters that I deal with, the one yesterday was in New York. We were in Knoxville. The one Monday is in Brentwood and will be in Chattanooga. So they don't have to travel. They save the travel cost. So I believe that the Zoom mediations are here to stay. I don't believe that if we ever get past this virus pandemic, that they'll go away. And I don't have the litigation practice that many of you do, but I suspect that you'll be taking Zoom depositions in some cases for here on out. I believe a creature was born that's not going to go away, and it's convenient. Certainly for many people, it's less expensive because there's no travel. And then finally, it allows lawyers, plaintiff lawyers and defense lawyers both, to do other things in the office while I'm with the other group. But break rooms, let me talk to you about break rooms for a minute. And I'm talking about Zoom. You've also got Teams. There's other virtual platforms. I've been real hesitant to use break rooms. Many of you use them, and that's fine. I'm not saying I'm right and you're wrong, but I don't use them. Early on, the Zoom platform had security issues with break rooms. That was reported. You can Google it. I believe that they have fixed that now, but I'm never comfortable with that. I'm always afraid they'll be able to hear what I'm saying to the other group, and so I just got cold feet about it. And so now what I do is I send a private separate Zoom link to the plaintiff, and then a private separate Zoom link invite to each defendant. Most of my mediations are multiple defendants, and so everybody has a separate link. If during the mediation it's necessary for one room to want to talk to the other, it's extremely easy to create a separate link, invite, kick it out, then you're joining everybody. So again, that's it. Now, the problem with the Zoom mediations, let's just get straight to it, is I've got a little bitty screen. I don't know who's in the room. I don't know if the door in the conference room is open in the law office that I'm talking to, and there's people going up and down the hall. The camera doesn't always have everybody that's in the room. So how I resolve that, let me say this much, and I've sent you a paragraph that Fred Collins uses, which is outstanding, and I'll be honest with you, I didn't use it. Andy, and I hope, did they get that paragraph that I sent?
If it was in that PDF that Lauren sent me, it was uploaded into a Dropbox and sent out to everybody.
Okay, great. Well, let me talk to you about, of course, Fred Collins, Milan, Tennessee, an outstanding mediator, lawyer. Fred's, one of the, if not the earliest in this area to get into mediations. And so I appreciate, he's very thorough, very professional, and he has a paragraph I hope you got. If you didn't get the paragraph, let me know about it. Just email me at flippin@flippinlawpc.com, and I'll send it to you. But I appreciate Michael Hill, Fred's partner, sharing this with me. It's awesome. But I have everybody sign the agreement to mediate. Again, I scan it to them. They scan it back. I ask the lawyers, look, everybody involved in this needs to sign this agreement to mediate. And there doesn't need to be anybody else in your room. If there is somebody else that comes in and hears information, they need to sign the agreement as well. But am I nervous about it? Yeah, a little bit, because again, I can't see the people. But I would just encourage you, my way of practice is to, again, you ask the lawyers, look, I'm seeing you and your client. Is there anyone else in the room? Anyone else going to be participating today? No. Okay, well, you two sign this and send it back to me. Anybody else got a better idea on that? Okay, let's see, Mary Jo. Yeah, you know what? Everybody can see me. I hope can see everybody's. Yeah, they can. I agree, Mary Jo. You're talking about the benefits in a family law, certainly, and that may be different than these civil mediations I've got, but I doubt it. In person is absolutely better. I don't disagree with that at all. Third party interference, yeah, absolutely. Wow. Okay, that's interesting. I didn't know that. But in these mediations that I'm in, I don't request Zoom. I'm requested to do it by Zoom. And of course, it takes everybody to agree to that. If there's one dissenter, then they have to work all that out. I always take the position, it's not my mediation. I'm just a mediator. It's the parties. But I agree 100% that in person's better. Jonathan, how do you manage a belligerent participant? Yeah. Well, in person, you can handle a belligerent person better. Some of y'all know I officiate football and basketball. Well, do you think that we deal with people that are belligerent? The answer is yes. there's when I'm in person with the belligerent person, our football boss is a guy named Bobby King. Bobby's the mayor of Henderson. He is a former U.S. Marshal, and he taught us as officials an interesting thing. Floyd, the louder somebody gets to you, the softer you respond. That's easy to say and hard to do. And Floyd, furthermore, when you're in person with somebody that's belligerent, put your arms behind your back and clasp your hands together. Because once you start pointing, which is me sometimes, or you start raising your voice, it's over. So I would say, I don't know if that answers your question, Jonathan. How do you manage a belligerent participant? I kind of go back to what Bobby King told me. They're raising so much cane. I understand. They don't like that, but it has a calming effect. And I try to put my arms behind my back and clasp my hands, thinking about Bobby King and the U.S. Marshal Service. And it does seem to help. But on Zoom, that's harder to do. Hopefully the lawyer, of course, the lawyer sometimes can be the belligerent one. But you just try to, and that does happen. Yes, it does. And then you get into good faith and all that stuff. But those are the two things that I've done. Softer response, the louder they get, a coach on the sideline, the louder they get in my face, the softer I respond. And generally that helps. Now, at some point, you just have to turn and walk away. By the way, with your arms behind your back and your hands clasped, okay? But back to the confidentiality on Zoom mediations or telephone. It's an issue. It's a concerning issue because you don't always know who has access to your voice, who has access to the information. At the end of the day, I don't know if y'all agree with this or not. I hope you do. It's just something that's worked for me. Isn't it on us as lawyers? I mean, you've got to control your client. You've got to advise me as the mediator who's in the room. You're ethically obligated as a lawyer to do these things. And so, that's been my case. We all know lawyers, yes, we do, that, are more difficult to deal with than others. You have to take that into account. There's a couple of lawyers that come to mind with me, and I try hard to just softer response. But it's up to the lawyers. It's up to you to handle your client in a mediation. I'm not as a mediator. We're not as mediators. We're not the police. We're not. We don't have control over your client. Certainly, we don't need to respond. I can tell you that right now. We don't need to get belligerent. We don't need to, to join in that fracas. But that's kind of how I do that. What about, in addition to Zoom, what about telephone? Are any of y'all using the telephone for mediations? It may be anybody doing that? Not seeing anybody respond to that one. Well, believe it or not, I am. We have situations where, Monday. Okay, Monday's a perfect example. The claims attorney for the mediation Monday called me yesterday on my way home and said, Floyd, my mother is coming into town from New Jersey, and she's only going to be here through Thanksgiving. And she has never been to, and named all these places in Nashville. And so I've got to maximize my time with my mom. And so can we just do the defense side? I've already talked to the lawyer, and she said it was okay. So can you just conference call us for each round so that I can be mobile with my mom, visiting the various places around Nashville that she's not been? What about that? What would you say if you were the mediator? Now, I'm going to be with the plaintiff. I'm going to be with the plaintiff and her lawyer. But the defense lawyer and the defense claims rep and the defendant will be available by phone too. What about that? Anybody had that happen? Well, it goes back to, again, is it my mediation? No. So I said to them yesterday, contact the other lawyer, make sure they're good with that. And if all of you all are good with that, I'm fine with that. And I haven't heard back. I'm assuming today I'll get a thumbs up that that's okay. But now we're talking about confidentiality. So what about on an iPhone? You know, on an iPhone, I think it's 32 people. By the way, when I got started with this pandemic mediations, I found out, I think I'm right, that you can add 32 people to an iPhone. What about that? Do any of y'all, you know, if you put an iPhone on speaker, it's pretty loud. Anybody in the room? So do you advise, what do you do to guarantee that you've got no one else listening on the telephone? Okay. What I do is I say, look, you may have to use a speakerphone, but I need to know anybody that's on this call signs the agreement to mediate. And are you in jeopardy somewhat? Because, you know, cell phones can, some of y'all, I'm sure, heard other people's calls, or the calls get mixed. Certainly if they're on speaker, you know, other people can hear it. So again, Fred's paragraph, back to Fred Collins' paragraph, is awesome. If y'all don't have it, it says this: the confidentiality provisions apply not only to in-person mediation sessions, but also to mediations conducted remotely by Zoom or other remote platforms or by telephone. So I would encourage you in your agreement to mediate, if you're doing anything other than in person, to add this paragraph that Fred has put in his agreement to mediate. It points out one more thing that I never thought about, and that is the remote session cannot be recorded. You may say, you darn fool, why did you not think of that? I didn't. When I saw that last sentence that Fred put in his agreement to mediate, I thought, I have never told people not to record the Zoom mediation. It's not anything I ever thought about. And boy, I sure have now. And so I would strongly encourage you, if you have a remote mediation, to add this paragraph to your agreement to mediate. Eric has suggested earbuds. That's great. With an attached mic. Yes, that's fantastic. Again, some of the people that you're going to be dealing with, though, don't have that. But I think this paragraph is kind of the a really good catch-all that we all need to add. And so any other issues with, I looked at my notes, we've talked about, finally, the post-mediation settlement agreement. Oh my goodness, let me just get this out for what it's worth. So 3, 4, 5 years ago, not naming names, my law school classmate is a big time mediator arbitrator in another city, not in West Tennessee. And I had a case in his grand division of our state, and it was kind of down his alley. And so we mediated the case. I got the other lawyer to agree to him. We mediated the case. We signed the agreement to mediate, and about 6 o'clock at night, we agreed. We reached an agreement. I can still remember like it was yesterday. I said, okay, well, we need to get this post-mediation settlement agreement signed. The party against us was from another state. We, of course, were here in West Tennessee. And he said what is true for all of us. For it at 6 o'clock, my staff has gone home. I will do it in the morning and email it out to y'all. Now, at the time, this was probably 5 years ago, I didn't see, he was, first of all, great guy, great mediator. All of his staff was gone. He wasn't very proficient at typing something up himself. So we just, the next morning, when his staff got to the office, he put together a post-mediation settlement agreement. He emailed it back and to all of us, and it was right. And so I printed it off. I signed it. I had my client sign it. I scanned it back to him, and the other party would not sign it. Would not sign it. Said that wasn't the agreement. His lawyer said it was the agreement. And I can assure you without any doubt at all, it was the agreement. What had happened was he made a bad deal and he had buyer's remorse after he went home and slept on it. And he just changed his mind. So you can throw everything I've said out the window. Please have a post-mediation settlement agreement signed there at the mediation session. So, Mary Jo, it's much easier to, absolutely. Let me just tell you what I do. I came up with a form that I carry with me to every mediation. Now, if it finishes in time, obviously I've got, I can print it out myself, but if it's after hours, I carry with me, as Mary Jo has said here, you can carry with you the needed documents and you can fill in the blanks. But let me tell you this much, that case, did that guy get out from under the agreement that was reached that day with my friend whose staff had gone? Did he get out from under that, or could I compel him to that agreement? How many, somebody say yes or no? Could I compel him to do it? The big answer is no, that's right. He got out of it. Now, my friend was embarrassed, and I don't hold it against him. Who would have thought that, not to be judgmental, but the guy that got out of it had a three-piece suit on, lived in a, was a very wealthy fellow. He was a member of Augusta National Golf Club. That ought to tell you what kind of money he had. And he got out from under it. So just remember, please, 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 never leave a mediation. Never, 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 never. Without having a signed agreement, even if it's on toilet paper, even if it's on a yellow legal pad, just get the son of a gun signed, because you don't have anything if you don't. And I've had the experience of losing out. We actually had to pay more money than the agreement that we reached. So I know my time's about up, Andy, so I probably talked too long. Any questions, any comments?
I don't see any questions in the chat. Oh, there's one from Eric. Anyone have issues with parties texting non-parties for input or advice during mediation?
I never know they do that. Andy, I don't know. I'm sure they do that. Well, I have enjoyed the day. Andy, I appreciate you asking me to be a part of this, and I'm seeing all the people that are on here. Hey, I'm just a small cog in this thing. There's some great mediators, all of you out there. I hope some of this helps you, and a thumbs up again to Fred Collins for this paragraph about remote mediations. I would strongly encourage you to add that to your agreement to mediate. All right.
Thank you
Thanks a
so
lot.
Thanks, Floyd, for doing this. We will go ahead and move right on into our next session. So I'm going to go ahead and give Pam and Jonathan the ability to present. It might take just a second. But Floyd, you are good to go.
All right. Thank you all.
Thanks, Floyd. All right, Pam and Jonathan, y'all should have the ability to share your screen, turn your camera on, all that fun stuff. So everybody, next up, we have Pam Wright and Jonathan Steen, and they will be talking about mediating end-of-life decisions. So y'all are good to go.
Great. Thank you, Andy, and thank you, Floyd. That was a really good presentation. Got a lot out of that. So we're going to start talking about mediation in end-of-life decisions, and primarily I'm focusing on conservatorships. Jonathan's going to help me keep this relevant for those situations where mediation is going to be an option. And we're going to talk about resources. There's a handout that Andy has for y'all that lists some resources, and I want to go over a few in detail. For example, in Tennessee, in Davidson County, we have an Office of Conservatorship Management. Now, the office is just for Davidson County, but they have included a lot of materials that are written for statewide application. And one of the great things about it is, I mean, practitioners can look at it, but it's intended to educate the general public. Some of it is very specific to Davidson County, but what's general is great information. There is expected to be some proposed legislation that's going to come forward this session to require newly appointed conservators to sit through the conservatorship school that's on the office's website. This is the page. And have some kind of certification process. Now, I don't know how that's going to be enforced. I don't know what the time frame is on that, but it is the beginning of a discussion to make sure that when someone's appointed conservator, they understand the obligations and what a conservator is. Also, there's a Conservatorship Association of Tennessee. They have some helpful information on their website, but really it's just the association and being able to talk to the membership. They put on quarterly meetings with a speaker and an annual conference. So want you to be aware of that. The American Bar Association has some great materials from their Commission on Law and Aging. They are a very prolific part of the American Bar Association and put out a lot of publications that can be useful. One of them is one of the resources that we'll talk about later today. And then we're also I'm going to speak a little bit about the concept of supportive decision-making. And I want to get started on that because I think this is a developing policy and option for people who need help in managing life decisions. And it's not completely settled law. It's a fairly new idea, but it definitely gives a framework for mediators and the parties to work within, just to come up with some resolutions on specific points of contention. Tennessee now has a website dedicated to supportive decision making. And you can see at the bottom the sponsors of the website. I also want to point this out as a resource because
Hey, Pam.
yeah.
I don't think you're sharing your screen, so I don't think.
Oh, I'm so
participants-
sorry. I thought I was. Hold on, guys.
I just
I am-
realized you were referring to the slides.
I
and
am
one that
very
came up there.
sorry. Yes, we are there now. So real quick, here's the slide for the page of the Office of Conservatorship Management, their conservatorship school. They also have pages for frequently asked questions and some forms, and then there's videos that are basic training that tell people how to put together an accounting or file a property management plan, some of those kinds of things. And here's the web address for the Conservatorship Association of Tennessee. And they don't have information right now on their website. They just finished their conference, but that's where they post information about their quarterly meetings and annual conference too. And here's the website for the American Bar Association Commission on Law and Aging. And I may come back to some of these resources later to give you a little bit more about what you can find there. And I am going to talk about a tool that the Bar Association put together to help people craft decisions and settlements in this area. So here's the national website for supportive decision making. And this has a lot of resources. I mean, if you do a Google search for this, it's just everywhere. This has been bubbling up for really a long time. In all the states, there are advocacy groups working on this. Some of the states have adopted legislation around this concept. There's presentations on this page and on many others. There's a lot of information out there, but actually using it is going to be new in Tennessee because it's not been around that long. So here's the Tennessee page, and it's only recently been unveiled, and it has good resources. But I think the best resources on this page is that it gives information about different types of decision makers. Like it discusses what is the power of attorney, not just conservatorship. And then it discusses supported decision maker. And it discusses it in very plain language so that most people could find this pretty understandable. The Office for Conservatorship Management is a much more sophisticated website, and it uses more terms of art. I think it's a little harder for people to get through, but this has very simple and plain spoken language to make it a lot easier to use. And I want to come back to these in a little bit. Supported decision making. We're going to talk about this a little bit more, but I just want to point out that there are going to be situations where you absolutely cannot use supported decision making. And we'll talk about that. And the Conservatorship Association had occasion to come out with a policy statement, kind of a white paper about some of the issues that might arise to keep supported decision making from happening. So that's available on their website. So why do you even need to know about this? Well, one, it is a mechanism you can use in crafting a good agreement. And it's a mechanism that many families are interested in using to maximize the freedom and independence that someone will have, even if they have support and other people helping them with life decision making. Also, many of the individuals that need assistance in making life decisions may be receiving support services from federal or state resources. In Tennessee, that tends to be receiving care and supports through TennCare and through one of the TennCare waiver programs. TennCare has multiple waiver programs. The one that many people think of is TennCare Choices, which is for adults who are physically disabled or aged with an inability to do all of their activities of daily living. Typically, this would be a nursing home population, but TennCare Choices makes it possible for people to receive the services in other settings, including their home. So that's called a home and community-based program. That HCBS that you see right there stands for Home and Community-Based Services. There's another program, Choices Group 3, for SSI recipients that provides limited services in the home. And then there's the Choices Employment and Choices Waiver, ECF. That waiver is for people with intellectual or developmental disabilities. And all of that is home and community based. None of that is institutional. There's also the new Katie Beckett waiver, and then there's some other waiver programs that have been grandfathered into the TennCare program. So there's a lot of waiver programs in TennCare for home and community-based services. Federal rules require that you have to have supportive decision-making as part of the care plan or the supports plan in those waiver programs. So if you're working with a family, representing them or handling a mediation, and you anticipate that someone's going to be using a waiver program in Tennessee, or they're already in a waiver program, then that means somewhere in their plan documents, their care plan or their supportive decision-making plan, their supportive services plan, there is a supported decision-making agreement. And if you're crafting or looking toward doing a conservatorship, it would be really helpful for you to know, if that already exists, to accommodate that in whatever resolution there is of the case, if there is one that includes some kind of protection. And if you're anticipating this, then you just want to make sure that you leave room for supportive decision-making to go forward. Now, to give you an idea, here's the website for the TennCare, how they approach it. It's not necessarily the same everywhere, but that's what TennCare is looking at on these pages. And this is considered to preserve individual independence and dignity. That's why one of the protocols is called dignity of choice. Make sure that people have a formal way of protection to voice their own choices in regard to their health services and some financial services. So in 2018, a pretty comprehensive bill was introduced to codify supported decision-making. And that's actually what caused the Conservatorship Association to issue the white paper, because they wanted to comment on some provisions of the bill. And what happened is that almost all of the bill was stripped out. And the only thing that passed was a definition for least restrictive alternative. And that leads us right back to the conservatorship statute, because that's where we see that we have to have a finding as to what the least restrictive alternative is. And it also leaves room for people to incorporate some supportive decision-making or other alternatives to conservatorship that we'll talk about. So this has been a big policy debate. This language passed in 2018. It didn't really change much of the practice. I don't even know if most people are aware that that language was added. And policymakers are still working on it. But you know what? This is what really makes it relevant. All the policymakers and all the advocates have been slowly churning through this. But Britney Spears has made this front and center by asserting her own wish to leave the conservatorship and the Free Britney movement, we are now seeing a lot of discussions that just weren't in the mainstream before. When it was announced that Miss Spears would be free of the conservatorship, the judge ruled that the conservatorship was no longer required. Before that ruling, there had been a lot of speculation as to whether Britney would have to submit to a medical evaluation, and if that would be the basis or the hindrance of getting through, getting out of the conservatorship. Well, that's the way it used to be. That's what we used to have to do, is come up with medical evidence that would overcome the medical report that was the basis of conservatorship. But that's not what happened in Britney's case. There's in multiple news reports, we see reference to a quote safety net. So there was a proposal offered to the court. We don't know what that is. We may find out over time, but there's an accountant, there's a trust, there's probably more than one trust. We know these things from just a little bit of the press coverage. They put together some kind of plan that was considered appropriate and less restrictive. And that's what the court used to justify pulling back on the conservatorship. Says both on the financial and the personal side. So we know this case has captured so much attention, and we know we're going to see a lot of articles come out of it. This is worth following. It's not just the publicity of it and everybody loves Britney, but it's also technically going to be a very interesting case, and already is, because it's going to give people new ideas about entering into conservatorships, maintaining conservatorships, and exiting conservatorships. So.
Well, I think, Pam, that it also underscores how in making end-of-life decisions or healthcare decisions for folks, how a multitude of often unidentified and poorly understood factors complicate the decision-making. For example, in end-of-life decisions, you've got family dynamics, ever-changing healthcare teams, inconsistent opinions about prognosis, and even cultural differences between physicians, patients, and their families, which are just a few of the factors that can lead to conflict.
Right. Yes. And the thing about healthcare decision making is that we have a Tennessee laws that kind of govern that already. And I don't have a slide on that, but I do think that's in the materials. And that gives you, those are, again, more tools that you can use in crafting an agreement. I do want to point out that when you're talking about a conservatorship, incapacity is not the standard. And that was well illustrated in the Spears case. In Tennessee, there's a lot of findings that the court may have to make, but the absolute required findings that are general in conservatorships is that the court has to find by clear and convincing evidence that a person is under a disability and that assistance of the court is needed, and that what is ordered is the least restrictive alternative. So that's why I use the dimmer switch versus the flipping on and off, because it is intended to be a court-ordered action that can be scaled back to meet the individual's need or ramped up when needed. So in a medical situation, what starts out at the beginning where there may not be great medical need might change down the road. It's hard because you have to try to anticipate that, and it becomes very expensive if you have to go in and out of court. And that's one reason mediation can be a real gift in this area, because the people involved can sit down and really start anticipating they have the may already have the conflict, such as the ones that Jonathan just mentioned, or they may just know those conflicts are coming. And it gives them a great opportunity to work through that with having to go in and out of court with each change in circumstances.
And I would agree, Pam, that it's the balancing of the loss of individual rights with protections to vulnerable individuals. That's not an easy one, made more difficult because there's no one size fits all solution or one and done plan. I think the balancing is ongoing as the individual's needs and abilities to manage their own personal affairs change. And that's, I think, where there's a great opportunity for mediation. Because as you said, going into court, even to adjust agreed conservatorship can be very expensive.
Yeah, I mean, conservatorships are becoming more expensive as they try to be more protective. There's more work that has to be done. In many conservatorships, you're going to have the petitioner's attorney, you're going to have the guardian ad litem, you're going to have an attorney ad litem or an attorney that the respondent has hired. And just getting to hearing, you've already burned up thousands of dollars with that much work. And if there's conflict and full hearings and discovery, we're talking about an extremely expensive situation. And quite often, when these are filed, once the attorneys are able to set out their position for their clients, in my experience in the last few years, the attorneys almost immediately begin discussing some kind of informal range of settlement. You know, what would people be willing to work with, and what are the things within there? So I feel like a lot of you have probably maybe been through that if you do any conservatorship work. I have never done a formal mediation or been in a formal mediation for a conservatorship. Have you, Jonathan?
I have not, although the ones I have done almost universally, especially contested conservatorships, almost universally, even at a hearing, the chancellor or judge will say, look, okay, I've got the basics. Y'all need to go back and talk some more.
And I would love to hear from any of y'all if you have had a formal mediation. I'd kind of like to know more about that. I think when you go into the discussions, it's possible to come up with, some alternative protective arrangements. For example, Brittany has trust. Well, trust is a great tool. That's something that can be used. But if you know that there's going to be something in the court and you need the court supervision, maybe not so much now, but in the future, or maybe you need that intervention right now, keep in mind these general findings. That's something that needs to be established for the court. So whether that's established by agreement or not, if you can't get those four things, then, you've got some more work to get to the next level. I want to talk about sticking points a little bit. And that's another thing that I hope that the resources address pretty well. Okay, well, let's talk about money last, because that's it, guys. I mean, that's it. On the last page of the handout that you'll get, there's a reference on driving that I think would be helpful for people, because quite often a family is concerned about an individual's ability to drive, even though we don't think of that as an end of life decision. Health-wise, it is. I mean, it is a process as your life changes, and driving can be the big sticky wicket. I literally had a client who the family would get creative and take away the keys and do something mechanically under the hood. And this family lived within walking distance of downtown. And the husband, who didn't need to be driving, would just go downtown and buy another car. And he did it more than once. So they ended up with 3 disabled cars, and that's when they decided they need a conservatorship. So the drive, that right to drive, that ability to drive is really important, but it also drives people. The whole family has to be realistic about what it means. If somebody stops driving, then how are they going to get to their doctor appointments? How are they going to pick up medications? Are the medications going to be delivered? Who's going to do grocery shopping? You know, is the person just going to be stuck at home and virtually a prisoner? So that's quite often, I mean, like I say, it's not an end of life medical decision, but it is the kind of decision that can really drive people to what kind of care do we have to craft and support to make sure people can get where they need to be, get the services they need if they're not able to drive to those services. At the last page of the handout, there's a URL linking you to the materials on the Department of Safety website, Tennessee's Department of Safety. And it has the forms that are submitted if you want to report that someone is not medically able to drive and they need to be evaluated. With a doctor's statement, that kind of thing is there. And also there's the URL for the registration of the Department of Revenue, where titling and registration forms are kept for restricted licenses or other things like that. So that may be helpful. The third resource that I list for those of us in West Tennessee Healthcare has, as part of the rehabilitation services, a driving adaptation services. And this department can evaluate somebody for their ability to drive. You may have somebody who actually could drive if they had the right assistive technology, or maybe they just need more therapy and then the assistive technology. So we actually have that resource for somebody to be able to return to driving safely or to continue driving safely, having had a professional evaluation and assistance with getting whatever adaptive equipment they might need. I think that can be a terrific tool if you're looking at somebody who is younger and needs to be driving and has that ability to stay in there. It's an important thing to really maximize independence. End of life medical care, that is, I didn't list all the resources, and I may follow up with Andy to give you a few more. One of the things that's been developed, and you can find these with on a general search engine like Google, is medical care decision trees. Sometimes those can be helpful as you evaluate where somebody is in their end of life care. Just to get the terminology and the markers that the physician is looking for on certain things, it might help the mediator and also the people representing the parties know what the choices are, what are reasonable choices, what are unreasonable choices. This area has always been difficult because everyone has their own interpretation of the information they get from the health professional. Two different people can hear the health professional make a statement, and a statement of information. And one will hear that there's hope and there needs to be more therapy and care. And the other one will hear it's time for us to look at palliative care and no more interventions. And you can become more educated about the choices but that's just one of those things where people see things differently, and finding that common ground is a very difficult area. To be honest, I think it may have gotten worse because of our experience with the pandemic. People may not feel the same reliance and trust on the medical care that they want to. And you may find that it's important for you to maybe have more than one medical opinion. Maybe the parties need to work towards getting more than one person to give an opinion to try to give people more trust and security that they're getting the right information. Jonathan, you got anything to weigh in on that? That's a difficult one.
No, I think you hit it on the head, and I think I think in mediation, finding common ground is, I think, key to getting the discussion started. And I think most participants in a conflict involving end of life decisions have the best interest of the person with a disability at heart. So I think mediating these types of decisions is unique in the sense that there's kind of a built-in common ground to start from. But I think, as you said, what people hear are different. I think the different ways of assisting folks, either by substituted judgment, best interest, or some combination of those two mechanisms to assist, people come from different backgrounds. So I think that the complexity is only increasing, as you said, with the pandemic and people's experience of being homebound. I think a lot more people have experienced, death in the family. There's been so many deaths from the COVID pandemic that I think more people have experienced these issues, unfortunately.
Yeah, and it's also made an interesting twist for people like me that deal with a lot of nursing home placement. It's also changed people's attitude about that quite a bit too, because during the pandemic, we had the lockdowns where people couldn't visit their loved ones. I mean, that's just, we've never had anything like that before. People in a facility unable to have visitors, so people have been very creative in the last 2 years in trying to find alternative residential arrangements. And so I'm going to talk about residents a little bit, because that, of course, has to lead into the money conversation with the individuals who are talking about the arrangements. One of the things that the mediator can do, and the attorneys who are representing the parties, is make sure everybody has a realistic idea of the money. What money is available? How much does it cost to have certain type of services? Is there any public program available for those type of services? And if so, what are the rules about that? Is there a way to reduce costs by using family labor or using an informal support of some type? If that is a part of the arrangement, do there need to be agreements? Does there need to be formal employment agreements? If you're taking somebody out of their job and reducing their income, does there need to be a way to replace some of that income as that person steps into a support or caregiving role? The other thing is trying to explain, living in the South, we've never had a huge range of residential options. That was more developed in other parts of the country, but Southern states are getting in on it now a little bit. So in Tennessee, we have nursing homes. Everybody's familiar with nursing homes. And then we have assisted livings. I remember when those were a new thing, but everybody's familiar with those now. We have continuing care retirement centers. We don't really have one of those in Jackson, but they're in Memphis and Nashville, where you pay a deposit and then a monthly fee to live in a community, and the community will have within it a nursing home, assisted living, or independent apartments. And then that way, particularly with a married couple where one needs to live independently still, but the other one needs to be in a nursing home, they're on the same campus and involved in the same community. So that's an option in some places. Been a lot of litigation about those. They're not very well regulated in Tennessee, and the contract is a very important thing because that's all you got. So then we also have senior living, like Jackson Meadows and Jackson is senior living, but they don't, the living component doesn't provide services. You contract for those separately, and they may have an affiliation with a group that they, have on site, but it's set, each person does their own mix of services or not services, and they control it. It's not something that comes from the apartment complex. And then you have TennCare has created, they're not licensed. These are not healthcare licensed homes. They're not regulated in the same way as nursing homes and assisted livings, but they are certified through the Department of Intellectual and Developmental Disabilities. And these are small adult homes that will have up to 4 people in a residence. And we have a number of those all throughout West Tennessee. And the individual that lives there pays the rent, and then TennCare pays for the support staff or the whatever waiver program it is. We have mental health group homes that operate the same way throughout West Tennessee, where an individual pays the rent with their own check, and then the Department of Mental Health or TennCare pays for support services that are given within the home. There's also a license for home for the aging, but you just don't see much of that in Tennessee anymore. They may try to create some new options, but those are the options that we have now. As I said, TennCare Choices will pay for services to come into the home. So someone can continue to live in their home or in a senior apartment or another kind of apartment if they want to. Some places like in McKenzie or here in Jackson at Brookdale you can start in an apartment and then move into assisted living, but be in the same area and know the same people. So there are some arrangements like that in a few places. And then TennCare can bring in services. TennCare does not bring in services for 24/7 care. And if you're talking about somebody needing 24/7 care, you're talking about, by that I mean 24 hours a day, 7 days a week, you're talking about at least $10,000 a month in expenditure, at least. Most people don't realize that. I mean, if they put pen to paper and figured out, something not much higher than minimum wage, it would be easy for them to see, but most people just don't think about it. The other thing you run into with family members is they're like, well, mom can stay with us. And they don't realize that mom cannot be by themselves. So she's going to fall if you're not there with her, because she doesn't realize that she can't get out of the chair safely. And when you go run to the grocery store, she's going to think, I need to go to the restroom. And she's going to try to get out of that chair. And when you come back, she's going to be on the floor, or even more serious medical issues that require constant monitoring. So when you talk about residents, you're also talking about the set of medical services. And then it brings in the money. So that really, those 3 things right there are the gist of what we see in most of these conflicts. Those are the 3 things. The one thing, now Jonathan mentioned that what's unusual about these is that everyone at the table is worried about the well-being of the family member that they love or the individual that they're seeking to help. Occasionally that's not true. But the nice thing about conservatorship is that people have to pretend that it's true quite often. So it's very easy for the person who is leading discussions of settlement or the mediator to say now, well, the one thing we want is the best possible care we can arrange, right? And everybody has to give a buy-in on that. Or the one thing we want is for, you know, dad to have an opportunity to see family, and or for dad to have an opportunity to still go putter in the yard and keep his garden, or whatever, you know, is that would make this life more enjoyable. That's where you start getting your common ground. And even though you know some of the parties there are there to protect a perceived inheritance, you can steer them toward the reality that as long as an individual is alive, the assets are theirs and should be spent for their benefit. Now, I have not practiced in all the courts in West Tennessee. I tend to practice in my geographic area, but every court I've ever been to, let me tell you, the judges feel that very strongly.
I've heard it described that they're not going to attach a U-Haul to the hearse headed to the cemetery.
Right. Yes. And I've never seen one. I've never been in front of one that didn't feel that way. So even if your client doesn't buy in on that, you can tell them that's what the judge is going to look at. And so that's the approach that you take. So the money, residents, end of life care, and those supports that are needed, that's really what we're working on in the agreement. That's the bulk of it. Speaking of money, I might need to veer off into another topic, government benefits. The first thing that I want to say is that when you're talking to individuals about government benefits, you want to find out if the individual that needs assistance has ever served in the military, or if their spouse has served in the military. They may not be aware. They may assume that they're not eligible for benefits. They may not be aware of what benefits are out there. The benefits have changed over the years. They're different for different conflicts. I strongly recommend that you have the parties find out about that before you sit down and figure out what can be done. It makes a big difference. Some of the VA benefits are hugely valuable. And I know this from professional work, and I know it personally because my brother is taking advantage of some of those benefits. He's a veteran, and some of the things are things you wouldn't even think about. He was able to get access to some experimental treatments that were hugely valuable that no insurer or Medicare would cover at the time, but the VA was testing them and was anxious for people to use it. And it made a big difference for him. So I'm always like, please don't go too far without checking on this. And it's easy to do because the state of Tennessee has a wonderful Department of Veteran Affairs. This is a state department, and their mission is to get benefits and access to services for veterans. That's their mission. It's not their mission to deter people from using services. So this is an unusual government agency. And working in conjunction with the department are veteran services offices in just about every county where a veteran is employed to also find out what benefits and what services are available for other veterans. It's very easy. It's a free service. You can call, talk to your VSO, your Veteran Service Officer, and make sure you find out about those benefits. The biggest source of public payment in assisted living in Tennessee is Veterans Improved Pension, which is commonly called aid and attendance. So it's a big factor in long-term care services. Aid and attendance is also available to pay for care in the home, not just assisted living. But it's important to know that aid and attendance has a transfer of assets penalty, just like TennCare or Medicaid does. VA looks back 3 years, Medicaid or TennCare looks back 5 years for any inappropriate transfers. So you also want to get that information out to find out if that's going to be an issue. Now, I won't go in, nobody wants to hear all about TennCare. I do want to point out, though, that a lot of older people are going to have Medicare, and some of your younger people who have been disabled, drawing disability benefits for at least 2 years, are going to have Medicare. There's different types of Medicare. There's traditional, and then a lot of people go into Medicare Advantage plans. And when you see Joe Namath and Joe Montana, whoever, touting Medicare giving you more $100 each month, or that kind of thing, they're talking about Medicare Advantage plans that are zero premium plans. They're very popular. Think about it. People don't want to pay the premium, and some of the plans will cover the Part B premium, so they get money back in their check, just like you hear on the advertisements. Those of you a certain age are not watching the channels that have those advertisements, and lucky you. So what you need to know, the other thing, the information that needs to come to the table, is what kind of Medicare does a person have? Because if they have a no premium plan, you've got to look at the coverage, because their hospital coverage might be only for 3 days. Under traditional Medicare, the hospital coverage can be for, an indefinite period. Your coverage for skilled benefits in a nursing home, where you're getting rehabilitation for that broken hip, can be up to 100 days. Now, there's cost sharing that goes in, but for some of the Medicare Advantage plans, the coverage is only 2 weeks or 3 days or something like that. So you've got to find that out. And the families are not going to know this. They don't have a clue. So make sure your clients, and as a mediator, that is information you get ahead of time, because some of the Medicare plans, these Advantage plans, will advertise that they pay for services in the home, and some of them do, but it's like 2 weeks worth or something. So you don't want people come in with unrealistic ideas that all of this is going to be paid for by Medicare, and that just doesn't happen. Medicare does not pay for long-term care. It does pay for hospice services. TennCare will pay for hospice services, but that is not the same as supports or custodial service, which would be the sitter who comes in. Medicare does not pay for that unless you get a limited benefit under a Medicare Advantage plan. People are not aware of that. So if somebody goes into the nursing home, their immediate care is their first set of cares is going to be paid for by Medicare to some extent, whether it's just observation and assessment, or if there's rehabilitation going on, physical therapy, speech therapy, something like that, or if there's skilled nursing like treatment for a bed sore, that kind of thing. So that's going to start off, but it's a time limited, and it's limited based on the type of Medicare you have. And anything after that is going to be private pay, or workers' comp, whatever type of insurance, long-term care insurance, or TennCare. So, or veteran benefit. But veterans benefits are generally not enough to pay for nursing home long-term care. But some veterans have access to some other options. So the other thing you need to know is that it doesn't matter what your settlement agreement says, what you mediate, doesn't matter what your judge orders, state laws have absolutely no sway over representative payee selection. That's determined by federal law. I think most of y'all already know that. But if somebody needs to have money handled for them and they receive a Social Security check, railroad retirement, veterans benefits, if they were a federal employee that's retired, there are ways to have a representative payee or fiduciary named to manage that money, but that's all done through the federal agency. It's not handled through conservatorship. It's not handled through settlement or mediation. I think most everybody knows that.
Although the person to be a rep payee or to the extent that it is flexible can be part of the negotiated agreement.
Yes. I mean, and you could say, well, let's have this person apply to be that. We can agree that this person will apply to be that, and that we feel confident with that. And that will usually go through. And if the person's been appointed or agrees to serve as a conservator or limited conservator or whatever, usually that's, that sways the Social Security selection or in any of these other agencies. But keep in mind that if there's still conflict and there's conflict reported to the federal agency, sometimes that makes the situation worse, because what the federal agency will do is freeze the check. So no money's coming in. So it's good to address this. Just know that it requires some extra steps by making the appropriate applications with the federal agency that you're dealing with. So the other thing is, if you're dealing with veterans benefits, you do have to notice the VA. If you're doing in terms of a conservatorship, and if there is a conservatorship, there are some notice provisions for VA. If the individual who has a conservator receives VA income, the VA wants to know about that. And if you just go to the VA website, it has pretty clear instructions about that. There's also the use of authorized representatives by federal agencies. I just mention that because if somebody needs to get information or needs to help manage care that is paid for by TennCare, they have to have a signed form that says they're an authorized representative. So that's another tool that you'll want to use if that's part of your agreement. But you also need to know that there's a formal form that has to be completed and submitted to TennCare. And that can be part of what you're working, your plan that you're working. Medicare has, most people don't use this, but Medicare has a provision for an authorized representative, and all of the Medicare Advantage and supplement plans have that as well. Most people for these type of benefits often just create an online account, kind of like they do with Social Security, and monitor it through an online account, which you can certainly make an agreement to do. But just know that these formal forms are out there and may need to be completed for somebody to be taking care of this appropriately. And also, you want to be aware, if the worst case happens and things go south, you want to know that there are emergency actions that can be taken. And these may be the kind of actions that have driven somebody into court and created the need for mediation. But we think of the emergency conservator, but there's also a limited healthcare fiduciary. Typically, I see this filed by the healthcare provider, say the hospital. And then they'll just ask for a short-term fiduciary appointment to make some healthcare decisions. But that's also a great time for people to come together and make a plan for end-of-life decision-making. Don't often see people put into adult protective custody by the state adult protective services. Involuntary commitment, we all understand that. There is, for people who have a need, active need for behavioral health services and who have been in the hospital or in case management, there is a declaration, the site to that's in your materials, where they can appoint they can authorize a substitute decision maker for a period of up to 3 years. You don't see that used very much, but it is used if people take advantage of the peer support services. That can be part of a care plan. It might be something that you want to look at. It's just another tool that you can use to fashion an agreement. So, any questions?
I've noticed I was watching the chat and I haven't seen anyone say that they've mediated contested conservatorship or anything along these lines. From this morning, we heard Charlotte Fleming talk about having substantive knowledge in the area you're mediating. And I think it's particularly important in mediating end-of-life decision conflicts because a lot of times folks just don't know. Even represented parties don't know about all these tools and services. And so I think it's very important to learn about those as a mediator. Although you're not representing a party, you're trying to get the deal done, as Charlotte Fleming said. And I think even Floyd in his good presentation pointed out how substantive knowledge is important, where he had folks who weren't aware of how wrongful death proceeds are distributed. And I think it was Floyd who pointed out, or maybe Miss Fleming as well, how asking important questions is a central role of the mediator, and raising your game as a good mediator, asking the right questions. And so while having these tools for long-term care planning and dealing with conflict in making end-of-life decisions isn't necessarily a mediator's role as far as advising, I think knowing these things and then asking questions, like Pam has talked about. Have you considered VA benefits? Are there VA benefits available? Have you considered other insurance availability? Have you considered compensating a family caregiver who's going to be staying at home and giving up work? These are types of things that I think are crucial for mediators who mediate these types of conflicts to have the background, or at least the toolbox available to assist in getting the parties to an agreement that ends up being in the best interest of the person with a disability. Pam, I put this question to you. I didn't see anyone who's reported that they've mediated these types of cases. What do you see are barriers to mediating end-of-life decision conflicts?
Well, the hardest thing is that often the actors, the people that are actively involved are the people who are trying to help or get their way. And the person who needs the assistance doesn't have the capability to advocate for themselves effectively, or they may not have a full appreciation of what their personal needs are. So in that case, it's great if they're represented, but that's expensive. A lot of times the person who serves as guardian ad litem will end up kind of trying to balance that and make sure that the individual's preferences and core wishes and beliefs are assumed are central to the decision making. But it's a challenge for everybody, and even the judge, and they all acknowledge this, because you're trying to run somebody else's life, and most people are reluctant to remove rights. We all prefer for it to be done in a supportive and agreed way. That's why mediation is so valuable, but it's also very challenging when you're trying to do it for another person who may not be able to fully convey or understand what's ahead for them. Money's the other barrier, though. I mean, it's just sometimes trying to make people understand that what they want to happen costs money that they don't have. So they have to be more realistic and maybe shrink their desires down to what's affordable or what's available in their part of the country or in their county, because not all services are available everywhere. And I didn't go into, y'all are legally trained, about powers of attorney, and about trust, and those things that are tools that can be used to avoid conservatorship or to help with managing the ins and outs of the care decisions. I would like to point out, and this is in your materials, there are professional geriatric care managers, and some of them are called life care. Some are trained for older people. Some are trained for young adults with lifelong disabilities. And they can come in and do an assessment. They can evaluate what the needs are that are unmet and what resources are in the geographic area, what can be purchased, what assisted technology might help. That can be a great investment to get a real professional assessment. And it also comes from a neutral person who can bring to the table not just recommendations, but also maybe some new ideas for resources and care that people wouldn't otherwise be aware of.
And I think that's a particularly helpful suggestion because a lot of times the sticking point, either for a conservator or for some representative capacity, is who that representative is. Some family members want a particular person, and other family members don't. And so if you have someone who has a background and skill in evaluating the situation, evaluating proposed either limited conservators or representatives, that can go a long way in having a neutral person making a recommendation as to who that representative or conservator should be.
Well, if there's no questions, I think we're done.
Great. Thank you all so much for doing this. We are now going to move into our 30-minute lunch break. So we'll see everybody back at 12:45. Thanks, Pam. Thanks, Jonathan.
Thanks.
Thank you. Thanks, everybody.
All right, everybody, it is 12:45, so we will go ahead and get back started. Next up, we have Pam Sheridan from the Nashville Conflict Resolution Center, and she is going to talk to us about unconscious bias in mediation. Pam and Robin, y'all should have the ability to share your screen, turn your video on, unmute yourself, all those things. If you do not, let me know.
Is the screen showing? This is Robin.
I'm unmuted now. I see a screen with pink mountains. Is that your screen?
Okay, let me change which one is showing then.
Okay.
Sorry.
Sorry about this, everyone.
It happens. It is perfectly fine.
Well, this was a last minute realization on my part that I didn't have the capacity to see my speaker notes without everybody seeing my speaker notes because I don't have a second screen. So Robin has beautifully jumped in here and she's going to help me out. Okay, we're getting there. I'm seeing it. And Robin, you can make that large presentation size. Perfect. Okay, so everybody, my name is Pam Sheridan and behind the scenes is Robin Wheeler. Robin heads up the family program at the Nashville Conflict Resolution Center. I want to thank you all for being here today and giving up this this pretty Friday afternoon to sit inside on the Zoom, which I think we've all done a whole lot of for the past couple of years. But I am with the Nashville Conflict Resolution Center. We are based in Nashville and we've been around for, gosh, going on 22 years, I believe. Our mission says that we help people in conflict. It's our mission to empower individuals and families to resolve and move beyond conflict through mediation. For the past 20 years, NCRC has partnered with courts, schools, and other organizations to provide free mediation services that are private and confidential, allowing successful participants to avoid eviction, further court or police involvement, loss of employment, school discipline, etc. We use a restorative approach to conflict resolution that draws both on ADR best practices and research regarding compassionate trauma-informed care. So that's who we are. So what does that mean? We are a mediation nonprofit. We hardly ever charge for our services. We have referrals from our partners like Metro Schools, different county school systems, juvenile court in Nashville, the JJC parenting court, where we mediate parenting plans for never married couples who share a child. We work with General Sessions Court to mediate off the docket 4 days a week. And we work with the Metro District Attorney's Office to mediate disputes between neighbors and coworkers and things that just really don't rise to the level of prosecution. So we have a lot of irons in the fire. We have, I would say, 3 or 4 dedicated staff mediators, and we have a slew of volunteers who help us do all this really good work. Like many of you, over the past year and a half, we have switched to video mediating. And it is, I know you're going to talk about this topic later, it is certainly where the industry is headed. It's probably where NCRC will stay for at least the foreseeable future. And we have seen a lot of advantages to it and some disadvantages, of course, but by and large, it's working pretty well for us and we've figured out how to do it. But it has meant that we aren't mediating as much, certainly not in person, because it can be a little cumbersome and not all of our volunteers have embraced the technology. So we're changing the way we do things. One of the things we have decided to do in the interim and kind of the break until we sort of figure out what the next steps are for offering mediations in person is to educate. And we run monthly lunch and learns, similar to what you're doing today, but these last an hour. Some of you may have attended, and if not, I hope you will check out our website and think about attending. They are free. They are always 1 hour of CME, and sometimes we are able to get CLE also free. So a great opportunity to earn some credit and learn a few things. I think we do our best to present interesting topics that kind of cover all the bases, family and ethics and general mediation, so that you can keep on top of your CME. So that's who we are. Let's go to the next slide, Robin. And the implicit bias, that's the topic that's bringing us here today. What is it? Bias has been getting a lot of talk these days in the media, and it has definitely a negative connotation. But bias is a pretty simple concept. Go ahead, Robin. Attitudes and stereotypes that affect our unconscious actions and decisions. I'm sorry, that affect our understanding, actions, and decisions in an unconscious manner. Let's go to the next one. Oops, that went too far. So bias is an evaluation or a belief. And nothing in this stated definition implies that bias is good or bad. It simply is. It's part of the human condition. So let's go to that next slide. Many of you have probably seen this before. 3 colors. We've got red, yellow, and blue. I have a mild preference for blue. I dislike the color yellow, and I am neutral towards red. Those are my biases towards these colors, and most would agree that my preference for blue over red or yellow don't make me a bad person. And I probably did nothing to consciously control these preferences myself. So when we say that our psychological process is implicit or unconscious, we are simply referring to something operating outside our conscious awareness. Go ahead, Robin. So biases are evaluations and beliefs. Go ahead. They can be positive or negative, and they can exist without our knowledge. They may be hidden, and they are not necessarily bad. So why are we talking about them? I mean, is this just no big deal? Everybody's got them. They're not good or bad. We can't help them. Why should we even bother talking about them? Because, go ahead. Because implicit evaluations can be based on inaccurate information or stereotypes of people, objects, and ideas. Next. Implicit biases can impact our decisions, our perceptions, and our behaviors. They really influence what we do and say. And implicit biases make it harder for us to live up to our values of equity and fairness, which as mediators, that's where we live. That's the whole core of mediation. Finally, biased decisions create barriers to equity and opportunity. If we are operating in a system of biases, which we are, then some people are going to have it easier finding a job, getting an education than others. And so we need to understand how biases play a role in these decisions and what we can do to mitigate the effects of the natural biases that we all possess. Next slide, Robin. So the power of the brain. The brain is amazing. I don't have to tell you all that. 11 million, next slide, pieces of information are processed per second in our brain. And I can't even wrap my brain around that thought. It just blows me away. 40 to 60 of those pieces of information per second are perceived consciously. And I don't know about you, but I'm sitting in my sunroom and I'm looking at, out the window and I see some leaves falling and I can smell, I'm using my senses, I can smell what's cooking on the stove. But boy, I can't get to 40 or 60 pieces of information that I'm processing per second. I think that even sounds really high, but obviously all of our senses are in action right now, perceiving things. The brain is able to sort and categorize all of this other information without even thinking. It just happens. It's literally like breathing. So as a result, up to 95% of our brain's efforts are in the subconscious and unconscious mind. So next slide. The unconscious mind. Your mind is a meaning-making machine. It is constantly trying to understand what's happening around it. It doesn't listen to data. It's not analyzing spreadsheets. It is simply observing things, making assumptions and mental notes, and it works with story and imagery and metaphor. It is trying to interpret what's happening around us into a story that we can make sense of. It relies on associations to make meaning out of confusing information. So this is a little exercise, and you can read this out loud to yourself. I'm sure you're all on mute. But this is an example of how your brain fills in gaps and makes meaning out of even error, even erroneous information. If you can read this paragraph, it's because our minds are very good at putting together pieces of information in a way that is easy for us to make sense of. Our minds do this automatically without conscious control. So what this exercise demonstrates is the automatic, adaptive, and associative nature of implicit processing. When faced with otherwise ambiguous or confusing content, our brains try to quickly make sense of it by relying on associations that we've stored in our memory. Importantly, these stored associations don't have to be based on accurate or logical information. By just seeing concepts grouped together repeatedly, we can internalize associations that are skewed, distorted, and inaccurate. Let's go to the next slide, Robin. So how do our brains do this? So in the exercise that we just did, where we read the paragraph, we were able to mentally correct the errors to come up with a sentence in our brain that made sense. Despite many errors, 16 out of 37 words in that paragraph were misspelled. We still got to the meaning of the sentence. And we have stored enough associations in our memories to make sense out of this inaccurate information. We've seen those words before. We've seen them used probably in similar order before. So we simply filled in the gaps and made perfect sense out of it, really, with no trouble. So the next slide. So priming is the mechanism by which we do this. It's a phenomena where exposure to one stimulus influences how a person responds to a subsequent related stimulus. These stimuli are often conceptually related words or images. So in the exercise, we were able to just fill in those holes because those words were related. We'd seen them before. We have been primed to solve that mental puzzle. So let's review implicit bias. Implicit biases are the attitudes or stereotypes that affect our understanding, actions, and decisions in an unconscious manner. Implicit biases are informed by stereotypes. And next, implicit biases are those things that cause a disconnect between our intentions and values and our actions. So to review, stereotypes are commonly held beliefs. It is important to understand how stereotypes come to be, and we'll look more closely at that in a moment. Implicit bias is how those stereotypes affect the way that we actually think or act. For example, we know that stereotypes are not true, but sometimes those common ideas seep down into our own actions. And so this leads us into how implicit biases form. So this next slide, Robin gave us a preview here. The word is executive. Several years ago, and don't go yet, Robin. We want to go slowly with this one. Several years ago, when we first developed this presentation, we decided to Google the word executive to see what Google is telling us we should expect to see in an executive, what an executive looks like. Go ahead, Robin, hit the first one. So there we go. Let's hit one more. Okay, let's have another executive. And let's get a fourth executive in here. So I'm seeing a lot of white men about the same age, about the same, they look a lot the same. They're dressed alike. They seem to be, there seems to be a code. You've got to wear a navy or a gray blazer, maybe a tie. A phone is cool. And these don't look like a lot of executives that I know. But a couple of years ago, Google thought this was what an executive should look like. So let's advance to the next slide and let's try this little game with the homemaker. And anybody who wants to can like play with this and Google it and see what's happening these days. I'd like to think that it's changed quite a bit. But let's look at the first slide of a homemaker. There is a mother, maybe with children and some lettuce, feeding them. Ooh, there's a good one for Thanksgiving. Somebody's really proud of that double oven and the turkey and the pies. Next one, let's see what we got. Oh, more kitchen action. And the final one, another woman at the stove. So again, we've got women, we've got white women, we've got women who look like they live in pretty nice houses. So there's some just stereotypes there, honestly. So how Google has played into this stereotype and it's reinforcing it. If we were to Google these images, this is what would turn up. These are the things that program our brains to associate certain images with certain words. So what happens when let's hold on a second. What happens when executives and homemakers are represented by popular culture in the media and the news? This is what we get. And so we are programmed from a very early age to decide that this is what these people look like. We are grouping words with images. And when we group concepts together based on stereotypes, sometimes they can get it wrong. Next slide, Robin. So a concept frequently grouped, Blacks and poverty. It is a fact that in 2015, Black families made up 25% of the American population living in poverty. And in the media, there was a study done and it actually looked at images in media, magazines, newspapers, and on television. And as it turns out, the images depict, when the story was about poverty and the authors of the stories decided to put an image with it, 59% of the time they chose an image of Black families in poverty. Next slide. So 17% of the images or depictions of poverty featured white families, even though they comprised over 60% of the poor population. So, in your head, you're saying, you're hearing a story about poverty and you're thinking, what does that look like? And most of the time, the media would tell you that that looks like a Black family. Let's move on to the next one. Associations can be helpful. Next slide. Let's just fill in the blank here. Night and day. Next one. Black and white, right? Next one, ladies and gentlemen. So those are great and predictable things that naturally go together. Let's keep going. Let's go through this one. We've got peanut butter and jelly. Sure. Next one. Sun and moon. Sure. Speaking of, did y'all see the lunar eclipse last night? It was at 3 a.m. and it was pretty astonishing. Okay, I digress. Next one, bread. Butter, sure, makes a lot of sense. Next one, doctor. I think I know where this is going. Bread. Well, that doesn't make any sense. Did it take you a second to think about what bread is? That's because your mind was already working about things related to doctors. Bread in our mind is not closely associated with doctor. Let's go to the next one. Doctor again, and there we go. That makes more sense. That feels better. It's right. Okay, let's try this one for fun. Don't advance yet, Robin. So felon, just get an image in your mind of what you think a felon might look like. And let's press that slide and see what we get. We get Martha Stewart, who is a felon, and LL Cool J, who is not a felon. But we have been programmed by stereotypes that, through the media, through movies, through culture, to associate the word felon with somebody who looks more like LL Cool J than Martha Stewart. And we've made assumptions, and assumptions, well, you know what they say about assumptions. Let's go on to the next slide. Assumptions, next slide. Priming helps us make assumptions. So when we prime our brains to group certain things, it helps us make assumptions. Associations are flooded with biases. And then assumptions based off of our unconscious associations cause our implicit bias to take effect. So this is the process that our brain is going through. We've been groomed from a young age to see things certain ways. Our brain processes information. When we're shown something, we revert back to that very base way of processing information, and we come up with these assumptions. Let's go to the next slide. I really like this thought here. We absorb bias in the same way that we breathe in smog, involuntarily and usually without any awareness of it. It's as easy as breathing. It's unintentional. It's completely unnoticed. You aren't bad for having bias. You truly cannot help it. Next slide, please. So I'm assuming that you all are mostly, if not all, mediators and maybe some attorneys. And I think it's important that we think about how bias can affect a mediation. And I want to break apart the steps of the mediation and just talk about where our bias can creep in at any stage. So the first step is convening. So I don't know about how you all work, but our organization operates, we get a referral, and it's a piece of paper with some names on it and some addresses and phone numbers of both parties, and maybe a little bit about what we're going to do here. Parenting plan, neighbor dispute, something like that. And we don't really have much to go on. So when we're convening and I'm looking at that piece of paper, let's use my name for an example. If I'm going to be your client, one of your clients in a mediation, and you see Pam Sheridan, what does your head tell you about who Pam Sheridan might be, what kind of person she might be? Well, the first thing it's going to say is it's female, more than likely. My name is Pam, and those of you who are familiar with kind of popularity of names throughout the years would know that the name Pam was popular for a very, not even that popular, but somewhat popular for a very short time. Most women named Pam in this country were born roughly between maybe 1955 and 1970. People just aren't naming their daughters Pamela anymore. So you can probably assume that I'm a woman of a certain age, and I am. And so my last name is Sheridan. Now that could be a married name, but what does Sheridan say about this person? It says that maybe that's an Irish name, so potentially white, probably white, right? And even if that is my husband's last name, there's a pretty good chance that a Pam of a certain age is married to somebody of her same race. So so we've already got a little bias going. We've got an idea of what Pam is and what she might be. The next thing we might look at is her address. And if you are familiar with the town that she's from, you might know that street. You might know that zip code. You might even know that you might notice that there is or is not an apartment number, which might tell you something about my socioeconomic status. But you can gather quite a few things about me just from a couple of lines there. So the next step in the mediation is pre-mediation. So I don't know how you all work, but at NCRC, we typically in most of our programs, we are working in a conference room when we're in person at the courthouse, and we do not have a receptionist, and we do not have a place for people to come and comfortably fill out paperwork and all that kind of stuff. The mediator is typically the person greeting and welcoming the participants. And so we see them before they walk in the room for the mediation very often. So we see them walk in, and what are we concluding about them? What is our brain telling us? We're going to look at how they're dressed. We're going to look at their body language. We're going to see if they are comfortable, or if they're slouching, or if they are making eye contact. Did they shake my hand? What is their clothing saying about them? Are they well dressed? Are they clean? Are they wearing anything with logos that might betray preferences or interests or teams? Is their hair blue? Are they tattooed? Are they, just what can we deduce from that? And that's just all very natural, very automatic reactions. It doesn't make you a bad person for looking at that. It's just the way human beings work. So we are going to, in the pre-mediation stage, we are already our stereotypes are already chugging away in our brains and generating opinions and attitudes about these people that haven't even necessarily entered the mediation room yet. We can also see how they work with us. I don't know if you've ever had this experience, but lots of times the first person at the mediation likes to use that opportunity to chat up the mediator. And we discourage it, obviously, and we try to politely distance ourselves because that we don't want to know anything about the case until we go in the room. But they might try to work you a little bit, maybe, ask you if you watch the football game or if you're a Titans fan or whatever. And so those types of things, all, those attempts to build rapport, that all can become part of a bias that we might have about somebody. So let's go to the next slide here. So during the mediation, this is when a lot happens. And this is when you're evaluating as a mediator, as a human. If you're even the participants in the mediation, you're evaluating that other person. We are listening to their grammar. We're listening to their speech patterns. Are they angry? Are they interested? Are they bored? Are they helpful? And all of their actions are potentially reinforcing kind of those earlier opinions that we had been forming from the very beginning. So during the mediation, we are, our brain is working to kind of come up with a story and figure out maybe what is really going on here. And hopefully as mediators, we are not letting our bias interfere with the mediation itself. We want to make sure that we are, even though we have these biases, we want to make sure that we are equal, offering equal time to both parties, that we are treating both parties with same respect, and not favoring or favoring one or the other. But everybody has. It's very hard to go through mediation without feeling some emotion in either direction. I think most people recognize that's just part of being human, is to sympathize perhaps with the plaintiff or the defendant, or draw some conclusions about the conflict. But as we know, that's definitely not our role. So let's go to the next slide. Possible results. What are some of the things that can happen when we as mediators are biased in a mediation? We have to work hard to tamp our biases down, to hold them in check, because the results are very real. If we are biased towards one party or another, somebody might get more time to speak, or somebody might get maybe the brainstorming that we're doing with them tends to favor one party's interests more than the other. If we have an inclination to like or dislike one, there's an excellent chance we are going to have a hard time treating them fairly. So the results are very serious if we are not able to check our bias as mediators, and we aren't doing our duty as mediators if we have conducted mediation in a manner that is biased. It's a tough line to walk, and it's something that I think we all are striving to do better with. And we'll talk a little bit down the road about what we can do to mitigate some of those bias feelings that we have. I'm sure you all have, if you've mediated much, you've probably been in the room with somebody who was biased, either a co-mediator or a mediation that you might have sat in on. I've had that happen a couple of times. One time I had a volunteer who was mediating with me, and he'd been a long time volunteer and had a good reputation. And I kept feeling like he was really favoring one of the parties. And it was to the point where the other party turned to me almost as her ally and said, he's not letting me speak. He's letting her do all the talking. And I said, I promise you're going to have your chance. And I said, just, stay with us. And this continued, and it continued despite my best efforts to kind of rein him in. And after it was over, he revealed that he actually knew one of the individuals from 30 years ago, and he didn't think it was important to share with anybody. But I do think, looking at it, that it did color the way he treated both of those women in that mediation. And I also happen to disagree with his kind of glowing, the halo effect that he put on this woman that he knew 30 years ago and her position in the mediation. I thought not only was he biased, he was also not seeing it at all for what it was. And I guess I have to recognize that I may have, almost in defense of the other party, jumped to a biased position as well in effort to balance a little bit. But he is no longer mediating with us, and he wasn't very happy about it. But it was very obvious that he had that he didn't belong in that program. So anyway, that's bias in mediation. But there are examples of, well beyond mediation. Let's go to the next slide here. Bias in the real world. We know that bias happens all the time in the real world, and I think in the last 20 years we've done a lot of study on it. And how can we make things more equitable for people who have different backgrounds and who didn't come up the same way we did. So this next slide talks about this legal memo evaluation study. Subjective and ambitious situations can easily activate implicit associations. Oh, sorry, that's wrong wording there. So let's go to the next slide there. There was a study done, I believe, through the American Bar Association in 2014, and it was testing how the race of a writer might impact evaluation by a senior law partner. And so a memo was constructed, and it had 22 errors in it. 7 of them were spelling, minor spelling or grammar. 6 of them were substantive technical writing errors. And if, for those of you who are attorneys, you know that that's a big deal. My husband used to do a lot of contracts law, and I used to see him diagramming sentences because he knew that if you modified the wrong something, you could change the whole meaning of a contract. So technical writing errors are a problem, obviously. This memo had 5 errors in fact, and it had 4 errors in analysis. So let's click the next slide here. The reviewers participated in this writing study, and half were told that the memo was written by a Black male, and half were told that it was written by a white male. So what happened? The white male received a score of 4.1 out of 5. Next slide. And the Black male received a score of 3.2 out of 5. And next slide, to add insult to injury, when they marked up each of these memos, the reviewers who reviewed the Black male's submission, they found more errors in the writing. So of course they got lower scores. They found more errors, but there clearly was an effect of being a white male and either overlooking or not looking hard enough for the errors in these memos. The last slide there, it does give credit to the American Bar Association. So it's not just in the legal realm. We see this in other areas too. Let's look at the next slide. Orchestras. Seems like a person who can play an instrument well and better than the next guy should get the chair, but that is not the way it was done in orchestras and in symphonies for a long time. Back in the middle of the 1900s, 1950s, typically an orchestra was hand selected by the conductor, and he was going to choose people that he studied with, that he played with, that he's worked with, and it ended up overwhelmingly male. Let's take a look at the next slide there. So females were dramatically underrepresented in symphonies. Next slide. Matter of fact, in 1970, only 6% of the instrumentalists in symphonies and orchestras were female. In the late 1980s, though, blind auditions became the norm, and most American symphonies adopted them. So similar to that TV show where they turn around in the chairs and the stars try to help them, they set up a curtain. You couldn't see the person. And for at least the first round, it was strictly based on the person's ability to play their instrument. Let's go to the next slide. And so by 1993, after a couple of years of this, orchestras and symphonies were 21% female. And that doesn't seem like a huge jump, but from what I've read about this, orchestras don't have a whole lot of turnover. They tend to be jobs that people stay in for a long time. So with attrition and with new talent being brought in, getting to 21% was considered to be a pretty effective program. Let's take a look at the next slide though. So this program, this blind audition thing, increased the probability that a woman would advance from the preliminary rounds by 50%. And then the likelihood of a woman's ultimate selection was increased several-fold. So I was wondering let's go to the next slide, what the percentage is today. And it's getting up there. Currently it's at 33% female, and they're kind of still doing this blind audition thing. And I did notice that recently in the New York Times, in the past couple of years, there have been a couple editorials about the need for symphonies to actually get away from blind auditions and to intentionally select musicians for more diversity. So that is obviously a popular discussion across a lot of arenas. But the blind auditions certainly did allow merit to be one of the determining factors, at least early in the process. So let's look at the next slide here. Implications for hiring, nonverbal behavior, and race. So do interviewers who are interviewing Black people and white people, do they treat them differently? And this study, go ahead to the next slide, Robin, sought to determine whether there was any difference in the way people were treated. And so Interviewers were videotaped interviewing both white and Black job applicants. And they found that the interviewers smiled and spoke to the white applicants more frequently. And they hesitated more, and they made more speech errors when speaking to the Black applicants. And in the parentheses here, you can see the interviewee can often mirror that speech. Unconsciously, mirroring speech is a very human thing to do. And so they, in turn, made more speaking errors due to mirroring. They also noticed that white interviewers sat farther back and leaned away, and they gave shorter interviewers to the Black applicants. So that's just one example of, how it starts. Just the bias, the lack of just treating people differently based on race. This is interesting, particularly in the light of the decision that came down about 45 minutes ago in Kenosha, Wisconsin. And if y'all haven't caught on, I'm guessing you did. Rittenhouse was found not guilty on all counts. Implications for justice, race, and sentencing. And I'm going to just editorialize here and say, I can't imagine what would have happened if that young man had been brown or Black. But that's too much editorializing for me. So a study was done that involved violent felons in Detroit, and it found that, you can go ahead and put the next slide up, that both Black and white judges imposed harsher sentences on Black defendants than white ones. The next slide. And other studies have revealed that judges set bail 25% higher for Black defendants than similarly situated white defendants, and give sentences that were 12% longer for Blacks than comparable whites. Killers of white victims are more likely to be sentenced to death than killers of Black victims. And you don't have to watch too much TV news to know that this is probably hot topic number one in our criminal justice system right now. So it's with a heavy heart that we read this. And if you've spent any time, the whole bail bond issue is also loaded. The problems that bail creates, and the fact that bail is higher for Black individuals just creates an additional burden on somebody simply because of their race. And as they sit being accused, that's a different tangent, but that unconscious bias that is exhibited by judges has real world effects on people's families and incomes. Types of unconscious bias. Before we move into the what can we do about this phase, I want to talk about some examples of unconscious bias. There are probably as many ways to be unconsciously biased as there are people with thoughts in their head. But most organizations have kind of grouped them into 10 to 15 that sort of have some similarities, and pretty much any kind of bias would fall under one of these. So this is an incomplete list of types of unconscious bias. And a couple of them I want to talk about. Robin, you can go ahead and hit that next slide. So we've got affinity bias, confirmation bias, gender bias, ageism, beauty bias, height bias, authority bias, overconfidence, name, halo effect, horns effect, anchor bias, and nonverbal bias. And you can probably conclude what a lot of these are, but these are especially important when we're talking about employment and opportunities for people. And I guess to a lesser extent, maybe education as well. So affinity bias is a lot of times when we're hiring and when we're in organizations that are making hiring decisions, we tend to talk about the culture fit. And I think the culture fit is such an interesting concept right now, because as we've all gotten out of our in-person offices, and maybe some of us are back in them, I think it's very interesting to hear. I think it's very generational when people talk about culture. My husband works in an office, and he can't wait for everybody to come back because he feels that the culture is suffering. My son is 27, and he has never met the people he works with, and he probably never will meet the people he works with, and he is 100% fine with that. In his mind, it's a relationship where he works and they pay him, and he doesn't need anything beyond that. my husband's opinion with the culture that they've created in his office is that when people like each other and know each other, they want to work better as a team, and they want to do work, help each other out, and pitch in and have camaraderie. And that is very much his management style. And he really likes it that way. But I have to give a lot of credence to kind of this next generation's way of doing things. You know, my son is very committed to doing his job and doing his job well, and it is his job to support his coworkers. But he doesn't see, he feels that it's a very professional relationship, and it doesn't need the happy hours, and it doesn't need the lunches together, and it doesn't need the culture fits when we hire, because we're here to do a job. My first job out of college, I learned, was because I happened to have good musical taste. I was interviewing for this job, and the interview went well, and I had a good resume. I had good grades. I had a good experience. I had good internships. And as a wrap-up question, my potential boss asked me what kind of music I like to listen to. And I said, you know, lately I've been listening to a lot of U2. And he said, oh gosh, I love U2, my favorite band, just saw them in concert, this and that. And we talked about U2 for a few minutes. A couple of days later, I got the job. Days later, I got the job, and didn't think anything about it being, you know, having anything with music or U2. But later, over the next couple of years, as I worked for him, he very proudly told the story that he hired me because I had good musical taste. And for some reason, that didn't bother me. I, you know, forget my experience, forget my youthful enthusiasm and my good education. He hired me because I had good musical taste. I didn't care. I got the job. But he would also go on to use that question in subsequent interviews with other people. And he thought it was a great way to kind of get a glimpse into people's personalities. And I don't know if he only hired people who had musical taste that he agreed with. I don't know if he ever like heard a band that he didn't like and said, oh, they're not getting this job. I don't think so. He wasn't that kind of person. But looking back on it, I realized how really silly it was. It had absolutely nothing to do with my ability to do the job. It probably had a lot to do with the culture in the organization. And at the time, it didn't occur to me that it was even wrong. But I look at it now and I think, wow, that was a form of affinity bias. When you look for the similarities, when you try to find that connection with people who have similar tastes, interests, and backgrounds, that is an example of affinity bias. Some of the other ones that are, I think, kind of red flags for the workplace. I lumped beauty and height together, but I just think it's astonishing that that I think it's 58% of male CEOs at major companies are over 6 feet tall. And there was one study that indicated that a person who is 6 feet tall roughly earns $5,500 more a year than people who are 5.5 feet tall, which is just kind of amazing and silly to me, because unless you're in the NBA, it probably has nothing to do, height has nothing to do with your ability to do a job. But people tend to like attractive people. People tend to be biased. They see height as leadership. They see gray hair as wisdom in a man, maybe not in a woman, but we attribute these biases to people who may or may not be deserving of our of this glowing opinion that we have of them. So how do we get these biases? I'm kind of curious. I think about my upbringing, and we'll talk a little bit about the tests that can kind of identify your biases. But you know, I think when you think about back to that executive photo on the Google search, if you turned on pretty much any TV show, particularly in the 1970s, 60s, 70s, and 80s, the boss was always the man. If you watch Brady Bunch, who went off to work, who stayed at home with Alice to help her, it's no wonder that we had that my generation has these views that are very traditional and very white and very male dominated. I was thinking back to one of my favorite books as I was a child in 1968. I don't know if anybody remembers the Richard Scarry Busy Town books, but they were these just richly illustrated books with so much to look at. And I think there was one called What Do People Do All Day? And I loved it because it had these teeny tiny pictures of little animals doing things. And so the postman might be a pig, and the grocer might have been a cat. And it just really was, it just sparked my imagination. I love the fun illustrations, the cats, they were all so cute. It was all animals. But looking back on it now, I realized that they are all gendered. It's not, I mean, I'm not sure that I had a cat for 15 years before I figured out really that he was a male, but they gendered these animals by putting bow ties or neckties on them, or hair bows. If they were female cats, maybe their hair was a little more flowing for the female dog as the male dog. And so that's the early message. In 1968, I was getting messages that teachers were female cats, were females, and policemen were always policemen. And, basically the jobs that required strength and lifting were going to be men, and the jobs that were caring about people were going to be female. And this unconscious bias just kind of follows us. I want to talk about one more type of bias, because I think it's important to, the overconfidence bias that's listed in here. Overconfidence bias refers to a person's tendency to be more confident in their capabilities than they should be. And in the workplace, overconfidence bias may not lead to the kinds of hiring and recruiting issues that other biases cause, but it can lead to conflict within an organization, and it can cause a company to not live up to its potential. When overconfidence bias is allowed to flow freely, employees with this bias do not believe that they need to make improvements, thus affecting their own growth as well as the company's growth. And the way to avoid overconfidence bias is simply to continue to work on the affinity bias and hire a diverse team that doesn't fall into your group think. It will be more difficult for overconfidence to take over if you foster a diverse and challenging environment. Some of these other biases, the halo effect, where, oh, he went to Harvard, he must be smart, let's hire him. And everything he says in his job interview supports, you're looking for those things to prove that he is smart and capable. Horn's effect is the opposite. Oh, he went to whatever school that my team doesn't like, so I can't like him. Or he used to work at such and such a company and they have a terrible reputation. Really taking out of the equation the abilities that individuals might actually have. Ageism is another common one. I think studies show that after age 50, people don't feel like they are looked at as fairly for employment. And I also think the reverse of that is true. I went through I graduated from college when I was 21, and I did not want anybody to know that I was 21, because that just did not seem old enough to be doing real world things. And so I kind of fudged my age for a few years and added 3 or 4 years. And for some reason, I thought 27 was going to be like that magical age when people would respect that I had a little bit of experience and I'd be good at things. And oddly, 27 was the year where I spent most of it unemployed. But I kind of got so used to lying about my age that I actually forgot how old I really was for a while there. But those are the types of unconscious bias that can color our decision making when it comes to employment and to a lesser degree, in a different way, in schooling. This bias also permeates graduate programs extensively, because a lot of graduate programs, particularly, almost all of them, require a faculty sponsor, and faculty sponsors can choose to work or not work with somebody. And there's an interview process. So anytime there's an interview process, you're going to bump up against people. It's a natural reaction. People like people who are similar to them, and they want to be surrounded by people that they like. But I think we need to consider that a better work product, like in this overconfidence bias example, a better work product can come from hiring diverse individuals with different experiences and different ways of looking at things that can challenge our assumptions and make us better. So let's go to the next slide. What can we do? The good news is that the human brain is incredibly plastic. You've probably heard the term neuroplasticity, and it's open to modify, to change, and to adapt. We have to first accept that no human being is an exception. There are some programs, and I'll talk about Project Implicit through Harvard University, the implicit association tests, IATs. Those are important in helping us understand where our biases exist and helping us begin to check them. We also need to recognize that we can revert to bias when we are in moments of stress and conflict. So go ahead, click that. We can educate ourselves. We can confront our own implicit biases by taking the tests and reflecting on our results. And we need to know when biases are activated. So if you're in a mediation and it's extremely stressful and you're seeing some behavior from one of the parties that just elevates your blood pressure, and maybe your flight and fight reaction is going, or your sense of justice has been triggered here, that's when we revert to those old ways of thinking. And so knowing when they're activated, let's go ahead and press that next one. Mindfulness is a way to work through that. But I want to back up and talk about what we can do in educating ourselves. At the end of this presentation, and we are awfully close and we have a lot of time left, and I don't know if that's good or bad, but at the end of this presentation, I will have some resources for you, and I will put them in the chat so that you can click through to them. There is an organization called the Kirwan Institute, and they are based at Ohio State University. And they were formed with the funding of a woman named Marge Schott, who many of you might recall as the apparently very racist owner of the Cincinnati Reds many years ago. And part of Marge's public penance was to fund a research institute at Ohio State University to study things like bias. And so the Kirwan Institute was formed, and they have fantastic training modules. Matter of fact, we use them at NCRC when we are training new mediators. And they're very interactive, and they're very, very interesting, and they break it down just in ways that really challenge you. So it's educate yourself. Project Implicit, Harvard University started a similar organization to understand implicit bias and to make available resources to kind of check out your bias. And they developed these tests called the implicit attitude tests. I'm sorry, I've lost the A word, but the IATs, and they have IATs available on their website to take for free. You need to give them your email address, but they don't spam you. And each test takes 10 or 15 minutes. And if you've taken one of these tests before, you might even check back because they keep adding new tests. I think they're up at about 10 or 15 tests. You can look for your bias with anything from race to gender, to women in science, to LGBTQ, all kinds of things that you could potentially be biased against. And I love to take these tests. I think they're really interesting. I think that they are not the be all and end all. And there is a fair amount of criticism about what the IAT really means. I don't think it means that because I showed maybe a slight or even greater bias against somebody that I'm going to behave that way. I think a lot of people come away from these IATs thinking, oh my gosh, I'm a horrible person. And that's really not the message. All they're trying to do is measure your reaction to images, and delays in your reaction indicates that that you're having to think more, and that you're probably overriding an implicit bias. So it's really, some days you can have better reaction time, that you're not distracted, your fingers are feeling a little more agile, whatever. So, take them a time or two, and you'll probably find that you might get a different score. But I think that the general trends that the IATs can identify are valid and important. But a couple of years ago, I took the IAT in preparation for a training class that we were doing. And I have a friend who belongs to one of the groups. And I took the IAT to find out my bias for or against that group. And I was really proud of myself, because turns out I am really feel very, very, very favorably about this particular group. And I thought that just showed how enlightened I was, and I'm, no bias there. It actually was a bias. It was a bias in a different direction. But I told my friend, I said, I took that IAT for that group that you belong to. And I was really proud because I have apparently a preference for that group. And she said, well, that's great. I'm glad that, that you like me and us. But she said, we can be axe murderers too. And it's true. You have to kind of guard against the flip side of that, which is swinging too far and not thinking that group, is not without potential to not be what you think they are. So I thought that was kind of interesting. I also just from a personal note, I have found that IATs have changed my IATs have changed over time. And I think that is because the more you know, the better you do. And the more you know, and the more you practice, that neuroplasticity of that brain is going to kick in and move you down the spectrum. Probably one of my most frustrating IATs that I've taken is about the role of women in the workforce. And I shouldn't be surprised by this, because I was raised by a stay-at-home mom, a homemaker, and an executive father. I was born in 1965 when pretty much everybody around me was raised that way. I turned on the TV and watched the Brady Bunch, and I saw orange juice commercials with women pouring orange juice every morning for breakfast. And that was literally the way I was raised. I went on to become, after a short career before children, I went on to become a stay-at-home mother for 17 years. But I like to think that intellectually, I don't have a judgment about whether that's the way it should be. It was the way I wanted it to be for me, probably because it was the way I was raised and I liked it. But I by no means expect my daughter or my son's future wife to have that, have that in their family. But when I take that IAT, apparently I do. I seem to have a strong bias towards women being the ones to raise children, no matter what I do. And I consider myself a feminist, and I consider myself enlightened. And I've worked for really strong, smart women for most of the years that I've been working. But that is a pretty deeply ingrained one. So that's a little personal confession, but I would encourage you all to take some IATs and see where you come out, and be mindful of that. Consider the results. Don't dismiss it. Just recognize that it's not a condemnation of you if you aren't where you think you might be. So how do we get over these biased positions? How do we move past them? The first thing is to know when they're being activated. And if they are being activated in times of stress, mindfulness, breathing, recentering yourself, thinking through things, telling yourself, having that internal dialogue that, that just says, calm down, it's okay. Accept this person, listen to this person's words. Try to cleanse your mind of that judgment position. One of the best ways, though, is through intergroup contact. Like my friend who belonged to that group that I could have potentially been biased against. I have contact with people in that group, and it's favorable, and I like them. And that's probably exactly why I have such an affinity towards that group. And when it's hard to dislike people, and it's hard to think bad things about people when you know them. And I would encourage people to seek out opportunities and activities to be around people who are not like them for that very reason. Volunteering is just one of the best ways that I can think of to open your mind to intergroup contact and to expand, start to knock down those stereotypes and expand how you see different groups. When Nashville had its floods in 2010, so many of us pitched in and volunteered. And it was really beautiful to see people from all parts of town side by side pulling carpet out of houses. And there was a group that oversaw a lot of it called Hands on Nashville. And it's a fantastic volunteer group. And one of the things I love about Hands on Nashville is that anybody can join. You don't need any special training. You don't have to be anybody in particular. And everybody is equal on the job site. There is one staff person or a group of staff people overseeing, but all volunteers are equal. So you are literally working side by side with lawyers and delivery drivers and grocery store workers and stay-at-home moms and grandparents from all over town. And you can just see the common goals, and it's just a beautiful experience. And it's a great exposure. We often don't have opportunities to engage with people who aren't like us. It is pretty easy in Nashville, in Tennessee, to go through your day, and with the exception of some ancillary engagements, to be around people who are just like you. And those are the kinds of things that don't help your mind expand. That doesn't help your neuroplasticity. It doesn't help you to create and seek out new narratives about people that contradict those very ingrained, deeply held beliefs. So let's go to the next slide. This is the for more information section, and I'm going to copy this and put this in the chat here in a second. And I encourage you to check these resources out, and consider taking those tests and challenging yourself and thinking about things a little differently. And that is all I've got today. And that was an hour, which is not exactly what we planned. So I want to open it up for questions and invite you all to, we can stop sharing the screen, I guess. And we can turn on our cameras if you want. I'm going to put in the chat these resources right now. And I want to open it up to questions or defer back to Andy and do it any way he would like to handle this.
Pam, I apologize. Sorry. I have a question that's not in the chat that I just wanted to see if you could explain a little bit about what the Nashville Conflict Resolution Center does, what all types of cases you'll take and stuff like that, just while people are typing questions in and stuff like that.
Great, thank you. And Robin, I would love for Robin to chime in on this. Robin heads up the parenting group at NCRC. And so she is probably our busiest mediator, because that is the one program that has been blowing and going since the beginning of the pandemic. But NCRC, how many before pandemic, we probably did 500 parenting mediations a year, probably an additional 300 mediations on top of that. The bulk of our work is parenting plans for never married couples. And Robin oversees that program. We've got a couple of dedicated volunteers who help out, and a couple of staff folks too. And we work with the juvenile court in Nashville to get those referrals. Once the parenting plan is done, the parties go back, the plan goes to the judge. And from that, the judge will determine support. And that parenting plan will become, in effect, the parenting plan for that child. Other work that we do, in probably our next biggest number group, is in general sessions court. Until recently, until the past couple of months, most of that work was landlord-tenant issues, a lot of evictions. But Nashville developed a housing court, and so those cases have been steered towards the housing court. We are currently working in general sessions on a lot of debt cases. That's primarily what we're doing. And we have mediators who volunteer their time and go down in person 3 days a week, 4 days a week, for a couple hours in the morning and mediate off the docket. We also have a very well-developed juvenile victim offender mediation program. We have a VOCA grant, and we are pretty well staffed up on that. We have 3 full-time JVO mediators. They go into high schools. They are also doing a lot on Zoom as well, but they work with pretty much anyone who asks, anybody who's got a problem with a juvenile. So it's a diversionary program to to end the school to prison pipeline. We are not doing things like felonies with that group, but we're getting involved with bullying. We're getting involved with fights between students, some teachers and students. Sometimes parents are involved in those mediations. We work with juvenile court. They will refer to us juveniles who've been in trouble, maybe for vandalism or for truancy or for something that's not a felony. And it's a diversion program to kind of keep their slate clean and keep them out of the system. Robin, what would you add to that? Anything that I missed?
We do some police and citizen.
True.
That's one I've not been involved in very much, but that is one that we've had some good successes with, where it's kind of a low key way for citizens to meet with the police that they've had interactions with. I think you talked about housing already, right? And we do some landlord tenant even, not in neighbors and all of that.
We have been, one of the blessings of the pandemic has been our ability to expand our reach. We actually have somebody in your neck of the woods, Andy. Karen Phillips is a mediator with us, and she focuses on the Memphis area. And so she is doing, she's working, doing family mediations. She has relationships developing with schools in the Memphis area. She's technically in our JVO mediation, juvenile victim offender mediation program, but she's expanding our presence. And we have been able to do that because of this technology. And it's been a real blessing, because there are a lot of counties in the state that have absolutely no access to mediation. And it is it's just a better way, we all believe, and I'm sure you do too, to resolve issues than having to go in front of a judge. And the courts, when they closed down during the pandemic, the backlog was tremendous. And so we were able to work, we reached out to, I think, literally every judge in, beyond Middle Tennessee and kind of the central part of Tennessee, the central 2/3 of Tennessee, and said, hey, if we can help you, let us know. And some of them were interested and some of them didn't call us back, but we are happy to work, happy to expand our reach. We used to focus solely on Davidson County, but we have really reached out in the past. And we now welcome volunteers from anywhere as well. If you are a Tennessee Rule 31 listed mediator with some experience and comfortable on the Zoom, I would love to talk with you. I'm going to put my email in here. And I encourage you to visit our website and to learn more about our education programs. But I can't say that we are using volunteers to the level that we used to, but we do have roles for volunteers with some experience. And again, the Zoom is the key. We are, for the short term, maybe for the long term, this is going to be where we are.
We have
Anything else?
I'll say we have a lot of attorneys and mediators on here who take pro bono cases through our office or reduced fee cases. If they have one that is needing a mediation, how do they go about contacting you all to see about getting a mediation scheduled if they're, have a low income client that might not be able to afford it?
Absolutely. They could reach out to me and I can direct them to the right place. Our office manager, Wanda, our email form is the same, first name @nashvilleconflict.org. Wanda Green schedules mediations. And if somebody from another county wants to do a family plan mediation, contact Wanda and she can get it scheduled. We're scheduling a couple months out, but we try to be mindful of the court dates that are coming up, and we're usually able to get people in pretty quickly compared to a lot of places. But we're happy to help outside of our county, so don't hesitate. Our mediators are very skilled on Zoom. When we are in person, we tend to do same room mediations. A lot of attorneys don't like to do that, but that's how we like to start. We do serve low income clients primarily. So if somebody out there, obviously pro bono would be, right in the alley. We aren't going to be doing mediations for clients with wealth. So I think we are taking care of the same people, Andy.
Perfect. Yeah, absolutely. Is anybody else, we've got some time left, have any questions for Pam or Robin or anything about what all they do or about the topic in general?
I'd be curious to know if anybody has taken any IATs out there.
I have one pulled up on my computer right now to take when this is over.
Oh, you want to take it in front of us?
I will say, go ahead.
I got to the point where you had to do things really fast and I couldn't do both at the same time. So that's where I stopped.
It is hard. Yeah, you definitely want to be in a room by yourself with no distractions and just really focus on it. And then it's humbling. It is definitely humbling, but I think it's really useful and it's a starting point. I think that's what we need to realize, is that it is a starting point for some introspection.
Yeah. And I was going to say, it's always interesting to me. I try to take a different one at least once a year. and to see how things even shift the way, when I've been doing them at any rate. So the first one I did, I had worked with people with disabilities for a long time. And apparently I had a bias, just as you did for your friends group. I thought, oh, people with disabilities were, quote unquote, good. And as somebody reminded me, they can be not so nice sometimes. So it's an interesting thing to do. And the Harvard Institute, the Kirwan Institute, all of them are good. I think they're all very good and interesting to look at. Any questions from anybody?
You'll have the
Is it-
unfortunate situation of going after lunch. So
Oh, yeah.
Well, maybe you
Everybody
can
has to
queue up
wake
your
back
next speaker a few minutes early and get him out of here early, Andy.
See, I actually do think she is already on. Actually had another quick question. I think you said, Robin, you work in a VOCA grant. So we have several of those that come through our office as well, covering a wide variety of things. So if you could explain kind of some of the issues of when it comes to bias of dealing with people who have been victims of crimes, people who you might know might be abusers or something like that, and trying to keep that fair, because I feel like that's one of the hardest things, especially if you know that there's been victims and abusers and everything all in the and you said you try to keep sometimes in the same room. How do you handle that?
Well, one, I think training is critical on that one. I will say that the VOCA grant we work off does some with the parenting and some with the juvenile. I cannot do if there's what they call intimate partner, I can't do that particular one, but I have had the domestic violence training. And I think part of that is making sure that the room, when we are doing the same room mediations, and this can be same room on Zoom, or it can be same room actually in this, physical presence, but it's just trying to make sure that everybody in the room is feeling comfortable, and it's really being attuned to, if as quickly as you can, what are some things that may be going on, and it's checking in privately with each person and making sure that if you're checking in with the alleged victim for 10 minutes, you give that same amount of time to the alleged perpetrator. And I'm going to say, I know that that's something I always have to, I have to really prepare myself when I'm going into each mediation where there is domestic violence, whether it's between a parent and child, or whether it's between, intimate partners, or whatever type of mediation it is, that you have that balance and you try to maintain that balance. And really listening, if somebody says, hey, you're spending a lot more time with that person, checking in and really saying, okay, you know what, I need to make sure, I need to set my timer. That's one of the tricks that I have is as I tell somebody I'm going to be, if I do split for a few minutes just to check in privately, move them into breakout rooms, separate breakout rooms on Zoom. And I go in and out of each of those breakout rooms, set my timer. So I'm going to be 10 minutes with this person, and then I'll come to you and I'll spend 10 minutes with you. And then we can come back together, or, whatever we need to do at that point. But I think it's just being aware. I learned the trick because time when you're in a breakout room with somebody, it can slip if you don't have a timer actually going on. And so that's one of the things, I guess that's one of my tricks for that. And just trying to, knowing when you're going in, taking a moment before you go in and saying, okay, keep your bias in check. And if you feel that way, maybe take a break and pull back a little bit too. I don't know if that's helpful.
No, it was definitely very helpful. And we actually just had another question come in from Jonathan Steen. Recognizing one's own implicit bias is important for the mediator. How do you address your recognition of implicit bias in participants in a mediation?
I would say the first step for me is if I don't think I can be unbiased, I won't do the case. And that's the beauty of having a healthy sized staff and volunteers. And there are definitely, we all have our own traumas and our own biases, and there are very valid reasons. And you just have to recognize that you can't, sometimes you just can't, and you shouldn't. It's not fair. So that's the first step. And then I guess maybe you didn't realize until you are starting to talk that the bias exists. To Robin's point, it is training. And if that's maybe when a co-mediator can help you maybe take over a little bit more if there's something you're not comfortable with. If at some point you realize you cannot do this fairly, you need to call the mediation, and we should be ready to do that.
Yeah.
I fortunately have not had to do that, but I can see where that could happen. I think particularly in situations where there has been violence or abuse, it would be, we've had some mediators who have refused to do certain types of cases because of child abuse or whatever. So I think you have to be willing to recognize that if you can't get through it, then you shouldn't, and you should end it and reschedule with somebody else.
We had another question come in. Many of our friends, are doing a great job, but recently I've had a couple of particularly painful experiences with prosecutors. Have you done any bias training with prosecutors?
We have not. NCRC does do a fair amount of this kind of training, and we do it with our partners, our referral partners. We do it with private businesses, different topics like adverse childhood experiences and trauma, bias, several different topics. We would be happy to if somebody ever reached out to us. And I like to think that our referral partners know that we are available for this, but we have worked with the Metro Police Department on bias training. And we are active in that space in Nashville. But I haven't seen anything from prosecutors.
All right, we'll wait a few minutes, see if we get any last minute questions in. But if not, thank you both for taking your time and doing this. It was very informative, and you gave us a lot of resources, a lot of people we can reach out to. If anybody else on this call, especially if you've taken a case from our office and pro bono and might need a mediator, reach out to us, reach out to me if you need to. I can connect you with Pam and Robin and everybody at the Conflict Resolution Center, because we do serve a lot of similar areas and a lot of the similar clientele. So if there's not any more questions, we'll go ahead and break early. We have to do a 15-minute break. So originally the schedule said that we would start back at 2:30, but we can move that up to a little after 2:15. And we'll start back with Melinda Seeley after this. But Pam, Robin, thank you all so much for this presentation.
Thank you so much. And y'all are welcome for the 15-minute shave at the end there. Take care and have a great weekend.
Thank you.
Thank
Bye-bye.
you.
All right, everybody, it's about time to go ahead and get started. We will start with our last session of the day. Linda Seeley will be speaking about technology outside of Zoom that can be used for mediations. And oh, Michael Hill just asked if there'll be a form to complete. Yes, at the end of the seminar, I'll send an email out to everyone with a link to a form to complete to get your credits. And Linda, do you want me to run your PowerPoint? Okay,
Thanks.
perfect.
I would appreciate it, Andy. Thank you.
Absolutely. Let me get this. Oh, there we go. All right, you can go ahead.
Okay, thank you so much, Andy, and thank you everyone for your attention on a late Friday afternoon when I'm sure everybody's ready to start the weekend, because I know I am. I appreciate Andy inviting me to do this. I actually did this same seminar back in November of 2016. And what I talked about then is pretty similar to what I'm going to talk about now, which is online dispute resolution, or ODR. So you're going to hear me refer to ODR. That means online dispute resolution. And that's pretty much what we've been doing since the pandemic hit in March of 2020. In March of 2020, I was still working in Washington, D.C. for the American Bar Association as the Director of Dispute Resolution, which I had just started that position when I did this same seminar back in November of 2016. And at the time when I came back in 2016 to do this seminar, I wasn't nearly as familiar with ODR as I have come to be. But at the time I started in September 2016, I really had no idea how ubiquitous ODR was and the number of different platforms that were available to people to use, and how intimately involved not only I would become with ODR and the use of ODR and various tools, but also how it impacts our life and how we should start thinking about it at the Adrc Commission level, and how we should think about how we are going to use these tools and how we are going to be trained on these tools as well. So Andy, could you switch quickly to the next slide? Thank you so much. So ODR, as I alluded to, has been around for many years. This is not a new phenomenon by any stretch of the imagination. And in 1996, that was when the first articles about ODR and its potential for use in mediations and negotiations and arbitration appeared in a law review article. And when the National Center for Automated Information Research sponsored their first conference about ODR, the National Center for Technology and Dispute Resolution, or NCTDR, and I will refer to them fairly frequently, and if you are not a member, I do recommend that you check out their website, was founded in 1998. It was founded by a gentleman named Ethan Cash. Ethan is semi-retired now, but he is still a leading voice in the field of ODR as well as its application. Cyber Week is an annual conference that is put on by the National Center and their fellows. They have a group of mediators, arbitrators, and negotiators who are fellows of the NCTDR, and they are known as ICODER fellows. But that first Cyber Week, and it's always in November, we just came off of Cyber Week earlier this month, was held in 1998. There have been numerous books, both published by the ABA as well as published by other independent publishers in this field on the use of ODR in cyberspace. But one of the first ones was in 2001. Articles such as The Virtual Courtroom in ODR came out in 2003. Initially, there were not that many platforms that really promoted or digital tools that really promoted themselves as being unique for or user-friendly by mediators and arbitrators. But you started to really see the growth of that particular industry from about 1999 to 2002. A number of platforms were created, beginning to be marketed. And this is particularly true not in the United States, but in Europe, where you had a lot of cross-jurisdictional and cross-boundary disputes that had different countries with different laws and different systems. And the difficulty, in particular in the commercial field, that people had in trying to resolve their disputes because of competing court systems and jurisdictions. Additionally, you had the same kind of problem occurring in Asia. The use of online dispute resolution is very common in Asian countries as well as in Australia. Next slide. Thank you. So, as I mentioned, you had a lot of ODR startups that appeared and disappeared. There's a couple or a few that are still around, Smart Subtle being one. And I'll talk a little bit more about Smart Subtle in a later slide. Cyber Subtle and the Mediation Room, those are still around and they are still being used, although they're primarily used in Australia and in Europe. So when I started in 2016 at the ABA, I would find myself often being approached by new startups, lots of people trying to break into the field as it became more and more acceptable in the commercial realm, as well as in the European countries and the Asian countries, and increasingly in Canada. Canada's a large country with a lot of rural areas, very difficult for people to get to court systems. So ODR was pretty well established and very accepted. There's a really great program out of British Columbia that I highly recommend. It's connected to their court system, and they've done a really great job with their platform there. We worked closely with a gentleman named Colin Rule. Colin created the first platform for eBay to resolve disputes. And of course, eBay is a global phenomenon with a lot of people that use it and a lot of people who have disputes about it. So he created an online platform to try to resolve these disputes. He eventually created the Modria platform that was bought by Tyler Technologies. Tyler Technologies is actually a company that works primarily with court systems to build online platforms for them. Matterhorn is their biggest competitor. Matterhorn actually provides platforms for courts, but it also has been working with a number of different court systems, including the one in Hamilton County that's dealing with medical debt. And what they do is they provide mediation platforms that are directly connected to court systems. So those are the two big court platforms that are kind of battling it out here in the United States. So the race was on. People were competing, platforms were being developed, things were moving along. And in 2016, when I came down and spoke to y'all before, my prediction was that we would very shortly, maybe within the next 10 years, see a huge adoption of the use of ODR in the mediation and arbitration field. And then the pandemic came and everything exploded. But one thing I want to stress to you is this, that this is not new. It isn't even really news. I talked about this back in 2016. There are hundreds of different platforms, new ones coming on the scene all the time. There are lots of resources that I'm going to recommend to you. One of them is a bibliography that's put together of different ODR publications, articles, links to TED Talks and things like that. That was put together by a gentleman named Noam Ebner. Noam is an instructor on ODR and mediation. The link to the bibliography is right there on the slide. I highly recommend that you, as mediators and arbitrators and negotiators and attorneys, take a look at some of these publications, because I think that you will be surprised by what you learn and by the number of different options that exist out there today. Next slide. Fantastic. So what are some of the tools that are available and usable? Now, of course, everybody's familiar with Zoom. And back when the pandemic hit, one of the things that we at the section had to do was to quickly pivot. We had our annual spring conference set in April, and that's usually our biggest moneymaker. And the sections at the ABA have to make their own money in order to fund the different projects that they want to participate in. And we pivoted quickly. Now, we did pivot to Zoom, but Zoom was not is not the only option in terms of successfully putting together training programs. There are a number of different options that exist out there, many of which provide much better and different kinds of functionalities and options, but we're not here to talk about training platforms, although there's a lot of them out there that I would use in lieu of Zoom, but they're more expensive, and Zoom is what we all know. So what are some of the tools that are available, and what are some of their functionalities, and what can they be used for? So one of the first ones I'm going to talk about is called ADR Notable. You'll see the website right there. This was started by a gentleman named Gary Dorenhofer. Gary is a friend of mine. He is formerly an executive with a big airlines company. He's got a background in engineering, in addition to being a fairly successful coder. But basically what ADR Notable was specifically built for by Gary and his team was to provide a platform for mediators to manage administrative tasks. Think of it as kind of a case management database specifically built and designed for mediators. So one of the things that it can do is it can help you with scheduling, provide sample forms. It has a note-taking function that you can use while you are doing your dispute resolution process online. It provides document storage, checklists, timekeeping, and their newest feature is billing and invoicing. So just like if you're a pretty smart lawyer, you're going to have a case management database for your legal cases, you might want to consider have something that was built specifically for mediators and arbitrators that provides the tasks that I list there. I will also say this, Gary is very approachable. He is both the creator, inventor, builder, and marketer for this particular platform. And he loves to give people the opportunity to use it for free for a short period of time, to get their input, to get their feedback. One of the things that I definitely recommended to him after I tried this particular program first was I said, you really need a timekeeping, a billing, and invoicing function for this particular website, because it's really important for mediators and arbitrators to be able to keep track of the time that they're putting in, especially on the front end, because a lot of people don't bill for that, and they really should. and then be able to invoice and get payment all through a platform. Makes things much easier for you as well as for the attorneys who use your services and the clients. Next slide, please. Smart Settle, you heard me talk about this one earlier. Smart Settle has been around for a very long time. They have a number of different options for the users. There's Smart Settle 1, and it is the easiest to use. It is something that you and I might use if we had a dispute over a sale or something like that. It's a very easy blind bidding process where the users go in, and you don't need an attorney to do this, but the users go in. You might recommend this to some of your commercial clients for small end disputes. Give them something to do, to use. You don't have to charge them for it. They might thank you for it. But you go in and each party bids in the ranges where they're willing to settle. Smart Settle uses an AI process to see how close you guys are. It makes a recommendation. You accept it or you don't accept it. Then you go back in if you haven't, the two parties have not reached a common goal. So you just keep bidding until the AI process gets you to a settlement. You see it while you're on there. And one of the really fun things about Smart Settle is that you can go in and play against the computer. And it's free. You can go in, set it up, and you can just kind of like you would play any video game, go in and play against the computer and kind of see how it works. It also, as part of the AI function, will offer a reward early effort settlement. So if you're in there and you're quick and you're not like just stuck on one particular number, it will give you a bonus in the bidding process. They also have, as you go through the website of Smart Settle, they've got a lot of different other options. So that's kind of the early iteration of Smart Settle, that AI functionality with blind bidding and the rewarding early effort piece to it. But you can go in, you can buy a more sophisticated access to Smart Settle. You can use a mediator, but it's not required. If you don't use the mediator, then you're definitely using the AI functionality. It is primarily text-based negotiations. So if you're really keen on using video or telephone, this might not be the best option for you, but it is a fascinating program. It's a great platform to go in and to play with. They have 5 different options, so you can choose whichever one that works best for you, for your client, and for the attorneys. Next slide, Andy. Thank you. Troct. I really like Troct, and the reason I really like Troct is because I really like their creator. It's been around about 5 years. It was developed by a gentleman named Chris Draper as a text-based asynchronous, which means you don't have to do it all together at the same time, although you can do it, tool to manage the negotiation of agreements. Chris is a technologist primarily. He is one of the smartest people I've ever met. He too is an engineer. Engineers seem to really be drawn to this. But he's also a mediator. He primarily mediates in the field of special education disputes. He has 5 children who one is a special needs child. And so he, as a parent, became very familiar with what happens with special needs children in the educational process. He got his mediation certificate to help work with his child. What he found was that this was a field he was really interested in. He created Troct. Again, it is a text-based platform. So you're typing in, that's how you're doing the negotiation. You can do it asynchronously or at the same time, whatever your preference is. One of the really great things about Troct is that it not only records the agreements, but they're also time and date stamped. You can either go through the web or you can download an app, whatever your preference. It's very adaptable to any structure, including mediation, multi-party negotiations, arbitrations, whatever it is. And what you get from that is you get a structure for a final document. Okay, so if it's really important, like a contract negotiation, Troct is a great platform to use to try to do that. But one of the other things about Chris and Troct is that he is incredibly security conscious. He's written a number of articles for the ABA section of dispute resolution about some of his concerns around privacy and confidentiality. He served on the ABA section of dispute resolutions task force for creating guidelines and guidance for ADR platform providers as well as ADR professionals. He's very knowledgeable about how to protect confidentiality and protection of documents. You can upload documents through Troct, which you can't always do on other platforms like Zoom. You can't upload and save documents. You can share a screen, but you cannot upload documents to Zoom. So they have a special application that Chris is particularly proud of called the thumb printer application. And you know how a lot of times when you've got metadata issues or surrounding your documents, one of the things that the thumb printer does, it ensures that whatever the end document is the end document. There's a timestamp ability, and that basically ensures and guarantees that the document at the end of your agreement is it. That's it. And nobody can amend it. You can't change it or anything like that. So he's real keen on issues of privacy as well as confidentiality and data security. He too is one of the most approachable people you could ever come into, and he's always looking for feedback on his platform. Andy, next slide, please. Mediation Suites is a really cool platform. It was created by a Tennessee mediator, a gentleman named Clay Phillips. It is the platform that is most similar to Zoom, but it too has many more options and functionalities and features than Zoom provides. It is 100% web-based. You don't have to download an app. It doesn't have updates. You know how like when you're working in Windows and suddenly everything comes to a screeching halt while they do your updates. It doesn't happen here. It does have end-to-end encryption, something Zoom has, so you know that you're safe doing your communications in that particular platform. It does have real-time video conferencing, so you can get on there, you can see each other. It's got chat options, text-based options, breakout rooms, document sharing, just like you've got on Zoom. But what it has that Zoom does not have is that it has file storage capabilities. So, you know, when you're using Zoom, you have to have another software program open so that you can access all of the documents that you want to have come up on screen, or you might have to save it to your desktop so that you can access them. But you do have to be able to access the other software program in order to share your screen or share your documents. You don't have to do that with Mediation Suites. And on Mediation Suites, you can also amend documents, add information to documents and things like that. So they have a document storage functionality. What it doesn't do, and I think it also has a scheduling functionality as well. What it does not do, it does not do invoicing and billing like ADR Notable has. So it may be something that you could reach out to Clay to and talk to him about possibly adding something to his platform that would be of help. But Clay too, he is a Tennessee mediator, although he does increasingly more and more work down in Florida. And he's a mediation trainer. He puts on online trainings, and I'll talk about those in just a few minutes. And it's a great little program. I've looked at it a number of times. You can always get a demo if you'd like that. He'll do that for you for free, walk you through it. It is subscription based, which means that you pay a monthly fee to use it, but I think it's got almost unlimited user time. But you know, something to really look into, because as I said, while Zoom is great, it's great for a bit as a video platform. When we did the big pivot back in March of 2020, Zoom was not built as a platform for training or for doing dispute resolution processes. Zoom was built as a communication tool. That's what it's meant for. That's what it does best, is it helps us communicate via video chat. You know, sometimes I think a lot about the one of my favorite cartoons when I was a young person, the Jetsons, and how far we've come towards reaching that goal of being able to just push a button and have that little TV come down and you can talk to George and Jane. Next slide, please. So, you know, what else is available? What else out there? Who are all these providers and what in the heck are they doing? Well, we don't have time to really talk a lot about all of these platforms, but I will say this, and I've mentioned the National Center for Technology and Dispute Resolution, and that they have a group of fellows, that's the iCoder people, and the iCoder fellows have come up with a set of rules and guidelines for providers and what those minimum requirements are that providers should offer to people who use their platforms. And they offer the opportunity to providers to certify that they are in compliance with the recommended guidelines as created by the iCoder Fellows and adopted by the National Center for Technology and Dispute Resolution. So there are 2 self-certified ODR providers that you can see on the National Center's website. That is odr.com and Troct, and I mentioned Troct before. Chris is active with the National Center. As I mentioned, Ethan Catch was the founder of the National Center. But and he's semi-retired, but the other director at the National Center is a woman named Leah Wing. Leah is a lovely person, another person who's very easy to talk to. She teaches at the University of Massachusetts. Next slide. So here is the start of a list of providers who have indicated that they are in compliance with the iCoder ODR standards that have been adopted by the National Center. Here is the first part of that list, and you see about 12 people, or 12 platforms rather, on this particular list. Next slide. Here you see some additional people, and if you'll note, these are all in alphabetical order, so we're at the C's. We've now got about 25 platform providers that we've seen on screen so far, including the China International Economic and Trade Arbitration Commission. I mentioned in Asia as well as in Australia and Europe. ODR is very popular. China in particular uses a lot of ODR. You may be familiar with the Chinese Belt and Road Initiative. They've been building infrastructure all across Asia and into Europe for the past 5 years. And the only way that you can resolve a dispute and as a contractor and or a subcontractor in the Belt and Road Initiative is by ODR. Next screen, please. Look, there's more, and we're only through the C's. Now, I will point out that some of these platforms are also app-based applications that have very limited functionality for what they do. You'll see Co-Parenter is on there. Co-Parenter is actually an app-based program that works with parents to help them in their visitation issues. They do mapping. If you're texting back and forth with your co-parent, they have co-parenter, they have an AI application that will help you modify ugly texts that go between parents so that you're not causing additional problems. Next screen. CREC is one of the newer ones. This one was started back in 2018. It's out of India, a great multi-functional platform that we did not see on the screen today, but here we are. We're probably up to about 35 providers and we're just at the ease, but I think you get the point here. There are a lot of platforms out there that are available for you as a dispute resolution professional. The full list is there. The place where you can find them is at odr.info. odr.org is actually the website for the National Center for Dispute Resolution and Technology. So I think one of the things I am fairly confident in predicting is not only what I said in 2016 is true, which is that ODR is actually slowly but surely becoming the preferred way for mediators and arbitrators and negotiators to meet with clients and resolve disputes. But I actually think that what will happen, and particularly in the commercial field, that people and commercial entities are going to start having favorite platforms, and there's going to be an expectation of you as a dispute resolution professional to be aware of, familiar with, and understand what it is that a platform has to do as well as provide before it would be appropriate for you to use it. Next slide, Andy. So how do you know which or what to use? There is actually a listing of providers and the different features that they have that was first created in the summer of 2019. At the time, the ABA section of dispute resolution was working with the Pew Foundation to put together a group of people, both from our section, but also from the Center for Technology and Dispute Resolution, from ICODER, from the International Mediation Incorporated, from various groups of people to come together and to talk about what is it that a platform really has to have in order for it to be appropriate to use by a dispute resolution professional. So you see that there's a link to the paper that was written by Amy Schmitz. Amy is a professor. She was at the University of Missouri. She is until, I guess, through the end of this semester, when she will move to the Ohio State University Moritz School of Law. And Janet Martinez. Janet actually is an author who co-wrote a book called Dispute System Design, where she talks about how do you appropriately design a system in order to be effective as a dispute resolution? What kind of things do you need to think about? Fairly expensive book. It is a scholarly book. It's primarily used at the law school and university level. But I do recommend it, although it's rather expensive. So you can take a look at this paper, and this paper has a listing of a number of different ODR providers, and it gives you a comparison of the different functionalities that each one of these providers has. And some of the providers I've talked about today, you will see on that comparative chart. Next slide. Well, what else should you know? You can kind of take a look at that comparative chart, but you know, maybe there's a little bit more to it. And I'm telling you, there's a little bit more to it. So one of the things that I recently participated in is via mediate.com. Now, you heard me talk about Colin Rule earlier. Colin is a dispute resolution system designer. He designed the program for eBay. He created Modria, which I talked about, and Modria was subsequently purchased and incorporated into the Tyler Technologies suite of options. Again, Tyler Technologies is primarily a technology system that sells to courts to help them automate their processes, and they also have this mediation platform built into another option for a court system to buy. So Colin is now the CEO at mediate.com. Some of you may have heard of it. You may be members of it. You may have seen their website and some of the articles that they post. But mediate.com, along with a number of other people, including Woody Mostyn, who has done a number of trainings for me in Memphis on collaborative law and other issues involving dispute resolution, put together a task force, and they issued a report that came out in September. It's called The Path Forward for Online Mediation, and the report of from the Online Mediation Training Task Force. Now, why is that important? Well, as a mediator, one of the things that you have is you have an obligation to be competent. And part of that competency requirement means that if you're going to be a competent mediator, you need to A, know what's out there. B, you need to know what these platforms need to have in order for them to be secure, safe, and appropriate for your client to use. And you also need to know what are some of the things that each one of these platforms should have, and what should you know about them, and how should you appropriately prepare as a mediator in order to be competent. So the task force was put together with the idea that we had learned some lessons from the pandemic. And I'll talk just briefly about what some of those lessons are. One of those is that mediators are going to be using ODR more than ever before, certainly than they did before the pandemic. Next slide, Andy. So the path forward, this is a quote from Woody. It's welcome to the online mediation resolution. And online mediation and online mediation training are here to stay. Now, I'm just going to digress for a second. You had heard me talk a little bit about working with the Pew Foundation, and that the section of dispute resolution had put together this kind of task force to look at producing some guardrails and some recommendations, both for mediators who wanted to use ODR. What did they need to know, and how did they need to, what did they need to know about ODR? Number two, what did ODR platforms need to have? And that's that comparative chart that I talked about earlier. It offers you different comparisons between different platforms and the different functionalities that they have. And then what is it that we needed the court systems to know? So the Pew Foundation comparative chart, the first one, not the updated one that's the link is in the slides too. That came out in the summer of 2019. So we put together the task force. It really got started in November of 2019. We thought we had 5 years. We had 5 days, because when the pandemic hit, we knew we had to act fast. A lot of us consulted with Zoom about what Zoom needed to add in terms of functionality so that it would be usable by mediators as well as by court systems. A lot of court systems adopted it. Some federal agencies as well as state agencies won't let you use Zoom. Some private companies won't let you use Zoom because there's still some concerns about its safety and confidentiality, although Zoom has made a number of upgrades. Next slide, please. So this is just a quote from Woody that I really liked. We know that the technical and legal context of our work is continuing to evolve. The task force strongly recommends that the mediation field fully embrace the opportunities that ODR provides and consider adopting some training options that I will talk about right in the next couple of slides. There's really no reason to delay. I frequently talk to Woody. In fact, I talked to him yesterday. The recommendations will continue to evolve and to grow. I served on the training committee of this particular task force. And I will say this, that was one of the most contentious of the discussions. We had a number of different committees, talked about a lot of different things, and there was 8 primary recommendations that I'll talk about in a few minutes. But the whole piece about training, we really had some very in-depth discussions about that, and I will talk about what the recommendations for what training for mediators needs to be as we move forward. Next slide. I will kind of digress real quickly about the use of ODR by mediators. There was a survey that was done. You can actually get a link to the survey on mediate.com. There was about 500 responses. Most of the respondents were mediators and arbitrators from the different Americas. 83% of mediators described their experiences online as positive or highly positive. A significant number of mediators who described their experience as highly positive reported that they had never used online mediation before the pandemic. Now, I will say that I did. I used Skype. It was less than optimal, but it got a gentleman who was in the military service and could not be face-to-face with his wife into the mediation room and able to actively participate. It did not have the same kind of functionality, of course, that Zoom has right now, but it worked in a settlement. But most people did not use ODR and were not familiar with it, particularly in the United States. Next slide. 67% of mediators say that they will use online mediation more often than they did before the pandemic. 18% have said that they will use it as a default. In other words, that's going to be their primary means of doing mediations. One of the things that the survey found was that mediators felt that it was much more accessible to participants. It increased time efficiency as well as cost efficiency. And a significant number also said that the flexibility of online mediation would make it a default for them in the future as well. Next slide. The bottom line here, I think, is that we need to be intentional about our ODR use and think about how can we make it better. So the Online Mediation Task Force offers 8 primary recommendations. I've talked a little bit about who it is. There were a number of ABA members who were on this task force along with others from across the nation as well as across the world. There's the link to the not just the recommendations, but also the recommendations of the training task force. Next slide. Here's a list of the members. You may recognize some of them. These are the leading lights in ODR as well as in the mediation field. Michael Lang is a well-known author. Susan Guthrie, a fantastic trainer on ODR who works directly with Woody. Claire Fowler is a co-founder of Mediate.com. There's a number of, you see Colin Rule, there's a number of academics as well on this list. Next slide. I was a member of one of the advisory boards. There's the list of people, and you see my name right there, tiny little Linda, just so I get a little added credibility here. Next slide. So what are the recommendations of the task force? And number one, and these are not in order of importance. They're just in an order. Develop online mediation, advocacy, and resources. So I mentioned the bibliography that gives you a lot of different resources that you can look at, that you can peruse, that you can read. They're accessible. Most of them are linked to different academic articles, books, a couple of TED Talks. But basically, the idea is to promote the use of online mediation globally, and it's expanding access to online training of conflict resolution skills for everybody. Next slide. Expand access to online mediation services and training. The access to this is a real key for a lot of the people on the task force. You can actually access most of these, not just the trainings, but most of the platforms using your cell phone. Normally, when I'm doing this, I'm actually using my laptop today because I'm old and I have a hard time seeing on my cell phone. Not always, but if you're just doing a video and not using a PowerPoint or a text or something like that, actually a lot of people use their telephone. I frequently use my telephone when I'm Zooming. It's just easier. The accessibility of the cell phone really makes the use of ODR as well as ODR platforms much easier for many more people in the United States as well as across the world. It's also easy for people with different physical abilities because most of them have built-in devices that make assistive technology available via their laptop. So that increases accessibility not only to people who are in rural areas, but also to people with physical disabilities. Next slide. This is a big one. Update mediation practice ethical standards to embrace the current and evolving issues raised. This was one of the things that we worked really hard on. The Center for Dispute Resolution and Technology has a listing of the different standards and technology recommendations for providers, what their minimal standards should be, what minimal functionality they should have. And I talked about this earlier. And that listing of ODR providers, the one that's really long, all of those people have met those minimum standards via the National Center for Technology and Dispute Resolution. There needs to be ongoing privacy and security issues constantly raised for you. You should always be aware of that. And then issues involving platform equity and accessibility should always be addressed on the platform. Next slide. So I'm going to tell you, just run real quickly through the standards for ODR, the ones that I've been talking about for the practice standards and for ODR providers. It should be accessible. It should be easy for people to find and participate in. It should be available both through mobile apps as well as desktop channels. Minimize cost to participants, be easily accessible by people with different physical abilities. You've got ADA considerations that you have to take into account. So do the providers, and they should be constantly updating and upgrading their platforms to enhance functionalities, but also to make them more accessible. The providers should be accountable to participants and the legal institutions and communities that they serve. One of the things I've talked about repeatedly today is how easy it is to reach out to the creators to make recommendations, upgrades, and updates to their platforms. It really needs to be a community of mediators, arbitrators, dispute resolution professionals, attorneys, end users, and the creators as you work to make the platforms better. Next slide. Competent. It is recommended by the center that the provider have some relevant expertise both in dispute resolution, in the law, technical execution, language, and culture, so that they can provide competent, effective services. When I've talked about the people who have created some of the platforms that I highlighted today, one of the things I've talked about is not just are they mediators, but they are engineers, they are technologists, they are competent in many different areas. And so when they create these platforms, they know what they're doing. Confidential, and this is the one I've talked most about. You better make sure that these platforms are safe. Zoom was not safe when you first started using it, hence the Zoom bombing. And that's why when they started to upgrade and change how to use Zoom, you see a lot more options for your settings. Make sure you know how to go in, change the settings, fix it. Don't share the link to the Zoom with just everybody. People were doing that and consequently they were getting Zoom bombed. The policies of the platform should be consistent with the guidelines and guardrails. Impartiality, all participants should just be treated with dignity and respect. They need to be conscious of the biases that might be built into the platform. You heard a lot of talk about that by the previous speakers, but please keep in mind that most of the people who create these are white guys. And so they have to be aware that there may be some gender or racial bias or disability bias built into that. And so one of the things that we do require, or that the center requires, is that they are aware of biases and are conscious to correct them if and when they are pointed out to them. Next slide. Fairness and impartiality, another key ingredient. They must be aware of and adapt to the laws in all of the relevant jurisdictions in which they practice. Yes, indeed, that's a tough one. Secure, make sure that the data that's collected, the communications between the parties that use these online platforms are safe and protected, that users are immediately notified should there be any breaches, and that notification should be in a timely fashion. Next slide. And transparent. There should be clear guidelines, guide frames, and other information provided to the user so that they are aware not only of how you can use the platform, but the risks and benefits of using them and what they do with the data. Because one of the things, if you've ever looked at that Facebook agreement, because they use your data to make money. That's how they make money. And you want to make sure that your provider is not taking and using your data to make money. Too easy to do. Read the confidentiality agreements. Next slide. Okay, so those were the guidances that were created by the National Center for Technology and Dispute Resolution. They apply primarily to providers. The recommendations from the online task force, I'll finish running through them and then open it up for questions. One of the recommendations is that mediators should have a standard universal code of disclosure. And basically what they're saying is that all mediators should comply with certain requirements in terms of what they disclose to the attorneys and end users who use their services. And there's a whole list of things. You can see them on mediate.com. line, but basically it's, being transparent about what your process is going to be, what you're going to use, how you do it, that kind of thing. Next slide. That we should assist existing mediation programs to renovate the basic mediation trainings and expand to include online mediation training. And this is something that dispute resolution commissions across the country are going to be asked to deal with. That the basic mediator training curricula should be expanded and enhanced to include certain standards and guidelines for mediators to be competent in the use of ODR and what those online mediation trainings should consist of. Remember, I talked about this being the most contentious thing that we talked about in the task force. There were a lot of mediators who prefer face-to-face that basically really put up a struggle to not increase the number of hours in the basic mediation training. But I'll tell you this, the task force recommendation include an additional 40 hours of training. I don't know that that's what will be adopted, but that is the recommendation. Next screen. Recommendation 6, established mediators should get the right kind of training to be the most competent mediators they can if they are going to offer online mediation services. We want to expand and renew your mediation training, include online mediation best practices, that the basic online mediation training should be renovated, and at least, and that the basic mediation trainings and at least one which has been thoroughly renovated to comprehensively address online mediation issues, concepts, and skills. Next slide. Expand mediation mentorship, clinical and apprentice opportunities. You heard a little bit about the different mediation centers, or at least the one in Nashville. There's one in Memphis. I think there's one in Knoxville, and there's at least one more. But a lot of times these community mediation centers provide opportunities for mediators to be mentored or apprenticed through their programs. There's a mediation clinical experiential clinic out of the University of Memphis, as well as out of the University of Tennessee. They'd like to see some expansion of both mentorship opportunities as well as clinical and experiential opportunities. Next slide. And then the final recommendation is one that kind of goes back to that survey, which is the recognition that online mediation is kind of the green way to do this. It's environmentally sound. You don't have your carbon footprint is not expanded. It's accessible, it's cost effective, and it's safe. It is particularly safe in the arena of domestic violence mediations. Final slide, or is that the last one? That's it, boys and girls. And we finished with 2 minutes for questions. Any questions, comments, or concerns?
There's
All right.
currently not anything in there. We'll give people a couple minutes, see if they've got any questions to add before we wrap
Do
up.
you have any questions, Andy?
I do not. You covered what all I wanted you to, so it's great.
Oh, good. Okay, seeing no questions. Andy, thank you for
All
the
right.
opportunity to speak. Everyone, I am also very accessible. You are welcome to call me at any time. Yes, Roy, what's your comment? No comment. Ah. You're right, Roy. How did you know that? No, just kidding. Thank you. I appreciate that. Thank you, Jonathan.
All
All right,
thank you
everybody.
so
Have
much,
a
Linda.
great weekend. Happy Thanksgiving.
All right, everybody, thank you all for attending this year's mediation seminar. You'll be getting an email here in a couple of minutes with the form to complete for your credits. If anybody has any questions or any problems, definitely reach out to me. If not, thank you all for attending, and I hope to be able to meet all of y'all in person that I haven't been able to yet. Y'all have a great rest of your day and a great weekend. Thanks.